All right. Welcome back. Welcome back. I'm actually on time today, unless you want to say I'm a day late, but there is that because, you know, Tuesday is the new Monday. So, sorry about the late notice yesterday. I was going to just go for it. Basically, had an upset stomach. I I have a feeling it's something I ate. I don't know. If if there were court today, I realize there was court today, but I wasn't going to stream the voir dire. So for my purposes, there was no court today. And yeah. So basically, if I hadn't known that today was free anyway, I would have just powered through yesterday. It wasn't that bad. But at the same time, I figured, you guys deserve better. I deserve better. We all deserve better. You know, it I realize there are a lot of options to watch, so why give you less than the best I can give you? So I realized the short notice wasn't the best I could give you, but just the same. So thanks for understanding. Thanks for all the well wishes. I am feeling better today. It's so yeah. And thanks for all of you that joined me on Saturday for the Team Skeptic lawsuit. That was wild. It was a lot of fun. A lot of fun. It broke me. Well, the Team Skeptic lawsuit didn't break me. The plaintiff's lawsuit against Shitter is what broke me. Yeah, I mean, imagine the audacity of expecting Shitter and Facebook to pay you your living expenses so that you can afford to sue them. In what world does that make sense? Like, and just for the judge to give an order like, yes, you've suffered damages even before the trial has even started, before we've done anything. Yes, they need to pay you. And so, fraudbusters, good to see you. Vince, I hope you behaved well on my day off, 2 days off. um so, and Uma, good to see you as well. So the as much fun as I had on the Team Skeptic stuff, I'm commenters still never cease to amaze me. And there were only a couple of them, but you know, it always amazes me that someone after the fact, so they already knew it was a 3.5 hour live stream, and they click on it and get upset that I go on a 2-minute tangent, that I'm not on task every minute. Just it's like, do you not get the point of live streams, that interacting with the chat is like the purpose of a live stream? And or I love Team Skeptic, but you talk too much. And it's like, have you watched a Team Skeptic live stream? And it just, I don't get it. I don't get it, but it amuses me at the same time. So I'm going to go on the tangent and share my amusement with the rest of you. And yeah, so as you know, I haven't watched yesterday. I saw a lot of destroyed thumbnails, and I don't know. But then I don't know that that there are people saying the Celebrite expert was destroyed, and I've seen others. He just put the nail in Karen's coffin. So yeah, and Kfar, good to see you. Did you get my email, Kfar? Because that also amused me. Um, but clearly, I got Kevin Campbell's um, email because he sent me this short clip of an interview with Karen Reed outside the courthouse that, as good jurors, we should not watch. But we're kind of terrible jurors. So, yeah. Um, I haven't watched it. The title, Karen Reed tells reporters she's willing to testify. Please, Karen, for the love of all that's holy, please testify. I'm begging you. It's, one of my favorite 90s bands is 311. Saw them in concert a couple times. Frankly, it was my first proper concert. Last day of school, sophomore year of high school, Incubus opening for 311 at Saltaire, and it was glorious. And one of the songs that 311 is known for in the 90s, and of course, the 90s is the best period for 311, is Beautiful Disaster. And I think Karen Reed testifying would be a beautiful disaster. So please, 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 please testify. It would be hilarious. And Dante, good to see you. And Frank Perry, good to see you as well. I think this is the first time I've seen you in my chat, but I've seen you in lots of other people's chats. So if it is your first time in here, welcome. Thanks for stopping by. So one of the big things I have been thinking about over the weekend is Trooper Proctor. And basically, as I've said, to me, Trooper Proctor's text messages, frankly, as I've already said, I really didn't see any real evidentiary value in him. It just shows he's a dickhead, but you kind of expect that from a state trooper, some level of naughty language. It's not a problem. And Casey, good to see you, and Painted Bronco. So, with the general rule is evidence has to be more probative than prejudicial, and it's a balancing act, and some bits and happy burritos to you too, William Graber. I think that's the appropriate Spanish response, but I don't speak any Spanish, so but with the probative versus prejudicial, it is a balancing act. And with some rules, it's really so long as, it's kind of the same scale as um it's the 50-50, 51-49, the preponderance standard, whereas other evidence rules have fun in the background corrections. So others, it has to be like 90% probative, 10% prejudicial, just depending on where you are. And so, Kevin, good to see you. I shouted you out right at the beginning because obviously I did get your email. And Sinclair Reed, good to see you. And so the reality is, I don't think Proctor's texts should have come in. Frankly, they were illegally obtained, I believe. They had no actual probative value, they were only prejudicial. And so, as a balancing act, I want to see Karen Reed's text messages. I want to see her texts with Turtle Boy. Problem, of course, is judges often that prejudicial versus probative, you know, scale is very much in favor of the defense, which frankly, it should work both ways. But, you know, if it's going to favor anyone, it should favor the defense. I say that in general, not in favor of Karen Reed, but it's, yeah. So, I was thinking over the weekend that, when the cell phone trooper, whoever went through her cell phone, when they testify, you know, if Trooper Proctor's private texts with his friends were relevant and the texts from his friends were relevant, why isn't Karen's with Turtle Boy relevant? So I want to see those. The problem is, once again, there's no way the judge is going to let those in through the trooper. But if Karen testifies, they're easily in. They're easily in and on cross examination, and it would be glorious. Absolutely glorious. And William, I won't say I'm jealous that it's hot where you are. Like, I complained last week that, our swamp cooler wasn't working properly and it was hot as hell. And so my brother over the weekend got up on the roof and fixed the swamp cooler. And so Mother Nature said, "Ha ha, joke's on you. I'm going to cut the temperature by 35 degrees for the next couple days." And so I'm back to wearing my fleece jacket, although I can't decide whether I need it or not right now because it's right on that border. So, yeah. And yeah, it really is gross. It's, I don't like it. And Dante, I'm not surprised. I think it got to 45-ish here. Obviously, your mountain valley is colder than my mountain valley, but yeah. Yeah, was that over the night overnight, Sinclair, or was that the high? Because I know Colorado and Wyoming got snow in the mountains. We might have in our mountains, I don't actually know, but it's what? What does my phone say? Says 54, but I don't believe. Well, it might be 59. So yeah, either way, it's a lot colder this week than it was last week, and yeah, it's sweltering east of the Rockies, and oh yeah, that's a good point, Frank. The courtroom, in order for the jury to hear, they have to turn off the air conditioner sometimes, and that could be a problem. Like maybe they should move into the proper courtroom, but yeah. So I think that's enough bluster. Let's listen to 46 seconds of Karen Reed. Ugh. And then we'll get to the trial.
Ask you just how you're feeling now that the prosecution's about to wrap up. I mean, they have like 1 day left. How do you feel about their case against you?
How do I feel about their case against me?
Okay, apparently it doesn't, like, the computer realizes that we're being naughty jurors, so it's buffering on us. But
yeah, there is no case against me.
After 8 weeks.
After 8 weeks, it's smoke and mirrors, and it's going through my private life and trying to contrive a motive that.
Going through your private life. Going through your private life. Oh, you poor thing. Maybe ask the Alberts about what it's like to have a mob going through your private life. Maybe ask the McCabe's. Jesus Christ, she's tone deaf.
Was never there.
Have you thought about what it would be like to be on the witness stand yourself?
Yeah, I have. I'd like to fill in some holes and correct some lies, but it's up to the attorneys, and they'll make the call probably at the 11th hour, and I'm there or not there.
You're lobbying though for your chance to testify?
I'm an outspoken person, and I've never not been able to speak up for myself and my defense, except when it matters the most. I've got to rely on them and their expertise, and I'll defer to the attorneys.
Oh, she's gross. That's just ew. Ew. I really dislike her. Pull up the tab I need. And that's it. You know, oh, they're going through my private life. Like Trooper Proctor's private text messages, like Brian Higgins' text messages, like just ew. And oh, it's all smoke and mirrors. They haven't proved anything. Oh, I mean, I think they've brought forward something for every single element. Like, if the prosecution has nothing, then the motion to dismiss on Thursday should be granted. Newsflash, it's not going to be granted because the prosecution has brought a case. And at the very least, although I don't know that they even charged her with bog standard DUI, and that's it. They've crossed every single boundary of human decency, but poor Karen's private life has been interfered with, and poor Karen, you know, what about poor Johnny, bitch? And it's good to see you, Anne, and 3 cents. But the prosecution, I don't think, has rested yet, but it's close. It's just after the prosecution rests, before the defense even puts on their case, the defense will move for dismissal for a directed verdict of not guilty and give all the reasons why they think the prosecution hasn't proved the case. The thing is, though, in deciding that, the judge doesn't weigh the evidence. It's just, has something been presented for each and every element of the crimes? And at this point, yes. And it's up to the jury to give that weight, to decide who's believable or not. And so anyone that's saying, oh, it's an absolute acquittal, or oh, it's an absolute guilty verdict, it's all just speculation. We don't know what the defense does. And and that's it, Frank. So I haven't actually seen the witness list because you haven't been here the whole trial. I am an attorney, but I come at this as if I'm a juror who happens to be an attorney. So I don't read the pretrial rulings. I don't read the motions. I don't read the evidence or the witness list. I basically I treat it as if I'm a juror and try to limit what I see to what the jury will see. And that's why I'm not streaming the voir dire of the defense witnesses that happened today, because the jury isn't there. So Neil, good to see you. I checked Team Skeptic's comment section. Thank you for following my instructions. One of the few that did. And so, yeah, basically, to me, the prosecution hasn't been exciting, but there's a lot of evidence against her. All this, there's so much reasonable doubt. From what I've seen, the things that there's doubt about aren't actually relevant. And it's only the evidence of the crime itself that is actually relevant. At least to me. I realize there's a lot of people that disagree with me. But there you go. So, but there absolutely is something rotten in the state of Denmark. I mean, I've been saying from the start, this has been a Shakespearean trial, comparing it to Hamlet, the play within a play, except came to realize it was actually the Chewbacca defense that the prosecution started with. The conspiracy doesn't make any sense. But there you go. So, yes, please, Karen, testify. She says it's up to the lawyers, but as the judge will point out when they ask, when the judge asks, it is Karen's decision. Now, she can take her attorney's advice, but it's her decision. 100% her decision. And Frank, that's it. Lolly has not been exciting. He hasn't seemed overly passionate, but he has been methodical. He has been very linear, and I appreciate him being linear because to me, that helps. He might not have started in the timeline where I would have preferred he started, but just the same, him being linear helps. Jackson bouncing back and forth through time, like, I get why he's doing that. He's trying to confuse the jury. But I don't think he's doing anyone favors with that. And there's a reason people are calling it's Yannetti spaghetti, because throw it up against the wall, see what sticks. And yeah, so the Euros, is that cricket or soccer or rugby? I'm assuming soccer. Football for you, of course. And that's something I've been curious about. I know other people have mentioned it too, that we've seen Lolly on direct, we've seen Jackson and Giannetti on cross, and the roles are going to reverse. And even a dispassionate prosecutor on cross-examination can get fiery. And yeah, so, and it's possible, but as I've said, I have a feeling part of the reason he's gone in the order he has is it's what was most efficient, what the evidence allowed, having a foundation for these last couple of days, so that with the real meaty witnesses, with heavy testimony, he wouldn't get the objection, assumes facts not in evidence, lacks a foundation. And going in the order he did, he avoided that. He avoided that. And it just it was smart, I think. And what do I think of the two expert crash reconstructionists? I don't know. I haven't, but versus Trooper Paul, I assume you mean the defenses, and I haven't watched them. I like I've said, I treat this as if I'm a juror, so I don't watch the voir dire. So I didn't watch today's hearing, so couldn't tell you. I will only build an opinion on them, assuming they succeeded in their voir dire and the defense is able to call them for their case in chief. So, and oh yeah, they did. And as I've said from the start, the big problem for the defense is they came out, guns blazing. First line of their opening statement was Karen Reed was framed. And as I've said from the start, that's true, but I haven't watched that yet, Anne. I That's today since I took yesterday off. But while the defense has no burden of proof, if you come out that strong with Karen Reed was framed and you don't show even a likelihood of her being framed, you've lost a lot of credibility with me, and that's been a big misfire for me. Would have been a lot smarter just Karen Reed is innocent. The prosecution will not prove the case. They didn't conduct a good investigation, and it was some Puerto Rican guy. Sure, John was hit by a car, but it wasn't Karen's car, and the prosecution can't prove that it was her car. To me, that would have been a lot stronger. That would have been a lot stronger of a defense. Kevin, with a trial this long, there's a risk either way. You put your best evidence first, and the jury might forget it by the time you go through all the boring, less relevant evidence. You put the best evidence last, it's fresh in their head, but the risk is you lose them in the meantime. So, as I've said from the start, I really liked the way the Waukesha prosecutors did Darrell Brooks' trial. They put the lead investigator on as their very first witness. As the lead investigator, he wasn't excluded from the courtroom, because I can't say for sure about Boston, about Massachusetts, but in many states, there are exceptions to the exclusionary rule. And victims are not excluded. The lead investigator often is not excluded. So he testified first. He sat in the courtroom through the entire trial, working with the prosecution. And then he was the last witness to tie things up, to clarify, to put a nice bow on top and seal the guilty verdict. And I really liked the way that prosecution team worked. Of course, they had 3 prosecutors, and all 3 of them were excellent. Like, even the young guy, can't remember his name, but he was definitely the least experienced, but he was so good. All 3 of them were excellent, excellent, excellent prosecutors. And I thought they were great. I thought they were great. So we'll see. And I don't know that they, as I've said, I haven't watched yesterday's testimony yet. That's what we're here for today. No spoilers. And won't be watching today's voir dire. But yeah, the coup and contra coup is what, with brain injuries, you get hit and you have that injury, but then the brain sloshes around and hits the other side of the skull and sloshes around, injures both sides. And the thing is, to me, Trooper Paul, he, based on Friday, so I've only seen the direct. I didn't watch his voir dire at the end of Friday because, once again, I'm a juror. He was decently competent on direct, not quite as clear as I would have hoped. He's nervous. He's not great on the stand. So I think his analysis seems to be pretty good. His testifying needs work. So yeah, it's just, and once again, it's for the jury to decide. So all that being said, how about we get into yesterday's testimony? As usual, we're at 1 1/4 speed. We might go up to 1 3/4 or 1 1/3 or 1 1/2, depending on how things are looking. So let's go. All right, Neil, enjoy the footy. Go whatever team Neil is cheering for. I assume Scotland, but really.
All right, so we can bring the chairs in. Morning. Sorry.
It was definitely fun, Kevin.
You are unmuted.
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Beverly Benoni, now sitting in the Norfolk Superior Court within Fulton County of Norfolk.
So is First Justice like the Chief Judge? I realize that's a pretty simple question, but you know, different jurisdictions doing things differently. I don't know. So, all right, then go Czech Republic. And oh yeah, congratulations to the Boston Celtics for winning the championship.
Draw near, give your attendance, shall be heard. Outside the Commonwealth District Court, I think you be seated for the now session.
Good morning again, Counsel and Ms. Reed. Good morning, jurors. I hope you all enjoyed this gorgeous weekend. I have those 3 questions to ask you. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left here on Friday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left you? Everyone said no or shook their heads. Thank you very much. Could we please have Trooper Paul?
And swatch yourself for me. Thank you.
Maintain the faith. So, the other speaker for the jury in case down here, truth, the whole truth, and nothing but the truth, so help you God.
I do.
Morning, Trooper. All right, Mr. Lally, whenever you're ready.
Morning, sir.
Good morning.
If you could just again, please state your name and spell your last name for sure.
Yes, it's Trooper Joe Paul. That's Paul.
And sir, if I could just take you back to a couple different portions of your testimony from Friday. With respect to the acceleration and braking tests that you conducted in the driveway area or outside of Camden Police Department, was that before or after Ms. Hartnett from Crime Scene Services Section had processed the vehicle?
After.
And so as far as anything that was removed by her, that was done prior to you conducting any of your tests, is that correct?
Correct.
Now, you've investigated approximately 191 crashes over your time with the cars unit with the state police, correct?
Correct.
Now, I'm going to ask you just some general questions with regard to a number of those crashes have involved motor vehicles, collisions with other motor vehicles, correct?
Yes.
Now, in general terms, with respect to motor vehicle collision, what, if any, you talked a little bit last week about sort of area of impact and point of impact, correct?
Correct.
Now, that's with regard to the roadway, is that correct?
Yes, it is.
So with regard to the vehicles coming in contact with each other, what, if anything, regarding damage would you expect or anticipate based on your experience in general terms when vehicles come in contact or touch each other in a collision sequence?
No, I'm going to allow it. In general terms, what do you look at?
So we look, well, it's 2 times of damage onto a vehicle. One's contact damage and one's induced damage. So when we look at vehicles, we are looking for what's called contact damage. And the induced damage is basically, start from the beginning. So contact damage is the damage that is actually made direct contact with another vehicle. And induced damage is the damage that did not make direct contact. So for example, if you push in one piece of metal to make contact, the rest of the metal will make a rippling effect that would more cause induced damage.
And just again, in general terms, as far as vehicles coming in contact with each other in a collision sequence, what, if anything, would you expect or anticipate based on your experience to sort of transfer from one vehicle to another event?
It's possible when you transfer, you can have paint transfers that come from one vehicle to another. You got tire rub off that go from one vehicle to another. Scratches that would come from one vehicle to another.
And again, so just in general terms, when it comes to vehicles interacting with each other in a collision sequence, what, if any, role does the respective height?
So my understanding is Friday's voir dire of Trooper Paul got testy. As I said, I haven't watched it. And it was about the apparent collision at 5:07 a.m. when she was backing out of the O'Keefe driveway. And I'm assuming that's why we got the objection just a minute ago. But asking about the direct versus induced damage and vehicle collisions, well, this was an auto pedestrian collision, not a vehicle on vehicle collision. So why are they talking about vehicle on vehicle collisions? Well, probably to try and say, yeah, no, that damage didn't occur from the little love tap on John's vehicle.
Of those vehicles play in respect to contact damage or induced?
Yeah, it depends on their heights and how they relate to each other. So that kind of shows if one vehicle is taller, one smaller, it's going to show where the contact damage would be from one vehicle to another based on their height.
So based on respective heights, contact or induced damage could be in a different location from a bigger vehicle to a smaller vehicle, correct?
Correct.
Now, if I could turn you back to the tech stream analysis that you conducted with respect to the defendant's vehicle. Now, the 2 events that occurred on that 1269 miles deep, there were 2 events that occurred within that trigger, within that mileage, is that correct?
Correct.
And based on your analysis with respect to the odometer readings and the mileage, where is it, what is your belief as to where the vehicle was when those 2 events being the 3-point turn and the backup straight for approximately 60 some odd feet? Where did those occur within the travel path of the defendant's vehicle?
So the first one with the 3-point turn, in this case, it appeared to be possibly onto as a Cedar Crest, which, because we know based on testimonies that she missed the exit to Fairview and had to make a U-turn onto Cedar Crest, and that would make sense to why they would occur with close proximity to each other. They're within the same odometer mileage and on the same key cycle.
And so that occurred 24.2 miles per hour for 60 some odd feet. Where would that have occurred geographically from your view of the odometer reading?
It should occur probably on Fairview.
So reverse 24 miles an hour on Fairview.
Now, sir, based on the totality of your analysis and your investigation in this case, what, if any, conclusions did you come to as to how this collision sequence occurred or how this crashed?
Yes. Can I show my report for that, or should you want me just kind of go off
You
it?
guys can look at your report?
Yes.
Sure, go ahead.
Okay.
Thank you.
We continue.
If you could, please.
Okay.
What, if any, conclusions did you come to through the course of your investigation?
So on Saturday, January 29th, 2022, at approximately 12:45.
So you can look at your report, but you can't read your report.
I
So
read my conclusions based on what they asked me to do. Okay.
Don't argue with the judge. He's wanting to be an expert witness, and she's saying no.
Yeah. So I can't hear you.
Sorry.
Okay. So just take your time, read your report, and then answer Mr. Lally's question. And if you need to look at your report, we'll see about that again.
All right.
Ask the question, Mr. Lally.
Based on the totality of your investigation, what, if any, conclusions did you come to with regard to how this collision occurred?
So this collision occurred on Saturday, January 29th, 2022, at approximately 12:45 hours. A 2021 Lexus LX570 was traveling
Right.
southbound on Fairview Road, in area 34 Fairview Road.
Yeah.
It appears that.
So,
I'm trying to
so
upload it.
you know what? Mr. Lally, break this down. Ask
Yes, please.
simple questions so that the witness can answer your questions. We don't need a narrative.
From your investigation, what, if any, conclusions did you come to as to where this collision occurred?
So, all right. So on the night of Saturday, January 2022, at approximately 12:45 hours, a 2021 Lexus LX570.
Can you slow down? sir?
Yes.
So forget all that part,
Okay.
Trooper.
All
Just answer the question.
Okay.
Where did it occur?
It occurred in the area 34 Fairview Road.
And who, if anyone, were the participants in
She's impatient today.
this collision sequence?
The operator appeared to be Karen Reed, and the pedestrian was John O'Keefe.
And where was the vehicle located in reference to the residents of 34 Fairview?
It was located along the southbound travel lane and to the left side of the house as you look at it from the front.
And as far as the vehicle, what, if any, directionality did it head in, and what, if any, interaction did it have with Mr. O'Keefe?
So the vehicle was traveling in reverse.
And that's a good point, Darcy. Jurors who have been diligent about following the rules, if they find out another juror isn't, yeah, they're not going to put up with it.
Along the southbound travel lane, traveling north.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
And at the time that the vehicle was traveling approximately 24 miles per hour over approximately 62 feet, what, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
And post-collision with Mr. O'Keefe, what, if anything, did the defendant's vehicle?
The Lexus continued traveling in reverse before they left the area.
Now, as far as the vehicle,
So, once again, over the weekend, I was a bad juror and watched Yellow Cottage Tales interview Attorney Mahoney again. And I still very much agree with everything Attorney Mahoney says. And basically, after Mahoney left, they played a video, basically some lady did an animation of it, of the crash. And like, she's obviously very skilled at animation. But I thought the animation was just as deceptive as the defense's animation of the house, of the yard at 34 Fairview, showing it flat, easy to see everything. Because this animation showed basically John getting thrown almost straight back, like right on the like on the grass, but like right next to the curb. Whereas he was found closer to the flagpole. And so I thought this depiction was very deceptive. Oh, Kevin had that made? It sounded to me like he just came across it and played it. Because some of her narrations to me sounded like she was free Karen Reed crowd. But I could be wrong. And it's not evidence. It was a YouTube video that Kevin on Yellow Cottage Tales played on his Sunday live stream. So yeah, never trust Kevin's. And right, Kfar. But yeah, so I didn't catch that Kevin had it made. And to me, like, the end result to me was deceptive. But okay, so there you go, a different video. But the impact to me clarified a little bit, because the trajectory that John was thrown was clearly not what happened, unless he crawled toward the flagpole. But it did illustrate to me, you know, if he were 10 feet further north, like on the property line to 32 Fairview, Karen could have been backing almost straight back parallel on the road. Like, because to me, it was like she hit him traveling diagonally on the road, diagonally backwards. But watching the animation, even though I don't agree with the end result, she could have been backing pretty much parallel with the curb, and striking him on the corner of the vehicle could throw him at a 45-degree angle and put him near the flagpole. So even though I didn't agree with the result and her questioning, well, if the glass is in his hand, how could it damage the car? And it's like, well, if he's holding the top of the glass, the heavy bottom would hit the car. Duh. But it just, watching the impact itself, it clicked, and I'm like, oh yeah, that could throw him at a 45-degree angle. So we'll see. But, well, we won't see because there isn't a video. That's just a fan fiction video. But yeah, and that's it. In the end, it's for the jurors to decide.
From your inspection, what, if any, role did any mechanical aspects of the vehicle play in this collision?
There were no mechanical defects.
As far as your analysis,
And Kevin, I think because she didn't know the street, she didn't know the neighborhood, she needed directions to get there, and it's easier to go out the same way you came in, is my guess.
Of the roadway and other factors related to that, what if any role did they play in this collision sequence?
There were no roadway or environmental factors that contribute to this collision.
Now, sir, with respect to your investigation, what if any opinions did you draw based on your training experience in regard to this collision and how it occurred?
May I look at my report real quick, just to make sure?
Yes.
Thank you.
Vera, good to see you.
So throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration when
He's definitely nervous. Don't look at your report. Naughty, naughty.
Sorry. The vehicle accelerated at a high rate of speed before she struck the pedestrian John O'Keefe on the roadway and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle and made use of in the course of your visibility analysis, what, if any, role do you, is it your opinion that played in how this crash occurred?
Based on the visibility analysis. So even if the camera systems were covered in snow, even the systems were defective anyway, and even the mirrors were blocked, an attentive and a reasonable operator would not travel in reverse, especially at a high rate of speed. They would have cleaned the mirrors off. They would have made the cameras and systems, if they worked, they didn't work. They would have done all this prior to accelerating.
And that's a good point. Well, first off, you don't accelerate 24 miles an hour or in reverse. That's reckless. Like, that's very reckless. But if your visibility is obscured by snow, blocking the cameras, blocking the mirrors, blocking the rear windshield, you especially don't reverse at 24 miles an hour. You creep because your vision is obscured. So, yeah, that just, to me, goes even more to it was intentional. Or she was really, really, really drunk. So it's 3/4 throttle according to the Lexus software. If I'm remembering from Friday, the chart, basically it said 3/4, 74.9% throttle. So you don't do that if your reverse camera is blocked, if your mirrors are blocked. Frankly, if everything's blocked, you shouldn't be reversing, period. You should clear off your car. And, you know, a big pet peeve of mine is you should clear off your entire car, including the roof. It's dangerous driving with a foot of snow on your roof. I realize at this time there's only like an inch of snow because it only started snowing, but the number of times I've seen people driving with between 12 and 18 inches of snow on the roof of their car, first time you stop, it's going on your windshield. Don't do it. Don't do it. Don't do it. And that's it. You know, as I said a week ago or 2 weeks ago, there was no driveway in front of her for like 2 or 3 houses. Well, on the other side. So she would have had to drive forward to find, but yeah, to do a 3-point turn on a narrow street in a big SUV, you're probably doing it in a driveway. And not having a driveway, I like, my gut is it was intentional. And no, I don't. And yes, every house has a driveway. So but the next driveway on the other side was quite a ways down, because the driveway across the street was behind her, and then the next house had the driveway on the other side of the house, and so it's basically two houses away, more, so it is a fair distance. She might not have seen the next driveway and just thought, fuck it, I'll turn around here. But I don't know. And JT Davis, good to see you. And Suburbs 101 is that I hate driving in the suburbs. Ugh. I really do. But yeah.
In reverse.
The objection sustained.
Move to strike.
I'm going to strike that.
With respect to your observations during the course of the visibility analysis, the exemplar pedestrian that you placed in the right rear of the vehicle, was that exemplar pedestrian visible to you at the time that you conducted that visibility analysis?
Yes, it was.
Thank you, sir. I have no further questions.
Okay, cross-examination?
Thank you, Your Honor.
That's a very good point. Is it an accident when you're at the very least being reckless? And before cross-examination starts, let me just point out my utter contempt and hatred for little Alan Jackson. I really dislike him. And yeah, like Ithaca, I assume, gets the lake effect until the lake freezes over. The thing about the Great Salt Lake is, being salty, it doesn't freeze over. So we can get lake effect real late into the season. But before law school, I worked at the radio pharmacy at the university, and our work trucks, like literally 3 of us would clear off the trucks. Everyone else would just go out and scrape a little visibility window, and it drove me nuts. And so the 3 of us would go out and clear all of the trucks, and that really annoyed me.
So do you have any, do you hold any degrees in the scientific discipline of mathematics?
I do not.
Do you hold any degrees in the scientific discipline of physics?
I do not.
Hold any degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
How about ask him, do you hold any degrees?
Well, sir.
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
At multiple classes.
You introduced the idea of what kinematics is, right?
Correct.
Testified about that on Friday.
Yes.
Define kinematics. Yours.
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics?
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Physics, correct?
Yes.
And it describes how points and objects, systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with the motions.
What's that called? the rate of velocity? What's another word for that?
The rate of velocity?
Right.
I mean,
Acceleration.
it deals with the motion. It deals with forward, and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play?
The word you were looking for was acceleration.
In the field of kinematics?
What role does what role does acceleration play in kinematics?
Right.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion?
That's what I asked.
Constrained motion. I can't recollect at the moment.
Constrained motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
When it doesn't have a predetermined path?
Free movement, right?
Correct.
Good to remember that from your class?
For the most part, we don't go that constrained and unconstrained.
Constrained, unconstrained, not restrained.
Sorry, unconstrained. Yes.
Kinematics uses algebraic formula to model these motions, right? Motions of these points, systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over a point in time or duration in time. Is that right? Do
Yes.
you actually understand the physics behind the study of kinematics?
Yes.
The word you learned in class.
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from the vehicle. You reiterated that again this morning. Is that right?
Correct.
I want to be clear. That is your opinion based on your training and experience, correct?
Yes.
And
on
that's
Friday, you
what
said-
experts give, is their opinion based on the data and applying their experience. That's just your opinion, man. Well, if you put your experts on, it'll only be like their opinion too, man.
You base that fact, you base that rather opinion on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said it was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go in my report saying I can't say that's definitively where a pedestrian was struck, but
I'm sorry, but
it wasn't definitively. Sorry, in my report I do say I can't say that is definitively where the pedestrian struck.
You cannot say it.
Definitively, yes.
Okay, so you're going to have to slow down and speak up, okay?
you said, I just want to make sure I'm hearing you correctly, and I apologize.
Okay.
You said you cannot say definitively that that resulted in a pedestrian strike.
That data point within the text stream data is what I'm talking about.
Okay.
That specific point, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by a half a mile an hour, right?
It's when I say when it's consistent, it's because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator.
Yep, interrupting cow. And as he's trying to answer, yes, there are a multitude of things that can make you slow down. But when the accelerator is in a constant level, there's some outside force that caused the 1 mile an hour deceleration.
It's I think it's a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
You also note that at the time, it had begun to snow, correct?
Yes,
The snow on the lawn, right?
correct.
Snow on the cars,
Yes,
snow on the trees,
yes,
snow on the roadway.
yes,
Snow on the roadway could impact how tires move over the roadway, correct?
in a way.
And obviously, there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, correct?
Correct. That's why I said I can definitely say it.
Right. So every time somebody slows down, going in reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the area of impact by basically following, if I heard your testimony correctly, basically following the debris field from the body from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what in your mind, or what you were told was his final resting place, and what you were told was the debris field. And you indicated that the furthermost piece of debris would basically be the area, right?
What you're told was his final resting place. Yeah, he wasn't there on the scene that night, but you know, they kind of documented where he was found.
It's within that line. I didn't say that is the area impact where the furthermost piece of evidence is.
Right.
It's just the linear, like you said earlier, it's that linear. We're going that path. That's the path that he traveled post impact with the vehicle.
And that is on which that fact that you stated is on which it's a terrible question. That's the basis for your opinion of where the area.
Oh, now you think it's a terrible question? Half your questions have been terrible questions, but you know, it hasn't stopped you before.
Correct?
Yes.
Let's take a look at exhibit, with the court's permission, 587. It's your diagram 3. If I may approach on this verb.
Okay.
And Frank, I'm with you. I have contempt for little Alan Jackson. I also have contempt for David Yannetti, but I absolutely loathe little Alan Jackson. And this is coming from a defense attorney. You know, you can advocate for your client without being a jackass. If your anger with the witness doesn't match what the jury thinks your anger level should be, you're maybe overplaying it. Once again, from attorney Kevin Mahoney, I really liked the way he said that. That's why I copied him. If you come out and you're immediately angry with the witness, and that anger level doesn't match what the jury has experienced, you're just being a jackass and you lose credibility. Like, you can work up to being angry with the witness, you can work up to an argument, but if you come out both guns blazing, it's bad. And yeah, that's absolutely disgusting. It's, to me, it's witness intimidation. That's contempt. It's criminal. Like, if he had no good reason to be at Trooper Proctor's sister's school, that's criminal. I just, you know, I advocate for my clients the best I can. I'm not going to jail for any of them. I'm not getting disbarred for any of them. I don't understand why Jackson and Yannetti seem to be willing to, because I think they've crossed the line. I think they've crossed the line, and it's gross. It really is gross. And my understanding is he went there to meet with a witness. I don't know who the witness is. I saw the name somewhere, but I don't know who he is, what he'd testify about. But whether he suggested meeting there or if Yannetti suggested meeting there, it's gross either way. It's criminal either way. And you don't, if you don't have legitimate business at a school, you don't fucking go to that school. If you're not a parent or a student or a teacher or like there for an assembly or like something, if the front office wouldn't open the door for you, you don't go. You just don't. It's gross.
May I approach?
Yes.
So you can see it. Your Honor, did we publish Exhibit 587?
Yes.
Okay.
But Yannetti still should have known better. Yannetti's the attorney. He should have known better.
So you see diagram 3 on the board. You also have it in front of you, correct?
Yes.
It's easier for you to refer to what's in front of you because that's a little bit further away. Let me know.
Okay.
The red arrows adjacent to the blue writing, where I'm highlighting right now, indicate basically the debris field that she explained to jurors on Friday, correct?
Yes.
And then there's a point of an arrow that comes back to a wording that says pedestrian's final rest, basically right there, correct?
Yes.
And the debris field ends right in the middle of that spotlight, correct?
Yes.
All right. So that's the area of impact that you indicated to Mr. Lally you believe occurred because of the debris field and the linear portion of that debris field going from pedestrian's final rest all the way out to that final red arrow that says red plastic B in parentheses, correct?
Yes.
Your Honor, can we have Exhibit 492 published to the jury, please?
Okay.
Approach.
Yes.
While that's coming up,
So basically, the video I saw that I was referencing on Yellow Cottage Tales that I disagreed with showed John basically being struck right in this area where the shoe was left, and then being thrown basically along the curb and landing sort of right here where the word glass cup is, basically right next to the road. Whereas, as I said, you strike him right about here where the shoe is, but most of the impact on the side of the car, that impact would throw him at a 45-degree angle, and well, not quite a 40, but like you know, at the angular momentum striking him right on the side, right on the corner of the vehicle, would throw him basically from the shoe in this direction. And once again, the shoe is planted not by the conspiracy, like his foot is planted on the ground, the force knocks him out of the shoe more or less doesn't have the energy transferred into it, and so falls basically right where John was hit. Like, it might not have even left the ground if the energy is all transferred into John and not the shoe. So, yeah.
while that's coming up, have you ever seen this?
No, I haven't.
Take a look. just above the arrow, Your Honor, with court's permission, maybe highlight or magnify the area just above the arrow.
Okay.
You see that?
And the spray of the glass isn't going to be in a straight line. Like the glass, well, the plastic will travel in a straight line, but within the spread, like whatever direction the impact sends it in, within the sort of arc, within the, not being a physicist, I don't have the right word, the penumbra, the spray of the glass, it travels in a straight line, but not all in the same straight line. So it to me, glass flying at a 60-degree angle as opposed to a 45-degree angle is fine.
Yes, I do.
Right underneath fire hydrant, correct?
Correct.
What does that look like to you?
Piece of plastic.
It's debris, correct?
Correct.
All right. We go back with the court's permission to exhibit 87.
Okay.
Diagram 3. Just the fire hydrant?
Yes.
Fire hydrant's right there, correct?
Correct.
That's another, according to your scale, that's probably, I think, 30 feet from the pedestrian's final rest, correct?
Yeah, that's about right.
That is,
But once again, I mean, landing next to the fire hydrant, it's what was the angle of impact? If she backed into him across the street, could fly in this direction pretty easily. Let's say the impact is here. What is that? 8 feet from where the debris is. But then that would have the shoe flying and landing there. But the point is, we just don't know. And that is a good point. The snowplow came by later, coming in this direction, could have thrown the debris right there. The fire hydrant is close enough to the road that, yeah, it could have. It could have. So that's a good point, Vince.
is the furthermost in this diagram, the furthermost piece of debris on the diagram, correct?
Correct.
So now your testimony changed that this, in fact, is the area of impact.
No,
Why not?
because it's just a piece of debris. I'm talking about the path. You follow the path of debris field. Debris can move and change.
The debris doesn't fly backward, does it?
I'm saying you pointed to like just the fire hydrant as the area impact where the debris, where that one piece of plastic was, saying that's the area impact is right next to the fire hydrant.
Are you asking me a question?
Yeah, that's what you said, right?
I'm asking you,
I'm making sure I'm understanding what you're saying so I can answer the right.
Ask the question again, Mr. Jackson.
in fact, you indicated on Friday that your analysis.
He wants confusion from the witness, asking him to clarify the question. Well, you answer me. Fuck you.
The area of impact was predicated on, based on, the furthermost piece of debris from the pedestrian's body that you were aware of, which is right there. Red plastic B, correct?
I said you said earlier with the linear equation. I mean, it might have moved it over more, but it's the debris, the start of that debris, the one that is. I can't say that's definitely the point of area impact or the point of impact. I cannot say that is the point of impact right there. You just kind of follow the linear path because they have to follow in a direct path that way.
Okay, so now your testimony is that's not the area of impact.
I never said that was the area impact. I said it's after that.
Trooper, we were all here on Friday.
Okay.
That's exactly what you said in the questioning by Mr. Lally, wasn't it?
Objection.
Sustained.
Didn't you say on
Argumentative.
Friday that you determined the area of impact for Mr. O'Keefe? The point of impact was red plastic B because that was the furthermost piece of debris you were aware of from the final point of rest from Mr. O'Keefe's body. Isn't that what you said?
I don't believe that's my exact words.
Okay, I'm not asking if it was your exact words. I don't have a transcript of it. I'm asking you, is that what you tried to impart to the jurors?
What I said to the jury, I said after that. That's the start of, that's the last point of evidence that I had. I said the area impact is probably along the roadway after that point. I mean, like before it, so we have to walk towards him.
I mean, lucky for him, he'll probably never appear before her again, so he can piss her off all he wants.
I'm sorry, I keep doing that because I think you're done. Are you done?
I am done now. So.
Now you're aware that there's a piece of debris, looks like taillight material, right under the fire hydrant, correct?
Correct.
If the area impact, which you indicated on Friday, was where this red plastic B is, you would be wrong, right? Your analysis would be flawed.
No, because that's not what I said. I said it's along the roadway. It's going to be after that point.
Okay, so is the area of impact now where the fire hydrant is?
Objection.
Ask it differently.
Are you now indicating, because now you realize that there's a piece of debris directly under the fire hydrant, are you now indicating that that's the area of impact where John O'Keefe's body was struck?
Objection.
Sustained.
Let's take a look at exhibit, with the court's permission, 279.
Okay.
Take a look at exhibit 279. I'm going to draw your attention to that piece right there of plastic. You see it?
Yes.
You describe it for me. Just physically, what does that look like?
Looks like clear plastic with a little bit of red and black on the top part.
Okay. Maybe in a triangular shape. Is that fair?
Correct.
Okay. Now, if we could go back to, with the court's permission, exhibit 492.
It's a damn shark's tooth. That's what it is.
Okay.
And highlight just above the ruler. How would you describe that piece of material?
It looks like the same piece.
Does that, based on that, does that appear to be part of the taillight material that was found at the scene?
Correct.
Okay. Now, based on that, are you now suggesting, if we could go with the court's permission, if we could go back to 587, I'll stop jumping around just a second. I think we
Okay.
just get back to 587. Oh, sorry, the diagram. Thanks. Now, seeing what you just now seen in terms of that piece of plastic that appears to be from the taillight, does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Okay. Based on that, does that change your opinion? Is that now the fire hydrant now the point of impact?
No.
Where's the point of impact now?
It's along the roadway. I don't know the exact point of impact. Can I?
So you don't know the area of impact?
I said the area impact is along the roadway after the debris.
Okay.
I mean, only thing it would change. Only thing it would change is maybe it's a little further away. But besides that, it's a linear field. I'm not talking about like one point. You kind of follow the middle of the debris field, and that should be the path.
Well, if the point of impact,
The middle of the debris field, because the impact is going to send it a spray. You know, did that piece bounce off of John's head at such a velocity that it went that way? Or as Vince pointed out, was it the snowplow the next day pushed it off the road and it just hadn't been uncovered and the snowplow moved it?
is along the roadway. Where along the roadway? You can show the jurors where along the roadway, in your expert opinion, was the point of impact.
Fuck you.
It should be within, if you follow from pedestrians, final rest here, just kind of follow back. That's what I'm talking about, linear field. I can.
So now you've indicated an area. I can follow your laser pointer, an area along here, correct?
Yes, somewhere in there.
All right. If I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know, definitely there's nothing on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Mr. Paul, sorry.
He's not great at testifying. he definitely needs to work at that.
Call. I'm asking you, based on your expert opinion and your conclusions, based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is? Is my spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
You have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
So what I'm trying to say is, so we follow the linear path back around this area.
Can you?
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if we follow back to here, it could be a possible area impact.
So when you say that area there, just I want to be very clear for the record that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of diagram 3, toward the lower part of diagram 3.
It's fuck you. No, he said it's from the X to the side of the roadway to the curb. So it's in a line.
Correct?
You would use your circle almost to kind of be a good area around.
Sorry.
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, that scale is going from full left to full right, plus or minus 40 feet, right?
Switch. Can't see it. So say again. Say the question.
That scale is 40 feet, going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet. My mistake.
I was okay.
As a terror. 20 feet.
That's some lawyer math for you, or little Alan Jackson is just really dumb.
Thank you. All right, so if you use that scale, can you estimate the jurors? I'm just going to use this X as a starting point. We estimate the jurors from this X that I've highlighted. The pedestrian's final rest. What's that number? Doesn't have to be exact. Give me an estimate.
So I mean, it could be within 30 feet because I tell you this also on my scale. This 2 and 3 is 50 feet from each other.
It's how much?
50.
Okay. 50.
50.
So would you agree that from this X down here, so pedestrian's final rest, as a crow flies, that's probably a good 35, 40 feet.
I mean, I could try to use the scale with me as a scale.
If you wouldn't mind. Do you use paper?
Yes, please.
With permission?
Okay.
Just blank piece of paper.
Thank you. Yes, thank you.
You need a pen?
I got one. Thank you. It's a little around. It's approximately 30 feet.
Approximately 30 feet.
Yes.
Can you place, with the court's permission, can you estimate 30 feet in here?
Can
Can you point to a place in the courtroom that looks like 30 feet from you?
Objection.
No. Next question.
Does the court have a diagram of the diagram of distances?
In this courtroom? No.
You indicated just now, and then I'm finished with this. Thank you. Thanks. You indicated just now in answer to Mr. Lowry's last couple of questions.
And that's why Lolly needs to object, asked and answered. You don't get to ask the same question over and over and over. It's
That in your expert opinion, the SUV.
And you'll notice he's doing that to be a jackass. In your expert opinion, trying to drive home to the jury, this guy's an expert. He can't even testify. Whereas all the other expert opinions we've had so far, he hasn't. In your expert opinion, it's been in your opinion. It's just, this guy's the least confident. So in your expert opinion, he's doing it to be argumentative.
Struck pedestrian John O'Keefe. He was, quote, projected forward and to the left, to the front yard to his final place of rest.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected, I mean, like I don't think he flew all the way there. That he got pushed forward.
Which he was rendered incapacitated, landed there, that's sort of fly there, right?
He just said it doesn't mean he flew. He could have skidded. That's part of the projected.
Didn't walk there.
I mean, was you definitely flying like literally off the ground the whole entire time, or?
Well, you tell me, you're the expert.
Well,
I mean,
he's
he got-
trying
When we say
to.
projected, we mean
He's trying to, but you're. I don't know. You tell me. Ask better questions then, you prick.
he gets projected, and they usually have a landing phase, and they land, and they either roll or tumble to final rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no way to.
And being hit at 24 miles an hour by a 5,700-pound SUV can easily project you 30 feet.
Of where his exact landing spot was.
Is there any evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or no, rolled.
According to you, the evidence that you have in front of you is that he get hit, fly 30 feet, land where he ended up at his final rest, right?
Objection. Sustained. Ask it differently.
Based on your expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I was saying.
Well, you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
Exactly.
Fuck off,
Exactly.
fuck off,
Objection.
fuck off. Exactly. Stop with the commentary. You've been told multiple times. You've been told over and over to stop with the commentary. Fuck off with that. Exactly.
Sustained.
You said on Friday that in your experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train, and if you have something in your hand, boom, you lose it, you drop it. It's not strapped to you, correct?
Correct.
You can.
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow it. Do you have a theory on that?
Maybe the cup was struck by the back of the SUV, so it flew with him. Energy was projected into it.
I don't know. I mean, it just could have been with him the whole way. I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So it's just common sense. You have to believe it. So it was in his hand. He held on to it the entire time he was being projected. Correct?
It's possible it could have been his hand. It could have been tucked next to his clothing. Did
you say tucked in?
I mean, like, could have been next to his body. So when he projected, maybe the glass was with his body as it was also flying. So there's a number of reasons why the glass, because it also got projected with the body while he was holding it.
I thought you said on Friday, and you just agreed with me, that people drop things.
But if the SUV hit it,
not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on. It's not uncommon to find a piece of clothing and stuff, that you find at the scene.
it's in his hand, he gets hit, his hand clenches.
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said why this, I'm just responding to what you said.
It's not what I asked, except it fucking is. You asked him about what he said last week, so he's clarifying your question. That's not what I asked. Yes, it was.
I'm trying to make sure you understand what I'm saying.
No, I don't, but I'll ask another question. Shoes are strapped on by definition, right?
Yes, but it's very common for shoes to come off.
How about a cell phone?
Cell phone, yeah. Yeah, it depends. Depends on where it is.
Well, it was under his body.
Okay.
How do you account for that? He held onto a cell phone with one hand and held onto a cup with the other.
Objection.
Sustained. Ask it differently.
If the cell phone was found under his torso, under his body, what's your theory on how that cell phone ended up flying 30 feet with it?
He would have to know where the cell phone was to begin with. What was it in his hand? Was it in his pocket? how is he supposed to guess that if he doesn't have data?
It just did.
Just did. And somehow, as he landed, tucked that cell phone underneath his body, so he landed on top of it.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
objection.
All right, so
Fuck
jurors, I've told
off.
you before, lawyers cannot make comments, so disregard it. Mr. Jackson, don't do it
I
again.
understand. So
You understand, but don't do it. Your answer's always, I understand. Don't do it.
Yes, Your Honor.
She's sick of him too. It's just been constant. Every single witness, he does it. So either he doesn't understand or he doesn't care.
Cell phone in one hand, cup in the other hand, with video, right?
Objection.
Sustained.
You were informed of this incident on January 29th, 2022 at about 2:30 in the afternoon. Is that right?
Yes.
At the time, you were working out of the Cars facility, which is located on West Grove Street in Middleborough. Is that right?
Yes.
By the way, that's a facility that has multiple garages. Sally ports, I don't know if they're called Sally ports, but garage bays, correct?
The mechanic shop are there.
The mechanic shop.
Yes.
It wasn't the witness being admonished. It was little Alan Jackson, Brandon, because he won't stop with the commentary.
Is if you're going to review, for instance, for purposes of reconstruction, if you're going to review a vehicle, is the vehicle placed in those mechanics bays?
No, not there. That's for state police vehicles.
Okay, so where are the mechanics bays? Sorry, reverse that. Where are the Sally ports where you do your analysis, your reconstruction, your review of the vehicle, inspections, things of that nature?
We don't have Sally ports for that.
You don't have anything dedicated to that?
No, the only time we would use a Sally port is the crime scene would have some Sally ports that they would do to document their crime scene stuff. And I've gone there to do my inspections, but most of our inspections are done either at the tow yard or some type of facility for that.
Ultimately, was this SUV ever taken to the Middleborough facility?
Yes, it was.
Where was it placed?
There's a fenced in area inside it's a fenced in area
Is it outside or inside?
outside.
Okay. Did it remain outside in that fenced-in area the whole time?
I don't know the exact time. It was there for a while, then it got moved.
Where did it get moved to?
I'm not sure exactly where they moved it immediately after I left Middleborough.
Are you familiar with the Foxborough location? Does
Yes.
that have Sally ports or bays for inspection and evaluation?
It has garages in it, but we wouldn't use them. We don't normally use those garages for inspections.
Is it possible to use those garages for inspections?
It is possible.
Okay. It's happened before, correct?
I've not used the inspection in the garages.
But
I'm going to ask you to keep your voice up and
Sorry,
speak
yes.
slowly.
you know that it could be used.
Sorry.
Sorry. You know that those bays could be used for inspections, or analysis, or evaluation, if needed. Correct?
Yes.
All right. Given the fact that the SUV that was being seized on January 29th was being seized as potential evidence, best practices would suggest that you want to get it in and out of the bad weather, the inclement weather, as quickly as possible, correct? You wouldn't want to subject it to continued forces from nature like rain, wind, snow.
But once you've collected the evidence off of it, you no longer care. You don't have to keep it in the Sally port until the trial. Once it's processed, putting it in the tow yard is as good as anything.
Sleet, hail, right?
That would be beneficial, yes.
You're aware that the Foxborough location and the Middleborough location with the mechanics bays are all closer to Dighton than Kent, right?
Both Foxborough and
Foxborough and Middleborough are both closer to Dighton than Kent. In other words, you have to pass by, depending on which way you go, pass by Middleborough, pass by Foxborough to get to Kent.
so from
But as Trooper Tully testified, Lieutenant Tully, those Sally ports didn't have room. They were closer, but they wouldn't have worked for their purposes. There wasn't room. They couldn't fit an extra SUV in them, whereas they could in Canton. This dude had absolutely nothing to do with where it was brought.
where?
From Dighton, sorry.
So from Dighton.
Where the vehicle was seized. in
Yeah.
all going toward Canton, you pass by either Middleborough or Foxborough to get to Canton. Correct?
I don't believe you'd pass by Middleborough to get to Canton, but you've passed by Foxborough.
the car was not taken to Foxborough, was it?
No.
As a matter of fact, the car was taken basically double the distance all the way to Canton to that Southport, correct?
Objection.
Do you know that? Is that double the distance?
I don't know the exact distance. I know it was in Canton.
And you know it's far to Canton.
From Dayton, yes.
Right. And you're also aware that because you've been to the scene, assuming correct, at the 3430.
Yes, I have.
And you've been to Canton, PD.
Yes, I have.
You know those two locations are about 3-4 minutes apart.
Yeah, I can say that.
In good weather.
When you started let me ask this in a different way. Before you began any review on this case, any physical review on this case or analysis on the case, you were told that there had been a crash, correct?
Yes.
You testified to that at the state court grand jury in this matter. Is that right? That you've been told in advance this was a vehicle pedestrian crash. And you were asked to analyze it, right?
Yes.
You wrote in your report that it was a single vehicle collision involving a pedestrian, and you were, quote, assigned to reconstruct that collision, correct?
Yes.
So when you began your analysis, Super Paul, you were told conclusively by the lead, your job was to reconstruct it. Is that right?
Objection.
Okay, so there are lots of parts to that. Break it down.
Sure. Were you told by
Hearsay.
Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Chief of Proctor?
I was not.
Okay, next question.
Sure. Who were you told, who were you given your instructions by
Instructions for what?
to reconstruct this incident?
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time. He gave me the phone call.
And you were told some basics about that reconstruction, the event that you were asked to reconstruct, correct?
Yes.
Information that you were told came from the case officer. Is that right?
What's to the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident, pedestrian bicycle, motor vehicle motorcycle. You were told it was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that, yes.
Right. And you had to be given some basic parameters of what that incident, how that incident occurred. Car was going in reverse, it's got a damaged taillight, things like that.
Some basic stuff, yeah.
What I'm asking is, I'm trying to get to is, who gave you that information? Where did it come from?
That the car was traveling in reverse. Like, which part of the information? You asked me about several different things just now.
Were you given information from multiple sources? Or did someone give you a summary of what you were being asked to do? At the very beginning,
Yep.
who gave you the summary
Summary of the whole entire, of what?
of the event that you were asked to reconstruct?
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary, like that I can remember. I was told that it was a pedestrian crash. I knew it was Boston police officer involved, that this was a vehicle, and that it was traveling in reverse. That's all they had.
Okay. What I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
I don't know if it was definitely anybody from the get-go that was like I talked to.
From where?
I don't know if it's anybody that I could definitely say that was the person. There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on what the vehicle was.
Okay.
So
My question is this: when you got that, did you call it a lowdown? Give you the lowdown?
he gave me information. Yes.
Right. When you got the lowdown, you were told Boston police officer was involved. The vehicle pedestrian incident. Car was going in reverse. Ultimately led to the death of the pedestrian. Struck the pedestrian in reverse. Correct.
Correct.
And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
I know the phrase. Yes.
You know what it means?
I can't definitely say what it means.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
You say so.
You noted in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to?
He definitely isn't very good at testifying, Grey Duck. Of course, Jackson isn't very good at asking clear questions. So you have a witness that's not good at testifying, getting questions from Jackson. It's just a recipe for disaster.
Any other time?
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, or I saw the video like a year ago on Court TV, I said that could be
On Court TV.
You asked the question, so next, keep going. He's answering. Next
trying to
question.
guess
Go
how
ahead.
scientific
Hold on.
thought the scratches were.
Hold on. Ask
Sorry.
your question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes.
Get scratched myriad ways, correct?
Correct.
Get scratched in a grocery store parking lot, right?
Yes.
Shopping cart can bounce off back.
And
scratch bumper,
if
scratch
that's
table.
the case, he needs to work on it, because being a witness is part of the job. So he needs to work on it.
By the car, quarter panel or something, right?
Sure.
I mean, I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get scratched, correct?
Correct.
My question is, do you, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well, do you have any evidence whatsoever that you can point to that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
I mean, they're consistent with that. That's the thing about science. That's the thing about reconstructing accidents. This is consistent with our theory. Consistent with, not confirmation, but consistent with. You know, with science, you're not proving anything. You're basically you're trying to disprove the null hypothesis.
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second.
Yeah.
You testified Friday, you were pretty clear. You said that, if I can find it exactly. Let me have just a moment, Your Honor.
Sure.
You said, quote, the dent and scratches for his hand could be, those are consistent with striking the Lexus.
And
You're saying
that's
that?
it. They are consistent with. That's what science is. It's consistent with striking the hand and glass. Consistent with.
Yes, on the tailgate.
Okay. So the dent and scratches we talked about on Friday, you said were from his hand.
And a glass.
Yes, hand in a glass cup.
Okay. Then are those the same scratches you're talking about in terms of the bumper?
No.
So,
What are you talking about? The scratch inside the bumper that we talked about?
correct.
Okay,
That's what I'm
no.
talking about. Okay. Is there any way to scientifically date a scratch?
No.
You go out in the parking lot right now, even as an accident reconstructionist, you walk out in the parking lot right now and look at a Toyota Camry sitting there. It's got a scratch on it. There's no analysis that you can engage in to date that scratch, could you?
Objection.
So you can ask it differently, Mr. Jackson.
Is there any way that you could, in general, look at a scratch and say, that scratch is from such and such date?
Objection.
I'll allow it.
Nothing more.
I'll allow it.
You cannot say. You can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would came from.
And it's possible.
Correlation is causation as long as it helps him. But the minute it doesn't help him, correlation and causation, what are those? Which, once again, zealous advocacy for his client, but it's, as I've said, it's consistent with striking him. saying definitively, oh yeah, that, that struck the third knuckle on his right hand, and it he, I scientifically dated the time of that scratch to 12:47 a.m. on January 29th, and yada yada. That would be complete horseshit. But saying it's consistent with is the scientific way to say it. It just is. And that, to me, that's a problem. It really does, to me, make him less effective. I mean, as I've said, this witness hasn't been good on cross-examination. But I don't think Jackson has scored many points either, because he's being a douchebag, not a zealous advocate. Or at least his douchebag tendencies are overshadowing his zealous advocacy. And once again, I don't know what the jury is thinking. I'm not a mind reader. It would rub me the wrong way if I were on the jury.
Any or all of those scratches on the Lexus could have predated January 29th, correct?
No.
That's not possible.
The ones that are on from the tail light and the other parts of it?
Scratches anywhere on the car.
Depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch. It's possible that any or all of those scratches could predate January 29th. Simple question, right? It's possible.
You're being pretty broad on your scratches here.
I'm not being broad. Let me ask it a different way. Let me ask it again. Is it possible?
Let me ask it a different way, but exactly the same, just louder.
Any or all of the scratches noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car.
Answer that question.
That it predate. Objection. I don't know every single scratch on that car.
No, it's not, because we know the taillight wasn't broken before then. So how would that predate?
I mean,
Overruled. So can you answer that question?
no.
Testify that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, would be matched to the cup?
I don't know anything about I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup, that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's
Fuck
what
you.
was told to me as evidence.
Fuck you. He just said he can't answer it. That's argumentative.
Done. By whom?
By the crime scene.
Who told you?
As crime scene, I was there. It says this glass from the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. I said by crime scene. While I was at my inspection.
Wait, what?
It was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Did Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No.
And here's the thing. You discount just about anything that this guy has testified about. Just throw it all out, except for the data tables. And working back through the key cycles to say this was the one where they drove from the waterfall to 34 Fairview. And if that's the only takeaway you get from this witness, to me, the evidence from all the other witnesses is still strong. It's just the only thing you really need to take from what this guy has testified is she reversed at 24 miles an hour at 12:40-ish, and it, you know, it was the inputs would indicate she struck something. Now, whether that's the curb or a body or whatever, it's just that's really, frankly, that's like Lolly should have interacted with the witness before trial. Like, I'm not saying do a mock trial. People actually do entire mock trials. Like, you know, generally it's for the lawyers and the, like, there are personal injury firms here in Utah that will, like, I'll see ads all the time saying, you know, come be a mock juror for this mock trial and we'll pay you, you'll give us feedback, and we'll refine our trial strategy. And, you know, if you're doing the mock trial, you'd probably do it with your witnesses. And then, like, knowing what little Alan Jackson is like, Lolly would get the biggest douchebag lawyer he can find to do the mock cross-examination. And if this witness crumbles, you're going to limit the scope of what you ask him and maybe limit it just to the absolute technical data, the, you know, the Lexis software. And the thing is, if he's the one that did the analysis, he's the one that has to testify about it. So should they have got an outside expert? Probably would have been a good idea. But, you know, you're dealing with taxpayers' money, and taxpayers don't like you doing things twice. Of course, having a second expert as opposed to paying for an entire second trial potentially is a better use of taxpayers' money. And yeah.
The crime scene told you.
Correct.
But if you knew that the crime scene was incorrect, and in fact those glass pieces don't match the cup, that change your opinion?
Objection.
Sustained.
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No.
I'm sorry. No.
I don't. It's a glass from a cup. It's glass. It's not. It doesn't belong to the vehicle.
Right.
It's glass.
But if I told you it didn't match that cup,
What?
your opinion?
Objection.
Does that change your opinion?
Are we talking which cup? We never established which cup we're talking about.
How many cups have we been talking about, Trooper?
You said that cup. One from the scene. Okay.
That cup. I'm talking
I just want to make sure that we're on the clear path here. On the clear what we're talking about.
Absolutely.
Okay.
He's got a good point. Who's to say there wasn't another cup? Who's to say there wasn't a second cup stacked on top of the first and it got atomized except for what was left on the bumper? Who's to say that isn't the case? I'm not saying it is, but he's got a fair point. You keep saying the cup under that, the base was found under Johnny, that cup. It's a good point. It's a good point.
All I said, it's
Was found next to John O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup. It's not glass from the car. That was my opinion on it. I didn't never said it matched to the scene.
You didn't.
I never said that in my thing. I said it's glass from a cup.
Okay. It's safe to say you didn't do any testing to determine the forces necessary to shatter a taillight on a 2021 Lexus.
And Giovanna, I think that's been part of his strategy. Confuse the witness, confuse the juror. That's the reason he does the gish gallop back and forth, switching topics and going back to a topic and backward and forward in time, just confuse everyone. And then when the witness says, "What do you mean?" "Well, I was being really clear. Are you just too thick to understand my stupid questions?"
This 5 seconds, right?
I did not do testing.
Your report indicates, we talked about this a little bit. I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came into his final resting place about 7 feet from the roadway, and that's what you based your diagram on, correct?
Yes.
Who told you that number?
I measured it from my diagram.
You should say that again.
I measured it from the diagram.
Okay, what I'm asking is how did it get on the diagram? In other words, who told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant Gallagher, Paul Gallagher, Captain PT. He told me this is where the body was found. So I used my devices to mark that location.
Okay, but before you used your devices,
But Canton Police was recused, so how could Lieutenant Gallagher tell you anything? Because they were still witnesses and Lieutenant Gallagher was on the scene and John was gone by the time any of the troopers arrived.
just pointed someplace on the ground and said he was about here. Correct?
That's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did you say that?
No.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body at being approximately 15 to 20 feet from the roadway?
No.
If he had told you that it changed your diagram?
Objection.
Oh.
He told me this is where he's found. I marked that location. That's all that was.
And you marked basically every other piece of item. Sorry, that's a terrible question. Every other item you marked based on a distance from where you were told John O'Keefe's body came to rest, correct?
Yes.
Yeah, and that was by Lieutenant Gallagher just pointing at the ground saying it was about here.
Correct.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
So did anyone say this? Not hearsay. Did someone say, did Lieutenant Gallagher tell you this? Might be hearsay, but did you hear it from anyone? Not necessarily hearsay.
What do you mean team? Canton PD?
Whoever was there. Who was there with you when you started doing your measurements, et cetera?
I said Lieutenant Gallagher. That's who.
Just you and him?
And myself, and I was training a trooper at the time, and she was there.
You were training a trooper at the time?
Yes.
Okay, so my mistake. I assumed that there were several people out there. Just you and Lieutenant Gallagher?
Yes, that's why I was accused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place?
No, I don't think so.
You did document in your report that the items that you noted on your diagram that you just looked at a few minutes ago, those were found by the CERT team, correct?
Yes.
And you indicated in your report.
Well, lucky for you though, BB, we've got a full day because we're doing yesterday.
Members of the CERT team located a single Nike sneaker that was noted on your report. Is that right?
Correct.
Diagram, right?
Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a tail light was discovered.
Yes.
So your report is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well, it was that on there. I can remember if that's on their diagram or if that's what I was told at the scene, but yes.
Sure.
Yes.
You knew that a cup was found.
Yes.
You were told a cup was found.
Yes.
And 3 pieces of plastic, 2 red, 1 clear.
Yes.
Not 5 pieces of plastic, correct?
Correct.
You then measured those items, is that right?
I didn't, what do you mean measure them? Like
Measured
at
them
this,
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it, we're gonna go over those numbers.
yes, I used their report to place those items onto my diagram.
So, and then I'm going to get to that question in just a second. I want to make sure that we walk through it sort of methodically. You then use some calculation, some tool or something to measure distances. Like there's where I assume John O'Keefe's body was. There's a final rest place. I'm going to use that as point A, and then I'm going to measure from there and go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes.
Who told you where the pieces were found?
They were in Lieutenant Tully's report. He put measurements in his report.
Okay. And you noted that the shoe was 9 feet.
Yes.
And you put that in your diagram.
Correct.
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
Correct.
1 foot is about that long, right?
Yes, they basically said it was found next to him.
Right.
Yes.
A piece of red plastic 7 feet from John O'Keefe's body, correct?
Correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes.
And a red plastic piece 12 feet from John O'Keefe's body, correct?
Correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from, he just said he was here, so I tried to put like where his head, where his feet, and try to measure the middle between those two.
So ultimately, because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
You had no photographs of John O'Keefe in place, correct?
So once again, if something is 1 foot from a center mass or 6 inches from a center mass, or like you're not going to run simulations through a computer program and say the plastic broke in exactly this fashion and each piece was found exactly here, and face up, face down. You can't reconstruct the accident to show exactly what the spray would be, to show exactly where things go. And that's what little Alan Jackson seems to be trying to argue as, well, you don't know if it was 6 inches or 12 inches. And it's like, it's within the expected spray pattern. It's, ugh. And yes, being more exact is better than being less exact, but it's not CSI. There is variation. It's a spray pattern, a debris field, not a debris line.
Correct.
There were no establishing shots, there were no perspective shots, correct?
Correct.
There were no relative shots, meaning this is relative to that, I can measure that, and figure out distances, correct?
What, like from the picture?
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2, 3, or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure
Fuck
from there.
off.
Sure.
You get cross coordinates, right?
Sure.
Left and right, where the 2 coordinates match, that's where the item is, right?
Correct.
None of that was done, right?
From the pictures?
None of that was done to do your measurements.
Like I said, I used the measurements I measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Objection.
Did you guess?
I did not guess.
Next question.
You stated in your report that you.
And I only call him Little Alan Jackson because he wears shoe lifts. So he clearly is sensitive about it.
Google mapped Miss Reed's path of travel. Well, let me ask you a different question. If I could withdraw that question with court permission.
Yes.
Your diagram has all those arrows pointing.
Because he is. He's a prosecution witness, and this guy's the defense lawyer, so he is hostile. Of course, that doesn't mean he has to be a dick about it.
At specific locations. Very, very specific, very thin arrows that point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well.
Objection.
Is that true?
I mean, I guess hypothetically, depends on how off you want to be.
And the answer is yes, right?
Hypothetically.
You stated in your report that you Google mapped Ms. Reed's path of travel on January 29th, based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the two events, meaning the triggering events, occurred at the same time the Lexus was at 34 Fairview at the time of the collision, correct?
Yes.
The first triggering event was what? Was it
And Grey Duck, that's generally the case, but you can call a hostile witness yourself. That often happens in like domestic violence cases where the spouse, the victim, doesn't want to testify. And number one, it would have to be a girlfriend, not a wife, because spousal privilege, the wife can just invoke and not take the stand. But, you know, if it's a victim that doesn't want to testify, the prosecution can put them on the stand, and either, you know, they already know it's going to be a hostile witness, and so the judge has already agreed, yeah, you can lead, or after a whole bunch of I didn't see nothing, you'll ask the judge, can I just lead? And yeah.
3-point turn, or I thought I heard you say that.
I guess it would be more. I mean,
Well, did you say U-turn on Friday? I just want to know that.
it could have been a U-turn. I mean, it's still turning around, so you had to make a U-turn when that's a 3-point turn or not. But it's still.
Okay, but I mean, not to be picky, but it's for my job.
Okay.
A U-turn, traveling in one direction. Turn, right? Spinning the wheel, never changing gear. It's just reverse, anything, just turn, right? A 3-point turn requires moving forward, stopping.
Within that 10-second period, it wasn't a 3-point turn.
Changing gears, moving backward, stopping, changing gears, using steering input, and moving on, correct?
Correct.
Well, those are two very different maneuvers, right? You'd agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. It's a 3-point turn. They're still making a U-turn, and it's. I didn't mean it as like she literally had to make a direct U-turn. She was turning around, and obviously the diagram, or the trigger shows a 3-point turn.
Well, I mean, I guess you could have said reversing direction, right?
That would be a better way to say it. Yes.
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn?
The 3-point turn.
Okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's correct.
So when you said U-turn, that was inaccurate.
Objection, Your Honor.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? Starting point and an ending point, tell you the exact path Lexus traveled.
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map, and Trooper Proctor told you the Lexus traveled from point A to point B, there are multiple ways to get from point A to point B. You agree with that, right?
Yes.
You picked one of those, right? The path of travel including freeways, et cetera, right?
Yes.
But as you sit here, you don't know what her actual path of travel was. Because it could have been something different, right?
It could have been something. That's why I give a range on my diagram.
I mean, a DUI is a DUI is a DUI. I don't know if the dash cam, body cam is out from that yet, but that might be something I have to do just, at some point.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
I got the addresses from Trooper Proctor. I put them into the thing, and one of the possibilities of 36 miles, and that was after looking at all of them,
not
36
along,
miles is a
not along,
possibility.
not along,
Understood.
not along, because this is good stuff. Don't stop.
So that's what I'm trying to get to, Trooper Paul.
Okay.
That's one possibility. There's 36 miles,
Mhm.
one route of travel, right?
Correct.
There are other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of have to guess. And there's no science to it. You said, I'm going to pick that. You put it in my report, right?
No, that's not how that works.
Okay, why don't you tell me how that works?
Her odometer mileage on the car from the download and the time we had the vehicle shows 36 miles. So when I plugged those addresses into Google, it came up as 36 miles as a possibility.
And you knew that there was another route of travel to the same location, correct?
What do you mean?
There were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from the street's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to
He
yourself.
could have, except that's not his area of expertise. Luckily, the previous witness did testify about that, and it's not exact either, but gave a pretty good time frame of when she was where. So it's almost like it's a team of many different experts with many different specialties. This dude doesn't do cell phone data. He doesn't extract from cell phones. Not his job. We heard from that witness. We might hear from another witness about it too.
Phone extractions.
So that answers my next question. You did not even attempt to do that, did
No.
you?
Because why would he? It's not
You
his
did
job.
attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lauer, right?
Yes.
I want to be clear.
Of course, working in conjunction with the other troopers would be good if he had compared that other troop, Trooper Tully's work with the cell towers. No, it wasn't. It wasn't Tully, was it? Can't remember who it was. Either way, it would be nice if he combined his work with the other and compared and to, if not confirm, at least validate his work. And yep, how dare Trooper Paul only do his job and not everyone else's? Because, little Alan Jackson is a jack of all trades. He could have, little Alan Jackson could have extracted the cell phone location data all on his own. He wouldn't have had to consult an expert for that. But, Brad Scooter, good to see you. But the fact that this guy works with cars, not cell phones, means all the rest of his analysis is void.
For the jurors, because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle of the car doesn't have to be turned on.
Say that again.
It could go from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, well, every single.
Presumably, the auxiliary could also be part of the key cycle. Although, would a car with a start-stop button have an auxiliary? But yeah.
Ignition
Ooh.
is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned
Ooh, I'm jealous, corrosive. Keep traveling north. Go visit Durham. It's worth it.
off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
Of course, if you travel anywhere during it.
The key cycle is turning the accessories on.
All right. But it does, my question was, where we started with this conversation, is it does not have any location data on it whatsoever.
Correct.
All right. So,
Okay, so we're going on a tangent. So if you're not stopping in Durham, are you taking the train from York to Scotland? And because the train from York to Edinburgh should at the very least travel through Durham. So make sure you're on the right hand side of the train, facing forward on the train. Make sure you're on the right hand side. Pay attention when Durham is the next stop. You're going to come out of a thicket of trees, basically, onto the viaduct, and just bam, right in your face. You'll have the castle and cathedral, and it's just out of nowhere. You exit the trees onto the viaduct, and yeah, and then assuming you stop at Durham train station, you know, the view is up from the top of the hill across. But yeah, so if you can't stop, just make sure you're able to see out the right hand side of the train, because like it's just ridiculous how sudden it goes from thick trees to being on the viaduct. Not that viaduct, because, well, that one's in Scotland in the countryside. This one is a Victorian viaduct literally built through the city. And it's gorgeous.
so when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get to your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them. Key cycles.
Key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
Doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right? But if you're seeing triggering events, I'm trying to be tricky here.
Yes, you are.
Cars in motion. What does that tell you? The ignition's on or off?
The ignition's on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here. It could be in Wyoming. The car wouldn't know the difference. It's not going to report the difference to you, correct?
It can't be in Wyoming because Wyoming doesn't exist. It's a conspiracy.
The key cycle,
Right.
Just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay.
To testify on Friday that this is a copy of
I would imagine he doesn't have a lot of grace and manners or patience for service workers.
the exhibit that was put in 591. This is part of your report, correct?
Yes, it is.
And this is a chart that shows when move to this arrow. That arrow indicates top and bottom where your testing occurred, correct?
Yes.
And we move over to the left, that's key cycle what?
1164.
Right. So you've testified, and we can turn the lights on. You're all right. I don't mind if that stays up. We can turn the lights on. You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1164. Is that right?
Yes.
Okay. So what you're saying in that report is the triggering events were 1162 going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right. And you knew, when you put in your report, or you know, that the triggering events that you see.
Are you saying that little Alan Jackson likes a little Cool Whip on his desserts?
1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were 2 cycles before that.
So, if John O'Keefe was hit on key cycle 1162, 1163 would presumably, which isn't on the chart, but wasn't deemed relevant to put on the chart. 1163 would be Mr. O'Keefe driving it from John's house to his house. The key cycles wouldn't start on 1164 for testing, because the tow truck driver drove it onto the tow truck. So that would be 1164. Drove it into the Sally port. That would be 1165. So either they're missing key cycles, or the witness is being inartful and the testing key cycles include all of the key cycles within police custody. He needs to clear that up for the jury, because that could be a problem. Because does testing mean everything law enforcement did with it, or is it only what he did with it? Because if it's only what the testing he did, then there are missing key cycles, and you have to go back further to find the 29th, the 28th into the 29th. But yeah, that's it. That we know someone drove it in and out of the Sally port. We know someone drove it onto the tow truck. They didn't drag it. We saw video pulling out of Daddy Reed's driveway and up onto the tow truck. They didn't winch it up. So there have to be at least 2 key cycles in there that either they're part of the testing, or that it go. So he needs to clarify this. He needs to clarify this. And I think it's the other way around, Frank. not every key cycle is an ignition cycle, but every ignition cycle comes from a key cycle. And so you can have a key cycle without starting the car, but you can't start the car without a key cycle, is my understanding. But there wouldn't be a tow mode because, like I said, it was a flatbed tow truck and they drove it on and off. It wasn't a lift two wheels and drag it across town. It was driven onto the flatbed and driven off the flatbed. So we need clarification on what he means by these key cycles are our tests. Because if our tests includes every time law enforcement moved it, great. If not, that's a problem. Maybe not an insurmountable problem, but it's a problem.
Yes.
Meaning ignition cycles at least, right?
Yes. For that.
You report. Oh, let me finish the point. You said that the mileage difference between these two triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report. I think you mentioned Trooper Zach Clark. Is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess now a 3-point turn, right?
Fuck
Switching
off.
direction, and then
Yes.
the reverse at 24 miles per hour, correct?
Correct.
And you even went on and testified to that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. I need the text streams?
On the key cycles.
Not in grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
If your testing occurred at
Oh, and by the way, as a tangent, the judge sided with Clayton Eckert against Laura Owen. The judge agreed you cannot get pregnant from a blowjob, and so Clayton has won. Hopefully he wins fees, and hopefully she faces perjury charges. But I just thought, since people have mentioned it in the chat, not today, but in the past, thought it was worth mentioning. Clayton Eckert won.
key cycle 1164, that means you turn the engine on, the ignition on to start your testing, correct?
All right,
Correct.
did you?
And that triggering event that
I missed it. But
we see up there at 1164 initiated your testing, all right?
Yes.
All right. So that 1164 is where that's where there's no more unknowns, in other words. Like you know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were and what they reflected, because you did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis of key cycles.
Say again.
The cornerstone, in other words, the one known that is immovable, it's immutable, is 1164 began your testing.
wait, were you one of the 2 previous guys that Laura Owen did this to? Whoa.
Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right.
So
So starting in
when the car was in state custody, is that just your testing, or is that, when the car was in state custody starting in Daddy Reed's driveway?
1164 and counting backward. Before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sallyport in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't speak to the fact that we record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know, because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
Super Paul, you just said unequivocally, when a car is turned on and then turned off, there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I mean. When it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why I didn't go on, why I did not record.
Well,
And this is a problem.
let's talk about the ignition cycles.
Okay.
Before 1164. Okay.
Okay.
Obviously, the car had to get to Canton PD because you saw it there, correct?
Correct.
Assume for purposes of my question, the car was turned on and there's a video of it turning on, driving up onto a flatbed tow truck.
Yes.
That would be ignition cycle. I'm going to use your word, key cycle, ignition cycle, 1163, correct?
Again, ignition cycle, key cycles are two different things.
Which word do you want me to use?
If you want to talk about key cycles, key cycles. You want to talk about ignition cycles? It's ignition cycles when the vehicle gets turned on. A key cycle does not mean to be turned on.
But every single ignition cycle includes a key cycle. You can't have an ignition cycle without a key cycle, correct?
Well, if you want to talk about it, just use the key cycles or ignition cycles. I'm trying to make sure this gets out. I'm trying to make sure that this gets put out the correct way.
What?
Every ignition cycle includes a key cycle, correct?
In a sense,
By definition, it has to, right?
it doesn't have to. They record multiple different ways.
You can have an ignition cycle without
Well,
a key cycle.
explain how they're recorded in different ways then. How do you get an ignition cycle without a key cycle? Everyone's confused. I'm confused. I'm not liking the answers I'm getting from this witness.
I don't know how it recorded, but it could happen.
Explain that. How could that possibly happen?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so
Or the 2 seconds is not on long enough, it might not record one.
let's ignore the 2 seconds.
But pulling it on the flatbed and removing it from the flatbed wouldn't happen in 2 seconds, in under 2 seconds. There's something wrong here.
Okay.
That's not what we're doing.
Okay.
All right. Let's assume that it's an old-fashioned type of key.
But
Okay.
it's not.
Halfway on, the electricity is on. It's like it used to be called ACC.
Yes.
Right?
Yep.
That's a key cycle, correct?
For that intents and purposes, yes. This vehicle's not a key cycle, so not a thing.
Keep turning.
Okay.
And that turns the engine on, right?
It turns the engine on, correct.
An ignition cycle.
Yes. Well, then turn.
But this isn't that type of vehicle, so that's irrelevant. This is a push button start. And yeah, they definitely needed, like, this guy sucks as a witness. He does. He sucks as a witness. He may be good at analyzing things, but he sucks as a witness. I can't say I'd be a better witness. I mean, I wouldn't be testifying about this because but I can't say I'd be a good witness either. But this guy really sucks as a witness. And that could be a problem. Lally needs to know his witnesses. Like, he can't coach his witnesses. He can't tell his witnesses what to testify. But he needs to know if his witnesses suck so that he can get someone else to do the analysis and do it better. Lolly's job is to put good witnesses on the stand. This guy isn't a good witness. And yeah, he needs to do better.
Turns off.
So ignition cycle necessarily includes the precursor key cycle, correct? Even though every key cycle might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine. With that definition,
In that
we're going to talk
scenario,
about ignition.
he said, in that scenario, yes. Except that's not what this Lexus is, because this Lexus doesn't have a key start. It has a push button start. So it's different.
Ignition cycles, because I don't want to get confused about accessories. Just assume the engine.
Okay.
turns on, right?
Okay.
If you started your testing at 1164, then if the engine was turned on, thereby indicating initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163 in that hypothetical, correct?
It could be.
Okay. Then going backward from there, if the SUV was, I'm sorry, let me add one event that I just forgot. It had to get off the tow truck in Canton and be driven into the Sally Port. Did you ever see that video?
No.
Being driven in?
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be a key cycle, correct?
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto the flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going back.
It's possible.
All right. Before that, if the car was started and the car was driven from One Meadows Avenue.
From where I stand at the moment, Alpha, Lolly needs to do a hell of a redirect. Because, like, even before Jackson got into it, as soon as he put it on the screen, I was like, there's key cycles missing unless the 1164 where they're starting doesn't just mean testing, but everything in law enforcement possession. So unless those include driving on and off the tow truck, there's a problem. So, of course, if Lolly can clarify that, yeah, those are included in that, great. Maybe, if he has any credibility left. But this hasn't been good for the prosecution. Of course, there's still a hell of a lot of evidence. You know, taillight fragments under the snow. There's and that's one of the questions. I don't know that I said it out loud, but that's one of the things I was thinking is, would a key cycle only record if there's a trigger, and if driving it on and off a flatbed wouldn't have a trigger to make it record a key cycle? Except to me that's dumb, because why wouldn't you number the key cycles that happen in between, even if you don't record the data from them? There's problems. There's problems. I'm not saying these problems completely sink the prosecution's case, but they absolutely don't help. They absolutely don't help. So, and that's why, get a better expert. Lolly needs to know his experts. He needs to know his witnesses. It's like Jackson and Giannetti have tried to paint it as suspicious if any witness prep was done, but it's not suspicious. It's completely normal. The defense has prepped their witnesses too. Every good lawyer preps their witnesses. And once again, prepping your witness isn't telling them how to answer, but telling them what to expect. Have a conversation with them. If, like, it could even be, ask, which trials have you testified in before with the troopers? And then go and ask the DAs that have tried those cases, how is this guy on cross? Oh, he really sucks. A good defense attorney would eat him alive. Oh, maybe I should get a better expert then. And that's on Lolly. That's on Lolly. And the thing is, like I said it before you came in, Alpha, you don't replicate your efforts if you don't have to, because taxpayers really don't like you paying for something twice. But paying for a second expert is a lot cheaper than paying for a second trial, assuming a mistrial. So it just, and that is a good point. He apparently hasn't been certified as an expert because the judge hasn't let him read from his notes. So by that, he's a lay witness, just a state trooper. He's not an expert, as little Alan Jackson, was very gleefully gleaning from the start of his cross. So you don't have a degree in physics, do you? You don't have a degree in engineering. You don't have anything except an associate's. How dumb of you. You're not an expert at all. You're a phony. And so, but the thing is, she was letting him refresh from his notes, but the actual experts could testify from their notes on specific portions. Like, they didn't have to look down, look up, close it. Like, they could properly consult their notes. So this guy, the judge isn't treating as an expert. Lolly should have got an actual expert with degrees.
Karen Reed's parents' home in Dighton, that would be another key cycle, 1161, correct?
Very possible.
Before that, if the SUV was started and driven by Miss Reed from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Is that right?
It's possible.
And before that, if the SUV was started and driven by Miss Reed to the waterfall, from the waterfall to 34 Fairview at approximately 12:15 a.m., that would be another key cycle, 1159, right?
It's possible.
I want to be clear. The reason that these numbers skip in your diagram, they don't go directly in order, right? Every single number is in order on this left-hand column, because this is only a diagram.
I don't think he said specifically criminal justice. I'd have to rewind it, but it basically is criminal justice. But I think the second word was something else. But either way, he's not been good on cross. He's definitely not an expert. He's he's a worker drone, not yeah, administration of justice or administration of criminal justice. But either way, this has been a problem, and I saw it even before Jackson started questioning about it. Either something's missing or they let's see. Yeah, I just something's not adding up. Like 1164 to me could 1164 could be pulling it onto the flatbed, but then 1165 isn't. 1166 is missing. 1167 it just it is testing. So it's just not adding up to me.
When triggering events occur, right?
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 1159, driving over to 34 Fairview from the waterfall. Then driving at 5:07 in the morning over to Jim Cave's house, 1160. Then driving to Dayton, her parents' house, 1161. Then the car being seized
I saw
in
it.
Dayton by Trooper Proctor, 1162. Then the car being taken off the flatbed and driven into the Sallyport at Canton, 1163. Your testing starts at 1164. That would mean that at 1162, that key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical.
Your hypothetical?
Yes.
If that's hypothetically how it works, then yes.
Then what?
Well, I can't testify about your hypothetical because I haven't tested your hypothetical. So pound sand. But and that's it. To me, it's not making sense. A good witness might be able to make it make sense. Hopefully, Lolly on redirect makes it make sense. But based on the testimony so far, this has been really bad for the prosecution. And I mean, you know, Jackson's just used to that. He's always an ass, so he's just trying to make an ass out of someone else. But yeah. So, well, you'd only testify about the triggers you think are relevant. You're not going to start with trigger number 1 in 2021. But you should have all of the triggers within the relevant time period. And it's just he's not explaining it well. He really isn't. Like this has been bad. We'll see if Lolly's able to clarify it. And of course, as Alpha mentioned, Jackson has the full list of triggers if it's in the report. And it very well could be that we're just missing something, and Jackson knows it, but his job isn't to explain it to the jury. His job is to confuse the jury, because confusion is doubt. Like, it is. So Jackson having the full clear report, if he can create doubt out of it, that's what he wants to do. That's and that's it. To me, the one report, the one key cycle, the 1164, could be consistent with pulling it out of the snow-covered driveway in reverse, and then pulling it forward onto the tow truck, and then putting it in reverse and turning it off. Because in some cars, some modern cars, I believe, you basically reverse is the park gear. I think. I don't know. But it and that, well, we know the tow truck driver cycled at least twice, presuming those key cycles would register. Because does it take a triggering event to trigger a key cycle within the computer's memory? Does it, if it only records key cycles where there's a triggering event, are the non-recorded key cycles still, contained within the numbers? And then so there's a triggering event in key cycle 1163, no key cycles or no triggering events the next 4, and then 1167 the next triggering event. So is that labeled 1167 or 1164? I don't know. And it just, he needs to explain it. And that's it, Ryan. I came into this not buying the conspiracy one bit. I still don't. I said day one, my gut instinct is DUI, manslaughter, but I can be convinced either way. And I said day one, I don't like her because I don't like the smear campaign she's used against the witnesses. So the way you get to second degree is, the comments, Karen was just a babysitter with benefits. Maya or Bella or whatever the daughter's name, I can't remember, but the mom was the real love of his life. Comment by Carrie Roberts, as testified by Jen McCabe, and that house being used as a landmark, to me, that could have started the fight, and it was an ongoing fight since Aruba. So there's that. There's if she knew she hit him and drove off, leaving him to die, failure to render aid, that could elevate it to second degree. Driving past 34 Fairview to look for him, seeing him, and then driving to Jen McCabe's at 5:07. Well, having left the O'Keefe residence at 5:07, but driving by 34 Fairview, taking the detour that, it's not definitive, but the cell data indicates that it's a possibility. And that explains how when no one else, Carrie and Jen didn't see John. Carrie and Jen didn't see John. Karen knew where he was from the back middle seat, and in the snow, he's covered in snow, so she drove by already and failed to render aid, failed to stop. There, it gets me closer to saying second degree. But if I think there's fuckery, like, I still think there's evidence that she hit him, even if they're assuming the wrong key cycle. But, assuming the wrong key cycle would be a problem. Like, what else was sloppy? What else was sloppy? So, and the thing is, like, to me, even discounting any other evidence from this witness, just say, you know what? I don't believe anything else he said. The analysis wasn't good. Just focusing on the key cycles could have been enough. But if we don't trust the key cycles, what else do we not trust? And because really, to me, finding a piece of the plastic at the fire hydrant, as Vince pointed out, that wasn't found day one, that piece. So the snowplow went by, clearing the rest of the street. That could have been in the debris field from the snowplow, pushing it south toward the fire hydrant. Like, that hasn't been testified to, but it's possible. But it's also, Jackson was trying to nail down, oh, well, the debris would only spray in a straight line, but it's a field, it fans out, and that makes sense. Like, there are multiple ways you can end up with that plastic taillight fragment at the fire hydrant. Now, the glass on the bumper, that's a question I don't know the answer to, but there's a lot of good evidence, but unfortunately, the jury can say, you know what, there's a lot of good evidence, but this bit of evidence was so bad that we don't believe any of it. So, Lolly really needs to rehabilitate this witness on redirect. And as I said, this was yesterday, but I haven't watched it, so I don't know if he manages. And no spoilers. So, and Vince is correct. Murder 2 is the charge. Murder 1 isn't. So it doesn't have to be premeditated, but still you have to show intent for murder 2. And, the jealous bitch angle could be the intent. She got mad. They argued. It all happened spur of the moment. But that's enough for murder 2. But you still have to prove it.
That's hypothetically how it works, then yes.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
Yeah?
Yes.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You have that in mind?
Yep.
May I approach?
Yes.
You were asked, does that remind you that you were asked by a grand jury if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that to figure out if you say if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, striking vehicle, and stuff. Remember saying that?
And the mass of the vehicle, the mass of what is struck, and any velocity off of the mass that is struck. So if Johnny's running at the vehicle as it's backing into him, that would, increase the relative velocity of, So there's a lot that goes into it and stuff. The whole unladen velocity of a swallow, African or European.
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would be based on miles per hour and stuff. Did you ever do any stuff to test that? That's the grand jury's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
Linux guy, it's not abnormal. It just depends. And, this judge not wanting speaking objections, it's expected.
Meet the role we.
Well, John O'Keefe's weight, right?
What's that?
John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Okay. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified, again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff. In quote, correct?
Yes.
What's that word again?
Fuck off.
It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle formula, Searle throw formula.
What formula?
Searle.
What does that mean?
It's a type of formula that we use for a calculation of post-impact
So
speeds for pedestrians.
that includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
There would be physics calculations that would be required to figure out how far a body at rest would move having been struck by an object in motion.
Right.
That's a basic principle.
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to
Alpha, my brother had that same thing. He was riding down the hill here in the city, and old lady turns in front of him. So my brother struck the side of her car. So he hit her, but he was probably traveling 25, 30 miles an hour because it's a steep hill, and went over her windshield and skidded and got a lot of road rash. It was not pretty. Of course. So my cousin's husband actually late last week was in a motorcycle accident. Wasn't paying attention, so he ran into the back of a stopped vehicle at 45 miles an hour, and lots of broken bones on that, like pelvis, ankle, wrist. Just, yeah, be careful on bikes and motorcycles, and physics isn't your friend in those situations.
Determine how far a body at rest would travel, having been struck by an object in motion.
So in this scenario, in this collision, it's more of a side swipe. So he did not sustain, he did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset from the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, he would have been able to get more.
So basically, he's trying to say, because he was struck by the corner, you can't calculate what portion of the momentum would transfer to John, because a lot of it was directed to the side, and that's not a direct calculation if you're having to estimate the angle of impact as well. So, but he's not explaining it very well.
More closely to the actual speed of the vehicle during that post-impact travels.
Well, that presumes a couple of things, Paul. That presumes that he was quote unquote sideswiped, right?
Presumed?
Presumed by you. You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
Based on the evidence, fuck you.
The principles of physics as we know them today, in modern mathematics, is thwarted by a sideswipe.
Objection.
Is that what you're saying?
It's the calculations that are out there. You can get a speed, it will just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is.
I mean, there are two objects here. Ask better questions, Jackson. The object, did John have a speed? There are two objects in a collision.
Not speed, momentum. There's a difference.
Okay.
Right? Do you agree with that?
No.
You wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, now in that sense, are we talking about trying to find the speed of the vehicle? That's usually what we're trying to do.
Right. Okay. Well, let's put the speed of the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Argumentative.
To calculate momentum, there's a singular.
So sustained.
Argumentative.
Isn't it true, Paul, that there is a singular calculation for determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow
Fuck
magically
off.
out of the realm of physics?
Objection.
Sustained.
Is a pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes.
Got it. Where'd you learn that?
It's in my math class. We don't use momentum for vehicle to vehicle.
Math class?
The math, the crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum?
And you'll notice when he's trying to answer, Jackson keeps interrupting to throw him off more. Let him answer the damn question.
Calculating these data.
Do I need to calculate the conservation of momentum?
Conservation of momentum.
Yes.
You know what that is? There's an equation for that as well, right?
Yes.
You know what that is?
Not off the top of my head, but yes.
Based on the basic principles of physics.
Once again, he's not in a physics class. In the real world, we keep the equation next to us and refer to it so that we get it right. You rely on your memory, you get things wrong. Like, you know, I'm pretty familiar with the rules of bankruptcy. I still refer to the rules of bankruptcy. And I use the rules of bankruptcy as an example since I had it right next to me. But rules of civil procedure, you've seen. I know Rule 12b-6 very well. I'm still going to, if I'm citing to it, verify that I'm citing it exactly, because I don't want to look like a fool. I don't want to get it wrong. So when you're dealing with physics equations, especially if you're in a job where you have to deal with multiple physics equations, even if they're like the most fundamental equations in physics, like the law of conservation of momentum or law of, you know, whatever. I'm not a physicist at all. But you're still going to refer to the equation. And especially you get up on the witness stand where you're nervous and ask, tell me the equation, you're going to forget. And yeah, put any lawyer on the stand as an expert witness. Ask them about the rule against perpetuities. That, you know, it's, you know, any interest in property must, you know, any future interest in property must vest within 21 years of the, you know, target lifespan, something. You, like, other than studying for the bar, no one memorizes the rule against perpetuities because it sucks and it's real hard to explain and understand, and it would be absolutely hilarious to see little Alan Jackson on the stand trying to recite the rule against perpetuities and then explain it so that a jury could understand it with a jackass like little Alan Jackson interrupting him every 3 words. That would be entertainment. How close was I, Alpha, on the rule against perpetuities? You learned it a lot more recently than I did. So, luckily, it's, you know, how often is it going to come up in your legal practice, Alpha? Never.
Is the total momentum of the collision greater or less than the total momentum after the collision? Total momentum.
I say never, but if you go into trust in the state's law, like, it's not going to come up, but you're going to have to be aware of it.
Collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Paul, they're exactly equal in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's
Yes.
transferred from one body to another.
Yes.
correct?
Correct.
Why didn't you say that to the jurors?
Objection, Your Honor.
Sustained.
Hey, I was close. The common law definition is that if an interest in real property, I said if a future interest, which, you know, doesn't, if an interest in real property does not vest within 21 years of life in being at the creation of the interest, then that interest in land is not good. And so I said life and interest, not life and interest at the time of, because, you know, hypothetical future interest, you know, lives, you can't take them into account. So I was close. I was close. And that's it. That they've abolished the common law. There's still going to be something about rule against perpetuities in most states, because, you know, the law wants finality, and you're going to have something, but it's not going to, in most situations, it's not the common law rule against perpetuities. You know, funny enough, I've wanted to make a video about Downton Abbey and how the entire plot line of Downton Abbey is pretty much pointless, because by the time any of it mattered, the entail laws had changed in England. So, you know, the daughters could have inherited the estate anyway, and bringing the cousin Matthew in, it's like, well, he's just the heir presumptive at the time, regardless of who Mary married. If she had a son, if any of the daughters had a son, that son would be the heir ahead of Matthew as the grandson of Lord Grantham. And so, like, the entire plot line was pointless. And so, but the thing is, the title would pass to the next male heir, which, like I said, would be the grandson. So when because Mary and Matthew's child was a son anyway, so as soon as he was born, like, even if Matthew hadn't died that same day, the son would have been the heir. He would have inherited the title, he would have inherited the estate, but by that time, the entail laws had changed, so Mary could have inherited the estate. It's just her son would have inherited the title. Matthew never would have inherited anything. So, yeah. And I know all of you understood all of that, but not really, because it's all complicated. But just the same, Downton Abbey, the plot doesn't make any sense if you understand the law and legal history.
Trooper Paul, if you were qualified to, quote, look into all this stuff, you would probably know these answers, wouldn't you?
Objection.
Sustained. Are there any other calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
I would, but Trooper Paul, it races over his words, so that's why I have him at 1 1/4.
Calculating the final velocity of the objects after the collision. That be important?
What objects?
That would be John O'Keefe's body, sir.
The
Object
Well-
that you claim was flying through.
That would be John O'Keefe's body, sir. There's multiple objects that went flying. The tail light fragments are objects that went flying. The glass, drinking glass, is an object that went flying. When you say object, you can't get pissy when he asks which object. Multiple objects went flying.
The air 30 feet.
objection.
Sustained.
How about calculating the displacement using kinematic equations? you be able to do that?
The
Displacement,
displacement
of
of the
what?
body.
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic equations?
So like I said before, the side swipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You couldn't hit a person and side swipe and spin them off to the side and have that and get a speed from those calculations.
So you're saying that the
It's
discipline of
garbage in,
physics
garbage out.
cannot figure out how far John O'Keefe's body would move. But you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
Sorry?
Sustained.
Are you saying that the principles of physics are
Argumentative.
incapable of determining with the proper calculations
Argumentative.
how far John O'Keefe's body
Argumentative.
would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No.
Okay, next question.
Well, you just said because it was a sideswipe, all these
Argumentative.
calculations are inapplicable, right?
I'm saying it would underestimate the speed and the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally,
Argumentative.
have you?
Yes.
You have been,
It's incorporated into the classes.
right? You have a few classes that use the word physics, but you haven't been formally trained in physics, have you?
Objection.
Argumentative.
You haven't been formally trained in kinematics, correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated ignition cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson, ask the appropriate part of the question, and you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm on a hinge? Was it in front of him? You did the reconstruction?
It looked-
Here's exactly how his body was positioned when he was struck by that.
So it looks like his arm is more kind of like this. If I can try it then.
You're indicating out by his side, correct?
Yes.
All right. And the taillight would have struck his arm, right?
Yes.
Not his torso.
Yes.
Okay. So the full mass, the full weight of that truck hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
But I said it from upper part of the arm
Right.
down.
That
Yeah.
elbow and the biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So his torso,
it's not saying it could not have been a possibility, but I just didn't see anything.
so his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder, yes.
Okay. And you said he then did a spin, like a sort of a pirouette.
He got spun around possibly the way he struck, it looked like it could have turned around counterclockwise.
Okay. So if he turns around counterclockwise, is he turning around in the air counterclockwise?
Yes, initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearms
Yes,
by an unbroken taillight, right?
yes,
In other words, it's nice and smooth. No shards of plastic or anything broken at the time that it made contact with his arm, right?
correct.
Okay, so how did his arm get all cut up?
Because when his arm struck the taillight didn't correct. And I see the car driving.
Wait, you're telling me that a taillight braking on him would cut him? Shock. And once again, if it hits him at an angle, there's dimples, the taillight rubbing across those dimples would create linear tears in his arm.
Past him, the taillight could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that you see, those lacerations, those abrasions, that you see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
Yeah, he was flying through the air 30 feet at the exact time he was struck. No, it all happened in a sequence. It was very fast, but it was a sequence.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
his
hinge.
shoulder?
Okay.
Okay, so arm got hit.
I mean, he said shoulder, but he was indicating the elbow, and it, like his arm being on a hinge. So you get hit, it pushes the arm into the torso. So it being a hinge, according to you know, anatomical genius little Alan Jackson, you know, a ball and socket joint is a hinge apparently, but it being a hinge, it hinges down into the body on impact with the dimples, the ripples, the bumps on the taillight passing across the arm as it's pushed into the body, because the truck keeps moving, it's not stationary, runs across the body, and he's thrown. Like, this makes sense. He's not explaining it well, but it makes sense.
His arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper
Okay.
point to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
the other one that talked about his injuries on his arm,
yes.
that's limited to about mid biceps, about mid forearm, correct?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So you're
And so it struck him mid upper arm, mid humerus. But
the theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to.
and once again, why, like, it doesn't necessarily have to injure the shoulder, because like if the mechanism for injuring your shoulder is generally up and out. That's how you dislocate your shoulder. And that's specifically talking about the shoulder joint, what's it called? It's where the scapula and humerus come together. I'm just trying to think there's a more specific name for it that I'm sure Alpha is going to tell me, and I'm going to feel really dumb because it's going to be the specific part of the scapula that the socket of the ball and socket is. But the mechanism for dislocating that is up and out. It's rotational. Whereas the AC joint, the separating your shoulder as opposed to dislocating your shoulder, is going to be like if you land on your hands and it pushes you back, is going to be one mechanism, a couple of others. But the thing is, your shoulder, while your arm getting pushed into your body, it's going to injure the point of impact. It's not going to dislocate your shoulder. It's not going to necessarily separate your shoulder. Your shoulder could be completely fine so long as you don't land on it wrong.
Explode, basically, to shatter. And these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Who says he
Yeah,
flew
have to
30
probably go
feet
faster
in
than
the
that, though.
air? He said he traveled
But
30
you said he hit his
feet.
head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around kind of clockwise. It's a possibility that the curb is there. Any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, you flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. You got projected.
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever that part of the crash would happen. Projecting is just what we call what happens to a pedestrian post impact with a crash.
Okay, so a couple questions. If his arm, elbow, took the brunt of that entire impact, how do you account for the fact that he didn't suffer a broken bone?
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for
That's the one, Alpha.
the fact that he didn't even have a bruise on the arm?
Objection.
That's sustained.
Fair approach.
Yes.
You account for it that it was fucking cold outside. And number two, he's not a medical examiner. Like, how do you account for it? He didn't have bruises? Are you now assuming that he has a medical degree? Are you now assuming that even though he doesn't have sufficient physics knowledge for your liking, kinematics knowledge for your liking, that he has medical knowledge to testify about how bruises form? That's outside his limited field of expertise. He can't testify about that. You twerp. And he knows that too. He knows that this witness can't testify about that because it would just be speculation. Just pure and simple, it would be speculation. He cannot speak about how injuries occur, the processes by which injuries occur. He can't speak about bruising. He's not the medical examiner. Well, in this case, Lolly finally did stand up and object. But and as I've said, I do think the state should have got a better witness. Get someone at least with a bachelor's degree that has done more than a weekend class.
May I inquire, Your Honor?
Yes.
The truth is, Paul, having investigated auto pedestrian accidents in the past, that John O'Keefe's injuries do not look anything like an automobile pedestrian accident.
Fuck off.
Yes, I do.
Isn't it true, Trooper Paul, you came to these opinions and conclusions because Trooper Proctor told you to come to these opinions and conclusions in furtherance of his investigation?
That is not true.
That's why you have these opinions and conclusions that just don't make sense, correct?
That is not true.
And you're just trying to fit a square peg into a round hole.
Objection.
Argumentative.
All right, juries will take the morning.
And once again, ending on an inappropriate statement, she needs to bench slap him. She needs to sanction him. Admonishing him in front of the jury hasn't done anything. His behavior isn't going to change if you don't discipline him.
Recess.
All rise for the court, please.
And I'll see counsel at sidebar about scheduling.
and that's it. The thing is, he's been a terrible witness, at least on cross. He was terrible, and you'll see the moment the jury leaves the room. Oh, they're gone. They're gone. So I guess after break, we'll see if Lolly is able to fix that. I have my doubts. I just, of course, I say I have my doubts because me sitting here, I'm like, how the hell do you fix that? But, you know, Lolly, as the prosecutor, is in possession of the reports, and it could be as simple as, you know, what makes a key cycle register? Is it the triggering event? Yes. Okay, so would you expect a triggering event on, you know, pulling it onto a flatbed trailer? No. And so would there be a key cycle number associated with that? No. And, you know, with the report in hand, if it's that straightforward, you know, it should be easy rehab when you're not trying to confuse him like Jackson was. But I'm sitting here doubtful that he'll be able to, but we'll see. We'll see. Let's zoom to right there.
Okay, you see the close back session.
I guess BB Jackson doing pirouettes, he's if his shoe lifts are high enough, you know, he could be close to on point at all times. So and that's where Lolly comes in, Vince. It's up to Lolly to be intuitive and spontaneous enough to know how to guide this witness into rehabilitating on redirect.
All right, Mr. Lally, whenever you're ready.
Now, with regard to your testimony, as far as that's triggering event, well, the two events on 12,629B, you testified that that was consistent with pedestrian collision. Is that correct?
That's correct.
And if you could tell the jury, why is that consistent with pedestrian?
The one specifically with the speeds and everything that we're referring to.
22 miles per hour in reverse.
Right. Okay. Yeah. So why I think that's consistent with a pedestrian strike is because the sudden change in the speed, it drops down by 0.5 mile per hour. The accelerator pedal is staying constant at the same percentage, and the steering wheel angle also turns to the right.
Now, your overall opinion is based on what you did as far as your construction, correct?
Yes.
Other information that you had at your disposal in formulating your opinion?
Like from other reports and stuff?
Yes.
Yes.
And that would include physical evidence, is that correct?
Correct.
And that would include witness statements, correct?
Sustained as to form.
What, if anything else, would that include?
the roadway evidence, witness statements.
In witness statements, would that also include statements of the defendant?
Correct.
Are you aware that the defendant indicated in a statement to troopers that she conducted a three-point turn in the area of 34 Fairview Road?
I'm going to allow that question.
Yes.
And what you observed in that triggering event is that from that mileage, is that consistent with the defendant's own statement?
Yes, it is.
Now, let me ask you a little bit, if you could, again, for the jury, clarify the difference between what you termed as an area of impact versus a point of impact.
Yes, an area impact is broader. It's a bigger area. Point of impact would mean something as obviously right there. That would be the area impact.
If I could ask, the cell phone that was located under Mr. O'Keefe's body, that location, is that also consistent with the linear path that you were testifying about earlier?
Yes, it was.
And do you know whether or not that cell phone was in his hand or in his back pocket or somewhere else?
The witness needs to slow down. Remember, we are at 1 1/4 speed, but he's still flying. So
I do not know.
Now, as far as the, let me ask you this. You were shown some photographs of some taillight pieces near a fire, correct?
Yes.
As far as the area of impact, that was, from what you determined, that was Mr. O'Keefe's sneaker, is that correct?
Yeah, it was within that. What I've had for no initial evidence, I said the area impact was the start of that in that area prior to the sneaker. Sorry, someone. So what I was saying was the area impact was prior to the area the sneaker was. It was in that path, just prior to that area.
And why did you determine that it was in that area?
Because that is the first point of evidence.
And first, I'm sorry, this first point of evidence in relation to what and sort of how the evidence was configured as it was evidence.
That was pointed to me as the first point of evidence away from, for the first evidence at that time that knew away from the pedestrian.
May I approach the witness, Your Honor?
Yes.
And so I'm showing you what's been marked as Exhibit 58. Do you recognize what's depicted in that photograph?
Yes.
And Your Honor, with court's permission, if I publish out the jury.
Okay, what exhibit number is it?
58.
Thank you.
And Trooper Paul, do you recognize what's up on the screen?
Yes, I do.
What do you recognize that?
There's 34 Fairview to the left side, and there's the fire hydrant.
And as far as these photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
Objection.
Is the objection sustained?
Now, Trooper, if you could, using the laser pointer, I know you've done this on the diagram, but if you could use the laser pointer with regard to what's on the screen as Exhibit 58, direct the jury's attention to where you believe the area of impact to be between the defendant's Lexus and Mr. O'Keefe.
It's probably somewhere out here.
And as far as that linear path that you were talking about from the area of impact, where did that go from and where did that go?
So from, I think it's from like this way.
Okay, let's go in here and take that time. May I approach this for tree count?
would you expect that the debris to go in a straight line or to fan out?
Now, Trooper, if you could explain to the jury as far as what you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of impact between himself and the SUV to the point where he comes to final rest on the wall.
Yes, so he was struck along the right side in the area of his arm, and then he was post-impact with the Lexus. He rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time. Is that correct?
Objection.
Sustained. Watch the form, Mr. Lally.
Yes. So as far as anything in your testimony about Mr. O'Keefe's actions, does that involve a pirouette?
No.
The rotation, is that correct?
Correct.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
I don't have any evidence that he had flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience, based on this collision, are you able to determine how far Mr. O'Keefe was traveled in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the speed of the vehicle.
Let me ask you a little bit about, you're talking about the Searle pedestrian throw formula, correct?
Correct.
And that's something developed in the course of physics specific to reconstruction by someone named Dr. Searle, correct?
Correct.
And that's SEARLE, is that correct?
That is correct.
And with respect to Dr. Searle's formula, why is that inapplicable in side swipe collision versus some other type?
Because it takes in, it's looking for more, not so much the formula, it's how much projection efficiency that would occur, how much percentage of the speed of the striking vehicle would have happened. In order for the formula to work, the more of the body would have struck the vehicle, the more efficient the outcome would be in the speed.
In the center of mass that you were talking about, sort of in the collision sequence.
It's how is the force transferred? If it's a glancing blow off the side, the force transferred is less than if it's a direct hit center mass.
What, if any, role does that play in regard to your ability to do that calculation?
It would just, like I said, it would underestimate the speed of striking vehicle due to the center mass not within the rear of the vehicle.
And not to twist your words or anything, but as far as when you say underestimate, that would not be an accurate reflection of the defendant's vehicle speed, correct?
Correct.
They're not going to cast a child actor. They're going to cast Kirk Cameron, but have him walk around on his knees, like when Gary Oldman played a midget. So I think that's what it'll be, because I think the only actor I can think of that has somewhat similar features, because let's say the normal person has a 4-head, Alan Jackson has a 5-head, Kirk Cameron a 5.5 or maybe even a 6-head, and he's just as insufferable as little Alan Jackson. So for the made-for-TV movie, I think Kirk Cameron walking on his knees would play little Alan Jackson.
You asked some questions about the glass and indicated that there are a number of reasons why the glass would travel with him, being Mr. O'Keefe. Can you explain what those are?
Yeah, the glass could have struck the vehicle also in that same way. It could have still been attached to his hand and still gone with him in the same way. It could have been attached to his body in midair. That's the multiple ways that the glass would have stayed with him.
Now, and speaking of collision sequences, particularly collisions involving multiple vehicles, vehicles are fixed with bumpers, correct?
Correct.
What's the purpose of a bumper on a vehicle?
To help absorb the
Scope,
Yes, yeah.
sustained.
Your Honor, if I may, I don't believe it is.
So why don't we come to second?
Well, that is a good point. I mean, trying to think of Ray Comfort. Maybe Ray Comfort produces the movie and casts Kirk Cameron. Yeah. Oh! Kevin Spacey as Alan Jackson, produced by Harvey Weinstein, using music from Phil Spector's catalog. I like the way you think, Alpha. That.
So I'm sorry, if I could ask you, what is the purpose of a bumper on a vehicle?
It's there to help absorb energy from a collision.
And with reference to the scratches that you were asked about on the vehicle on the, sort of the right rear quarter panel, what, if any, relationship does?
That's a good point, Kova. Tom Cruise probably gets his shoe lifts from the same place as Little Alan Jackson. So, yeah.
Bumpers or their interaction have, what's your opinion as it relates to that?
Sorry, say it again.
Back to what you just testified about bumpers, you were
Yes.
also asked some questions about scratches on the right rear quarter panel of the vehicle, correct?
Correct.
And what, if any, relationship does the bumpers on the vehicle and sort of their intended purpose have with relation to the scratches that you observed?
So the bumpers on the side was more of this wasn't more of a drag-on hit with the bumper. It was more of the side scraping of the paint of the bumper.
Now, the presence of Mr. O'Keefe's DNA on the taillight, is that consistent with a pedestrian collision?
Yes.
Now, as far as the glass not matching, are you aware that the lab's actual findings were that the glass on the bumper and the glass on the roadway was just inconsistent? I'm sorry, not found to be consistent with each other. Is that your understanding? If you know.
I don't know.
And were you also aware that the lab's finding was that the glass on the bumper was consistent with the glass on the road?
I'm not sure what the lab said.
Now, in order to construct your diagrams, your testimony, I believe, was that you had used cert diagrams in the process of that. Is that correct?
Yes.
And that's a good point, Grey Duck. And I would like to advocate for bringing back bumpers. I think cars got uglier when the plastic bumper cover incorporated the bumper into the body. Like having a nice chrome bumper adds something to the car. It adds visual interest. So bring bumpers back. But not necessarily on all cars, because some cars don't need it, but like most, it's just ugly without them. And that is true. They are safer, but they're uglier. They're uglier. So.
And
bring back
like
designers.
Back to that 12629B, the mileage from the tech stream data.
Yes.
The 3-point turn that you observed and the 24.2 mile per hour straight line for approximately 62 feet. How far apart time-wise within that particular triggering event were those two incidents?
8 minutes.
And as far as any of the other tech stream data that you observed, was there any other triggering event that included a 3-point turn?
No.
Now, as far as the defendant's path of travel, is it your understanding that that was obtained from a multitude of different witnesses?
Yes.
Now, with reference to, you were asking questions about the defendant's cell phone, as far as GPS locations, were you aware that the defendant's cell phone wasn't able to be accessed until?
Casey, I don't know that I have in person. Like, I know that a lot of cars are sold in England now. I don't know that they were when I lived there. I have seen them on Top Gear. And they're not overly gorgeous. Frankly, if cars just didn't look the same, I'd be happy. Of course, the car that looks the most different is the Wank Panzer, and I saw 2 on Saturday, and they are hideous.
By law enforcement until 2023.
Sustained.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
I'll allow that.
I was not aware.
Now, as far as placing the vehicle during that triggering event, 12629B, did you use key cycles to put it back at that location at that time?
No, I didn't.
What did you use?
I looked at the odometer mileage
And why would you look at the odometer mileage over the key cycles?
because I can physically see the odometer mileage at the vehicle at the time of my inspection.
And why would, well, let me ask you this. In your opinion, as far as
The Wank Panzer is uglier. Of course, I saw an opinion piece today saying the Wank Panzer is the new Pontiac Aztec, so
that is concerned, sort of backtracking to a specific location, which is more reliable, the odometer or the key cycles?
I would say the odometer mileage.
And why is that?
Like I said, you can physically see it when you turn the car, and I know that's the odometer mileage that it's reading on the dashboard.
And every key cycle, is that necessarily recorded within the tech stream data?
No,
And why not so?
it only records stuff that related to the triggers.
the Cybertruck. I call it the Wank Panzer. I think everyone should call it the Wank Panzer.
They don't what?
They only record stuff that is related to the triggers.
Okay, thank you.
As far as council's hypothetical with regard to the key cycles, is it your opinion that that hypothetical is accurate or inaccurate?
Inaccurate.
And why so?
Because it also you also add the odometer mileage onto the key cycle. So those key cycles and odometer mileage are on the same trigger. And plus the data seems consistent with everything else that's going on with this collision.
Now, fair to say that you were not outside of 34 Fairview Road on January 29th, sometime around 12:20 to 12:30 a.m. Is that correct?
That's correct.
And so fair to say that you don't know exactly how Mr. O'Keefe and or Glass or anything that tolling interacted with the defendant's vehicle at that time?
Objection.
I'll allow it. Is that true?
I do not.
And so based on your training and experience and the number of pedestrian crashes that you've investigated, again, if you could, one last time, just describe to the jury how you believe the vehicle interacted with Mr. O'Keefe and why.
Objection.
Sustained. Asked to answer.
With reference to what you've described as far as the interaction between Mr. O'Keefe and the vehicle, why is that your opinion?
Objection.
I'll allow that.
Based on the evidence from the vehicle, based on the injuries to John O'Keefe, the tail light appears to be broken and it's sharp plastic pieces that could have ripped his arm, and also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top, smashing on the vehicle, and a hand smashing the vehicle. You can see there's a line between scratches and a dent there.
Just Romeo.
So I did like the questioning about the mileage, because you back through the mileage and it's like, well, that's the trip. I still have a hard time with the key cycles though. So I think the redirect helped, but overall I still think this was a poor witness.
Very briefly, I just want to make sure I clear something up about the key cycles. You're not suggesting that every key cycle in the history of the car is on this page, right?
That's correct.
I'm pulling up exhibit 590.
Okay.
That indicates key cycles that have triggering events, correct?
Yes.
Triggering events are something that the manufacturer includes, basically a list of items that will be a triggering event, correct?
Yes.
It's a list of items basically for mechanics to figure out if there's some unusual driving or unusual event with the vehicle, correct?
Yes.
But the key cycles go in order, in numerical, 1 through whatever.
Correct.
And the hypothetical that I gave you on cross-examination, with those driving incidents, each one of those would represent a key cycle, correct?
So in your hypothetical, I mean, assume that it should create a key cycle, but that you can't just say that key cycle is from that, because I didn't just use key cycles, I used the odometer mileage on top of it. So you have to have key cycle and odometer.
Right. Interestingly, though, when you testified on direct examination, you said your analysis, this was on Friday, before the weekend. By the way, over the weekend, did you watch anything on YouTube or any social media?
No.
Nothing.
No.
No. Did you have any conversations with Mr. Lally about these key cycles and problems?
No.
Did you have any conversations with anybody about the issues with the key cycles?
No.
Did you realize at some point between Friday and today that I was probably going to ask you some questions about key cycles?
Objection.
Did you realize that yourself?
I assumed you were going to ask me loads of information.
So on Friday, you didn't mention that your analysis was based on mileage, did you?
Objection.
Sustained.
On Friday, did you mention that your analysis was predicated on mileage?
Objection.
I'll see you at sidebar.
I mean, this isn't the last witness for the prosecution, so. Or are you saying they just shouldn't have taken anyone after the next witness? But yeah. Looks like they're going into a break after this. So, and that's it. I'd say, hey, I can't speak to your hypothetical. I don't know. I would have to run the analysis. You know, have your expert take care of the hypothetical.
May I inquire?
Yes.
Paul, on Friday, you indicated pretty clearly that your analysis was based on the key cycles, starting at 1164 when you started your testing, and 1162, which was the key cycle you claimed on Friday was at 34 Fairview.
It wasn't based on it. That's how I describe it. I said key cycles. I based it on they were close within proximity to each other, but I've always said it's key cycles and odometer mileage plus all the information within the triggers themselves. So it wasn't just one of the other.
And you said on Friday that once you started your testing at 1164, it was 2 cycles earlier that had the triggering events, meaning 1162, that you claimed were 34 Fairview.
Yes.
But in the hypothetical, if there were 4
Fuck your
events or driving,
hypothetical.
or key cycle events between 1164
Fuck your hypothetical.
and 1159, it could not have occurred at 1162, correct? 34 Fairview, in my hypothetical.
In your hypothetical, if it recorded a key cycle, then your hypothetical is correct.
Right. And last question, if you got the route of travel incorrect, if your presumption of the route of travel was incorrect on that vehicle in the days earlier, then your mileage would be incorrect also, correct?
Mileage from what, the odometer or from?
The odometer reading.
The odometer reading is the odometer reading. It's 36.
My point is, your analysis that's based on the odometer reading, 36 miles here, 12 miles there, 2 miles here, 5 miles there. If you got the route of travel wrong and the route of travel was different, your assumptions about the odometer readings would be incorrect as well, correct?
So what I'm,
You got the path of travel wrong.
so what I purposely put down a range on my Google images showing, because I couldn't tell you her definitively route of path for every single way, but I know that it's possibly a possibility that she could travel 36 miles within those locations that she traveled post leaving Fairview Road.
Or if that mileage was put on at key cycle 1162.
I think he looks more like Kirk Cameron. But so funny you mentioned Andrew Scott, though. He played Moriarty in the recent Sherlock series. It's not explicitly stated in the Sherlock Holmes books where Professor Moriarty went to school, but it's generally accepted that he went to Durham University. So,
And that would mean that the vehicle would already be in Massachusetts State Police custody, right? The proctor's custody.
Objection.
So that's beyond the scope.
That's all.
All right, Mr. Lally?
Just very briefly. The range that you came up with for the defendant's path of travel, does that fit with the path of travel, the odometer reading, putting the defendant's vehicle in the area of 34 Fairview Road when it does the 3-point turn, and then 8 minutes later when it travels 24.2 miles per hour in a straight line in reverse for approximately 62 feet?
leading as hell. Leading as hell. But he doesn't care. He's just going to sit down and no further questions.
Yes.
Nothing further.
All right, you are all set.
Thank you, Your Honor.
All right, so jurors, we're going to take another short break to set up some things in the court. Okay?
All right, for the court, please.
I mean, if you want to be pedantic, though, Casey, Ireland.
Hey there, crime league trial watchers. This is another law and crime
Speaking
legal
of
alert.
five heads. Speaking of five heads, but Ireland is not part of Great Britain, but it's technically part of the British Isles. But good point. The actor is Irish, not as we'd call British. So let's zoom through the break because this is taking forever. It's a legal jump scare. So what did they get set up?
Thank you. Be seated. Close back.
And I still think the woman sitting next to Erin O'Keefe looks kind of like the actress on Peep Show that plays Big Suze.
All right, your next witness, please, Mr. Lally.
Yes, Your Honor. The Commonwealth call Mr. Ian Whiffen to the stand.
Okay.
All right, Ian Whiffen. So he's the Celebrite guy. We're into technical stuff.
And Mr. Lally, you just need to tell me when I need to give that instruction.
Yes.
An instruction about texts, maybe? Once again, I'd love to see her text with Turtle Boy. See if she uses naughty words in her texts. See if she's also, just a bad person like Trooper Proctor.
Okay.
Just raise your right hand, please. Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and
Okay.
nothing
Just based on this side view, Ian Whiffen looks like, from this side profile, he looks like Joe Ingles, who played for the Utah Jazz for a number of years. I believe last year he played for the Orlando Magic. I don't know if most of you would know who he is. He's a role player. Dante, as a fellow Utahn, from this side profile, he looks like Joe Ingles, doesn't he?
but the truth so help you God. Okay. Do you solemnly affirm that the testimony you shall give to the court in the matter now hearing shall be the truth, the whole truth, and nothing but the truth?
Okay, finally. Finally. It drives me nuts. The so help you God. It drives me nuts. Every time it's a violation of the First Amendment. Separation of church and state. Thank you, Mr. Whiffen. Thank you. Thank you.
Good morning. Good morning. Whenever you're ready, Mr. Lally.
Okay, his eyes are different though from the front. The eye and brow shape from the front aren't proper for Joe Ingles.
Good afternoon. And if it's at all helpful, that microphone before you is adjustable. You can put it in any direction you wish. Just try to keep your voice up. Okay, sir?
Thank you.
Now, sir, could you please state your name and spell your last name for the jury?
Yes, it's Ian Whiffen. So IANWHIFFIN.
And what is it that you do for work, sir?
I'm currently the coding product manager at Cellbrite.
And what is Cellbrite?
Cellbrite is one of the world leaders in mobile forensics software.
All right, so we're at 1 1/4, but he's Australian, isn't he? Casey says northern, but at 1 1/4 speed. I caught the H in his name. which is definitely a Northern English thing, but you can also get it in Australia. Okay, you say UK. Slowed it down. See if I can.
And when you say forensic software, can you explain to the jury a little bit about sort of what is forensic software and how is it used, specifically your cell book?
Yeah, so forensic software is used to gain access to people's devices, cell phones primarily, to extract that data and to allow examiners to parse and decode that data to make sense of it in a more user-friendly way so that a report can be created for investigators.
Yeah, I like he when you say Northern, he's definitely not in Geordie territory. Yorkshire, maybe heading a little west. Like some of that, I'm not a language, accent expert, but a little Lancashire accent wouldn't surprise me either from him. But sort of that area, he's definitely not Scottish. Definitely not Scottish. He's between the Midlands and Yorkshire, sort of that general area. So I mean, depending who you ask, Casey, anything north of St. Albans is the north. So he's like some of what he says just sounds a little posh. That puts me in London, but then some of it is definitely a northern accent. So it's just that somewhat indeterminate. But then, one of my close friends grew up in Middlesbrough, went to Oxford, and then Durham with me, and he insisted he had a northern accent. It's like, no, Steve, you have the poshest accent of anyone I know. And he'd just say, yeah, but when I'm with my family, it's northern. And to me, it could be he's northern but has spent enough time in London or spent enough time at Oxford that they beat the northern out of him mostly.
Now, sir, if I could ask you just a few questions going back to some of your
do you say yarp, narp, or are you West Country, Casey?
Educational and prior work experience with starting sort of with your undergraduate work, what if any, where did you go to school and what if any degree did you receive there?
Okay, I didn't get a degree. I'm originally from the UK, where I did qualifications in computing, a higher national certificate in computing, and then joined the police in 2004.
Which
and
police?
What department was that, sir?
That was response work. So South Yorkshire Police as a response officer.
And where did you go from there?
All right, so South Yorkshire, but once again, that doesn't mean he's from Yorkshire, but South Yorkshire, so Doncaster, is Doncaster South Yorkshire or West Yorkshire? Because that's where my friend is from.
In 2009, I immigrated to Canada, where I was able to continue policing with the Calgary Police Service, where I spent approximately 4 or 5 years, again, working patrol before moving to the digital forensics team of Calgary Police.
And with respect to moving to that digital forensics team, what, if any, specialized training did you receive in regard to that area?
So once I'd made it into the digital forensics, I was sent to Ottawa for 3 weeks to do a foundational computer forensics course, covering all manner of digital forensics to begin with. Throughout my 8 years with Calgary Police, I did constant courses each year to keep information updated, including a 2-week course, again, at the Canadian Police College.
So even without the degree, qualifying him as an expert.
In Ottawa, specifically about cell phone forensics. And then also during that time, additional courses for extracting data for interpreting internet artifacts or any other kind of information found on a phone or computer.
And following that, where did you go from there?
In 2020, I left Calgary Police Service and began working at Cellbrite as the senior digital intelligence expert, where I would use my knowledge of the forensic community to assist the developers with creating and maintaining a program that examiners would want to use. And finally, about 2 years ago, I moved to the decoding product manager position.
Can you explain to the jury sort of what it is, what your role is, and what is it that you do for Cellbrite?
Yep, so right now in the position I'm in, again, I use my knowledge of the digital forensics landscape in the community. I talk with users about their daily challenges, what applications are causing them problems.
See, and Kfar, to me, when I say I hear a little Lancashire in there, you know, I realize the Beatles are from Liverpool, but from what I've heard, you know, my friends from Liverpool don't sound like the Beatles. The Beatles sound like the people in Lancashire when I went to Lancashire. And so to me, I hear a little of Ringo in his voice.
What they need to get access to, what they need to understand. And I take that information, create a priority list, and then determine with our developers what we will tackle, how we will tackle it, and how it will appear to the end user.
Now, with regard to your education in this area, what, if any, certifications do you have?
No specific certifications. I've done the Cellbrite coursework since joining Cellbrite, but other than the 3-week course in Ottawa, and then
so internal training from the company that makes the software.
Again, the 2-week course in Ottawa. I don't have the SANS training or any of that kind of training certifications.
And in addition to your work with Cellbrite, what, if any, other areas of the field have you worked?
I'm sorry, could you rephrase that?
Sure. Have you given any presentations? Have you published any work in relation to this area?
Yes. So since working as an examiner, I identified that there were times that I needed to parse artifacts from applications that the main vendors didn't support. In response to that, I would do my own research. That research turned into a selection of digital forensics tools, and I created a website for myself to share that research, to share those tools with the community. And directly related to that, I have published articles related to accessing data on phones, related to SQL databases, related to various other artifacts, primarily locations.
Yeah, the thing is, you don't necessarily have to have a degree to be an expert, but it helps. The thing is, if you write a program, even if you don't have a degree, you're the expert in that program. If you work internally and develop systems at Cellbrite, you can be an expert with Cellbrite. So, well, that's basically what they're doing now, is the voir dire showing that he's an expert. And you know, I'm sure there was discussion before, but you still have to do it in front of the jury. So give me flashbacks to my evidence, Class Alpha. Come on.
Over the course of your work, have you had occasion to testify in other courts in relation to the specific field?
Yes, related to digital forensics, I've testified approximately 20 times, mainly in Canada, but also...
And were you certified as an expert when you testified? Is a question he could ask.
Once in Michigan, once in Australia, once in the UK.
Now, as far as questions that come into come into your company with relation to interpretation of data, other sort of general forensic questions. What parts of the world do these questions come in from, and how widely used is your product?
So the product is used globally. There are a select number of countries that we don't export to, but generally, if a police service is interested in digital forensics, then they're using at least some of our tools.
Not generally,
we operate
Kevin.
An email address which is open to any user called Stumpers. And the idea is that users, if they come across a artifact that they can't explain, they can email to myself and some of my colleagues, and we can research that artifact and we can.
So there's where you see the accent. I thought he said Stumpers. It was Stump Us, but he pronounced it Stump Us because that's the northern accent.
Try and give them an answer as to say why the artifact's there and how it should be interpreted.
You determined there as far as an artifact. If you could please explain to the jury sort of what your understanding of that term is and how it's used within your specific industry.
Yeah, so I would refer to an artifact as essentially any piece of data which I've recovered from the phone, which is of interest. It could be a web history visit. It could be a text message. It could be a photograph, any piece of information.
Now, sir, turning your attention to September of 2023, at some point in that month, were you contacted by the Norfolk District Attorney's Office and the State Police in regards to this case?
Eventually, yes. Initially, I was contacted by a member of Cellbrite.
And if you know why was that initial, as far as the initial contact, initial request from Cellbrite, can you speak about that?
My understanding was there was an artifact found on a device, and people were looking for an explanation as to how this particular timestamp was relevant to the case.
Now, if you could explain to the jury sort of what were you provided and what would you ask to look at?
So the original question is just basically how can we explain this 227 timestamp? I spoke to my colleague and requested if he could contact the investigators and any information that they could share about where this particular timestamp was found so that I could investigate it. I was advised at that time that the case had already been uploaded to our own support network. So the full extraction of the device in question was already in Cellbrite's possession. And I was able to access it from there and start to examine.
Once again, never give up your phone without a warrant. Just don't do it.
What the issue was that was causing the confusion.
Now, with reference to this issue, can you describe to the jury, just in general terms, sort of what this issue was?
Yeah, so the issue, as I was led to believe, is there was a timestamp for a web history artifact of 2:27 and 40 seconds AM local time, which would be UTC-5, and it didn't make sense to the investigators. And the question was, is there any other interpretation for what this timestamp could mean?
And so essentially you were asked to explain the timestamp and how it came to be, correct?
Correct.
And as far as this particular issue, has this arisen in other instances? Have you been asked the same question or similar questions in regard to this type of artifact?
Yeah, several weeks later, so probably around December time last year, I was contacted by a police investigator in Austria with a very similar question, but related to obviously a different internet search.
Come on, surely it's also about how long to die in the snow in Austria. I mean, Austria has snow, I'm led to believe.
And about a week later, the defense expert in the same case also contacted me asking the same question. The defense expert in that case was able to provide the database, and I was able to provide the answer.
Now, as far as the full extraction, is that the entirety of what you looked at in this instance, or what, if anything else, were you provided with in regard to your review and your analysis in this instance?
So I did work with the full extraction, but my interest was focused on just the web history artifacts.
What, if anything, did you find with regard to the web history artifact?
So the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record, but the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database.
I think you mean a failed Austrian painter. At least failed at painting.
Even though that's not the time, in my opinion, that the search was conducted.
And what is your opinion as to when the search was conducted?
There's plenty of other evidence on that extraction that shows what activity was occurring at 2:27 and 40 seconds. And there's plenty of evidence later on in the day that shows that that particular search was conducted at 6:23, I believe 51 seconds. And then.
So, just as an aside, so if Jen McCabe is laying there in bed, Googling things, why would she Google basketball stuff and then immediately after, oh, I should look this up too? Even if we take the conspiracy theorists at face value, if How Long to Die in Cold was at the top of her mind at 2:27 a.m., you'd think that would be slightly more important than the basketball, wouldn't you? Unless, oh, she's just trying to cover her tracks and, it was all part of the conspiracy. She Googled basketball as they were dragging him out in the snow just to be safe. And it's like, what? Why would you search for basketball and then immediately after, which, let's look up this basketball camp, which also leads me to wonder just how long should we give Johnny to die there in the snow? It doesn't make any sense.
And a similar search at 6:24 and 18 seconds, I believe.
And before we get to that, Your Honor, may I approach?
Yes.
Griffin, I'm showing you the document after this.
Thank you. Yes.
Do you recognize that, sir?
I do, yes.
What do you recognize that to be?
This was the internet history, the history.db database table showing activity from the morning of the 29th of January.
So I notice he's got a laptop in front of him. Presumably, this is what they were setting up during the break. So he presumably, once again, I haven't watched. I'm working this out in real time. But he's presumably going to work the jury through things on the laptop, like his prepared exhibits. So there's a reason the laptop is there now.
January 2022.
May I approach, General?
Yes.
I'll also introduce the next exhibit.
No objection.
Okay.
14.
Yes.
If I may.
Here come the feds. It's the feds.
Yes.
But why would they be coming to arrest Whiffen?
Or may I approach just to retrieve?
Yes.
No, it's my fault.
Good point.
Mr. Whiffen, do you recognize what's up on the screen now as the exhibit you have before you?
I do, yes.
And Ms. Whiffen, there should be a laser pointer on the desk next to you. What I'm going to ask you to do is, if you could, using that laser pointer, explain to the jury what we're looking at in this exhibit and what, if anything, is significant to observe within this exhibit.
Okay, of course. So this was a table I created based on the data from the phone. The first column shows the local time of a record that was written to the history database. This is a database which is tracking all web pages which are loaded as you use them. The second column starts with the...
I'm shocked, Alpha, that little Alan Jackson would ever be deceptive.
URL, so the Uniform Resource Locator. So what you would type in, or how the the browser knows which website you want to visit. The title is part of the website which is loaded. One of the top attributes of the website will load the title. Visit count relates to an internal counter within Safari, which just tracks how many times a particular website's visited in order to make suggestions to you down the road. And then finally, the last column shows the source of this information. So history.db is the name of the database. History_visits is the name of the table. And then the number is the unique identifier, which is assigned to that particular record in consecutive order. So every time you add a new record, that number will increase by 1.
Mr. Whip, probably a couple of foundational questions that I should have asked you first. My apologies. With respect to the cell phone extraction that you were provided, that was from a individual named Jennifer McCabe. Is that correct?
That's my understanding, yes.
And fair to say you don't know Jennifer McCabe, never met her, don't know anything about her?
Correct.
And as far as a extraction is concerned, if you could please explain to the jury sort of what your understanding of that is. What is an extraction?
An extraction in this case, all of the files and folders had been extracted from the device, saved on a computer in a zip file container. So essentially in a way that is as close to the original from the device as possible.
And again, what is your title specifically with Cellbrite?
It's decoding product manager at the moment.
And so what, if any, relation does what you do have with relation to an extraction and how that's, what's sort of the relationship between what you do and a Cellbrite extraction?
So once the extraction's been extracted and we have the zip file, then Physical Analyzer is the tool that Cellbrite creates to allow examiners to look at that extracted data in a meaningful way. And my role is somewhat shaping how examiners will see that data when they open up Physical Analyzer and look at the extracted data.
And how does your role play into that? What is it that you do what, if any, relationship does what you do have to do with how examiners will view something from Cellbrite tool?
Again, so after being an examiner for 10 or 11 years, I've got that kind of understanding of how examiners work. Being someone who also writes my own software and does my own research, then I can kind of cross that void that usually exists between developers and examiners and help both parties try to come to a meaningful conclusion.
Ms. Gilman, if you could shrink that just a little.
Yep. Something like 20 times before.
Now, again, Mr. Whip, and if you could, using that later pointer, direct the jury's attention to what, if anything, significant you observed depicted in this particular case.
Yeah, so the lower two records, which are highlighted in green, are two records which occurred at 2:27 and 42 seconds local time. So 2 seconds after the Google search had allegedly been made. And then the second record is 5 seconds after that at 2:27, 47 seconds. Both those URLs relate to a website of hokamocksports.com.
Always lasagna.
Okay. If you could explain to the jury, what is a contiguous identifier?
So again, every SQLite database will assign a unique contiguous identifier number. So again, the very first record created will be given a record ID of 1, the second record will be 2, and so on and so forth. Those numbers are never reused. So if I was to delete record 3, that record number will never be reused, and I can see that there's a gap and deleted data in that database.
You use another term in there as far as the SQLite database. If you could explain to the jury what your understanding of that term is based on your trainings.
Yeah, a SQLite database, essentially, it's a series of tables. It's a way for data to be stored, again, in a meaningful, organized fashion that can be queried, can be examined, can be filtered, searched, etc. It can be useful for anybody who wants to get data from an organized file.
Now, with reference to the searches that you observed within this particular web history, what, if any, relationship did the contiguous identifiers sort of the range? What, if anything, does that tell?
I'm sorry, can you rephrase that?
What, if any, observations did you make as far as those contiguous identifiers in the range they had in relation to the web history that you observed?
Okay, so within the history.db file, there were no missing numbers from the beginning of January, essentially, until early February. That told me as an examiner that no records have been deleted during that time.
May I approach again, Your Honor?
Yes.
If I can.
Thank you. I do, yes.
What do you recognize that?
This is the browser state record, which identified a search at 2:27:40 a.m.
May I approach again, Your Honor?
Yes.
Almost. We have no objection.
Thank you.
Now return to the witness, Your Honor.
Yes.
Commission may be published as adjourned.
Yes.
Counselor, directing your attention to the screen, is that what you have before you as the next exhibit?
It is, yes.
I guess by that logic, though, Edwin Wickham, pig in a blanket would be an American cannoli. Cannellini. Ugh.
If you could explain to the jury what we're looking at in this exhibit, what any information you're able to sort of glean as a forensic examiner with relation.
Okay, so this is a searched item exhibit. It's technically a derivative of a different exhibit that we find on the device. So we found what we consider a web history record. So a web history record would just mean we have a URL that was visited and potentially a timestamp and a title. Searched items looks at all of the web history items that we found and tries to identify were these actually searches that were conducted. So for example, if you were to do a search on Google, you'd see that the website that you're taken to is google.com query, and then it contains the query string that you've typed in. We extract that information, we extract that query and provide it to the user as a searched item. In this case, I can see that it came from the browser state.db WAL file. The search query itself was host long to die in cold, and it shows as a deleted record.
Now, with respect, I think we used a couple of different terms within that as far as a knowledge C database. Can you explain to the jury what that is?
I don't recall saying knowledge C, but I can explain what knowledge C is in this case. Yes, the knowledge C database is at the heart of iOS. It stores lots of information about the activity on the device at any given time. Things like when the backlight's turned on, when the device is unlocked, what application is in focus at the time and how long it's in focus for. And important to this case.
I'm going to take your word on that, Vince. It's above my pay grade. In technology, of course.
Which website's on screen at any given time as well.
When you say when a website is in focus, can you expound upon that as far as what exactly do you mean by when you say in focus?
So in terms of iOS itself, when it's in focus, it would be the primary item that's visible on screen. So with iOS, you can have applications in the background that you aren't using, but the one that you are currently using is considered in focus, taking up the entire screen.
I believe you had used the term as far as the browser state DB, is that correct?
Correct.
And can you explain to the jury what your understanding of that term is and how it relates?
Browser state DB is just the name of the database, the name that Apple gave it. It's gone through some changes over the last few years. For example, in iOS 14, it did store the state of the...
Wait. It's gone through changes? So Apple's in on the conspiracy? Oh.
Tabs that were open within a browser. In iOS 15, there was a significant change, and the only time that records were written to the database is when the tab was closed. So a significant difference in that it doesn't show you what's currently open, it only shows you what's previously been closed.
Now, this search here, what, if anything, did you observe as far as this record in relation to the history DB related to the search?
This record is not mentioned at all within the history.db database.
And what, if any, missing records from this time frame did you observe either?
There were no missing records in the history.db database. Within this time frame, within the browser state database, there were 3 deleted records.
When you say deleted records as far as your self-rights tool is concerned, what exactly does deleted mean?
These are records that have been deleted, not necessarily by the user, potentially by the system, but they are considered deleted records that we're able to recover.
What are some of the ways that something might be deleted by the system, and which system? Are you talking about the phone, or are you talking about your tool?
The phone. Right. Our tool is designed as a forensic tool. It's not going to edit, delete, or affect the data in any way, just present what is in the extraction. But there are multiple times on an iOS device or an Android device where cleanup essentially happens, and we start to lose data after.
So I'm going out on a limb here. I haven't seen this. I'm not a tech expert. But when he says cleanup, so let's say you do a Google search. Let's say it's host long to die in cold. And you say, oh, fuck, that's a typo. So you type in how long die in cold. And oh, fuck, there's another typo. So you finally Google the appropriate spelling, how long to die in the cold. And the system realizes, hey, we can clean those records up because they're basically duplicative spelling errors. Let's just keep the real one and not clutter things up, is what I'm guessing he's going to go on to say. Once again, I don't know. Of course, you look at my Google history on my phone, and there's going to be a whole lot of deletions because, frankly, there are things that I Google an awful lot on my phone, and having those show up right away in my history just makes life easier. Whereas if I Google, let's say 34 Fairview to get the street view of it, if I don't want that showing up on my recents, just, I delete it. There's like probably 3/4 of the stuff I Google on my phone, I delete. Not because I'm trying to, tamper with anything, get rid of anything. It's not that I'm embarrassed by my search history. It's just, it's more convenient to immediately delete it and keep the things I search regularly right up there at the top. And yeah, you'd be surprised what you're going to find on a criminal defense attorney's search history. I bet little Alan Jackson could be accused of being a serial killer based on his search history. But, deleting things because you have a misspelling, just it's not suspicious. It's a very, very, very normal thing to do. And then if the phone auto deletes, that's an even more normal thing to do because you don't play any part in it.
Certain amount of time.
Now, with respect, we'll just ask this for a moment. With respect to Cellbrite, as far as the tools, have there been a variety of different versions of those tools as far as conducting that forensic extraction?
Yes. So Cellbrite Physical Analyzer has been available for approximately 12, 13 years in various versions.
And what, if any, differences are there between, in general terms, between, say, an old version versus a newer?
Melanie, it's because when her parents said, stop making that face or else it'll stick, and it stuck.
Obviously, in the digital forensics landscape, whenever a provider creates a new feature, we have to change our code to adapt to what they've now introduced. There can be research that's been done, so we now learn new things, and we add support over time. So something can be supported in this new version of Physical Analyzer that may not have been supported or even existed in a previous version.
Now, with respect to your work in this field, what, if any, tools have you designed or created or something to conduct this type of work?
Aside from Physical Analyzer?
Yes.
Okay, so I have my own tool called Artex, which I've been working on for around 5 years. Since being an examiner myself and struggling to parse any particular application I needed. So I started to write my own tools, and that's the one that is one that I still maintain on the side in my own time, partly for my own knowledge, but partly because I think it still introduces some fantastic features which aren't available in any other tool for research purposes. So yeah, I continue to write this tool to this day.
And could you just say the name?
Artex, A-R-T-E-X. Thank you.
Now, with regard to the situation depicted in the exhibit up on the screen, what are some of the reasons why this may occur, or why this may read as it does?
Sorry, is it deleted?
Yes.
Oh, the record itself has been deleted. As I said, the reason why it's deleted, through my testing, I've only found 2 ways that that kind of record can be deleted by the user. And I don't believe either of those ways was actually utilized on this device.
That's what I was thinking.
The user has the option to selectively delete history items. So you can delete either one at a time, or the entire day's content, or the last 2 days' content. Or you can delete all content altogether. If all content had been deleted, we wouldn't have found any information on this phone at all related to web history, so I was able to discount that one quite quickly.
And I guess alluding to what you just said, why is it that you don't believe that either of those two methods of user deletion occurred in this context?
Objection, may we report, please?
I'm sorry?
I said objection, may we report, please?
Okay.
Because there are searches from that time period. If she had deleted all the searches, then all the searches would be deleted. What's your objection? Like, seriously, work us through your thought process. Why that? Huh? Right. I don't get the objection. Other than objection, it's devastating to our case. Maybe there. And yeah, I think Yannetti is definitely a boomer when it comes to technology. Of course, maybe little Alan Jackson is an even bigger boomer. Like, I bet he is, actually. Well, littler, but more of. Find where he was.
I have one more, John.
Sure.
But he also gave his opinion that he didn't think all the records were deleted. And so asking, why do you think that, isn't speculation. It's working through your thought process. So it's, to me, that's an appropriate question.
Mr. Whiffen, moving on from that for a moment. May I approach the witness, Sean?
Yes.
Okay, maybe lacks foundation.
Thank you.
That document I've just handed you, Mr. Whiffen, you recognize that?
I do, yes.
What do you recognize that?
It's a document that highlights both the search terms that were found in mobile Safari.p list and the method of searching.
I approach again, Your Honor.
Yes.
I'm also seeking to introduce the next exhibit. No objection.
Okay.
I did say that. I mean, he was asked, so the searches weren't deleted, and why? What makes you say that? Because there were searches that weren't deleted. So it's. I realize that circular logic, but it's just the data's there to show all the searches weren't deleted. Because if all the searches were deleted, the Hoslong to die in cold would have been deleted.
Thank you.
May I return to the witness? Of course, Commissioner, may I publish it to the jury?
Okay.
Ms. Whiffen, do you recognize what's up on the screen as the next exhibit?
I do, yes.
You did use a term in there, I believe, called a P list. Is that correct?
Correct.
Can you explain to the jury what you understand that term to mean and how it relates to what you're about to talk about?
Yeah, so a P list or a property list is Apple's way of storing serialized data. That essentially means a list of data with names and values.
And sir, if you could, again, using that later point, direct the jury's attention to explain sort of what we're looking at and what anything is significant to observe this particular slide or table.
Yeah, so again,
the analogy, Alpha, would be there are still chips in the bag, therefore I didn't eat all of the chips in the bag. I didn't empty the bag.
This is a table I created from the data within the mobile Safari.plist. The term shown down the left is what the user would have typed in to the search bar. Sorry, I keep blinding somebody. The search bar in the bottom of the Safari browser window. The UTC time is the time which is actually recorded within the plist. It's recorded as a string, so just text as it's presented on the screen there. And then I converted that and subtracted 5 hours.
And sometimes stating the obvious can be funny. I get that, but
to bring it into local time around Canton.
Now, aside from this, just for a moment, with regard to, familiar with what's termed as a private browsing mode?
Yes.
And can you explain to the jury what that is and how it relates to this?
Yeah, so private browsing mode is a setting that you can set on iOS devices, or primarily most devices.
It would be real funny. The ad that my face is hiding right now on Law and Crime is the Ozempic side effects ad, mass litigation. But in parts of the trial, we've had the, have you used Google Incognito? Because if you have, they've spied on you without your permission. It would be real funny if the Google Incognito mass litigation were sponsoring this video as he's talking about basically the private browsing on Apple.
Save the searches, it won't save the navigations. It protects everything so that it can't be found later on.
And what, if any, relation did that have to what your analysis of the extraction in this case?
If these searches had been conducted while in private browsing mode, these searches would not exist within this file.
So is it your opinion that they were not conducted in any kind of private browsing mode?
Correct.
Now, are you also familiar with the term as far as failure to load?
Yes.
Can you explain that to the jury and how that applies to this?
Yes, so obviously whenever you try to visit a web page, there's a stream of information coming from the web to the device, which then renders onto the screen. At the completion of the load event, there's a function effectively which runs.
I have a feeling, Vince, that Jen McCabe would not know how to do that. I wouldn't either, but Jen McCabe, I highly doubt, would know how to do that. And the South Park End of Obesity special was hilarious. Like, the beauty of South Park is they make fun of everyone, therefore they can make fun of everyone. You know, I realize that's another, they're not deleted because they're not deleted because they're still there. But, you can get away with a lot more questionable taste if you make fun of everyone than if you just target one group. And that's the beauty of South Park, is nothing sacred, therefore everything's on the table. And it just all culminates so nicely in the chase scene in the End of Obesity South Park special. Just absolute perfection. So good.
And that records the visit to the history database. If for some reason the page doesn't load and it shows up with an unable to load message, so for example you don't have an internet connection at all, that unable to load will be recorded. If, however, the device stalls and it just sits kind of waiting to load, nothing gets written to the history database. And if you were to close the browsing window prior to the page completing its load event, nothing will be written to history.
Or would that be written somewhere else within the phone as far as any other storage area?
Exactly.
Technically, the only place I found would be the browser state.
Now,
I mean, I realize it's not an inside joke, but everyone in Utah knows this one, Dante.
with regard to the plist files, does the plist file save all sort of history items or no?
Primarily, it's used to save preferences. So you'd have a lot of information in there if it's using light mode or dark mode, or when you want tabs to auto clear, that kind of information. But
we are at 1 1/4 speed though, Melanie, and he's British, so that his accent adds a little to it.
It also records several days history of searches. The actual number of days searches, I actually don't know.
And what, if any, relationship does that have with regard to the search bar that's located on the bottom of this table?
In order for the search item to be saved to the mobile Safari plist, you need to actually type into this particular search bar. If you were to just visit google.com and start typing into the Google search bar, it will not be recorded within the mobile Safari.plist.
And so what, if anything, were you able to determine about those two searches with regards to what you observed?
So in these particular two searches were conducted at 6:23:51 and 6:24:18 respectively. They were searched using the search bar that's built into Safari. The fact that they didn't exist within HistoryDB and that there were no deleted records from history.db leads me to believe that they never successfully loaded.
Al Pacino's too likable. I still think Kirk Cameron on his knees.
May I approach again, Your Honor?
Yes.
That new document that I just handed you, do you recognize that?
I do, yes.
What do you recognize that?
This was the additional, the items from the history.db, I believe.
May I approach, Your Honor?
Yes.
I'll proceed to introduce and admit as the next exhibit. Okay.
Okay. Did you bring it?
Bateman's too likable and tall. Not quite a big enough forehead. 5 head, 5.5 head. When I was a kid, my opa would say he wasn't bald, he just had a big forehead. Kind of like Karen Reed. But let's see. Who else? Oh. Okay. I realize most people think it's one of the worst movies ever made, but I'm of the appropriate age that it was absolutely hilarious to me when it came out. And so in Biodome, the Pauly Shore movie, the bad guy, when he like officially goes off the deep end and goes all squirrely, that could be Alan Jackson. I think it's from Biodome. It's been too long. It's been too long. And yeah, there's the deep dark purple all the way down his back, but is that an injury? Is that just pulling blood from dying in the cold? Like, is it from the impact, or is it just the blood pooling? But then, of course, what caused the blood to be able to pool? So, yeah.
You are unmuted.
Sure. May I return to the witness?
Yes.
I'm sorry, Mr. Whitman, if you could just repeat exactly what that is in the next exhibit.
Yeah, so it's a comparison between the search terms found in the plist, so the mobile Safari plist, and the search terms found within the history.db database.
So the items contained within the
Exactly.
table are items that were contained within the extraction that you examined, correct?
Correct.
And you're on the court's vision if I
And yeah, they like what mechanism does a dead person have to bruise? And the cold stops you from bruising, or at least slows it down.
display that for the jury.
Yes, yes.
Mr. Whitman, if you could, again, using the laser pointer, just to describe to the jury what we're looking at in this table and what, if anything, is significant between sort of the two sources of information.
Okay, so the first list, the P list term, shows the term within the mobile Safari.p list, excluding the two that we've already mentioned, which are of note. And the first timestamp column shows the timestamp according to that P list. The history item shows the search term as recorded in the history database. And then we have the timestamp as per the history database. So the purpose of this document was to show that we have a search for raining men and a history item related to the Google search for raining men, and they show within a second of each other. Again, the next one down, Antoinette Ock and basketball, and the associated Google search. And again, the timestamps are within a second. This list was non-exhaustive. There was hundreds of examples within the history.db, but limited examples within the mobile Safari P list. And as I mentioned,
Okay. I was trying to figure out, wait, why is she Googling John O'Keefe? But that's on the 30th, so that's fine.
two searches of interest, the how long to die in the Kikti and how long to die in the cold, didn't exist within the history.db at all.
Ms. Gilman, you can take that now. Now, sir, if I could ask you just a little bit now about the browser state DB. Again, can you explain to the jury sort of what that is and how it, if at all, it plays a role in your analysis?
Yeah.
Yep. So
the bad guy, though, in Biodome, he's 6 feet tall, so nope, he'd have to be on his knees too.
But initially, pre and including iOS 14, the browser state database would show all tabs that you currently had opened. So as soon as I go into my browser and open a new tab, a record is created. It includes information such as the time that I opened the tab or the time I last viewed the tab, the current URL, which is being displayed within that tab. It shows information whether it's in private browsing mode or not. So in that kind of case, in iOS 14 and below, we're able to see current private browsing records and subsequently recover deleted ones. But in iOS 15, things changed. The record was no longer written as soon as the tab was.
For the safety of all Canton, you must acquit. It's entirely up to you, Bad Scooter. It's technical jargon, so you know, it's entirely up to you. But yeah, they searched Raining Men because there's the running joke with one of the Alberts. I can't remember if it's Julie Albert or Brian's wife. Can't remember her first name. But there's a running joke that she's saying it all the time, and we have testimony that they pulled it up and listened to it at the Albert residence. So
was opened. It was only opened when the tab was closed. Sorry, the record was only created when the tab was closed. That meant that our ability to recover that kind of history was significantly lower. It means that it no longer makes use of the private browsing field, because now private browsing records simply are never written to that database. So now we can only really see a list of all of the tabs that have been closed, not which are currently open.
Now, with regard to the browser state DB, is there something referred to as a last viewed timestamp?
There is, yes. That's one of the fields within the database.
And can you explain specifically with relation to that field for what kind of information is kept there and what it means?
Yeah, so from my research based on this, that timestamp relates to the time that the tab took focus. So that's either when the user creates the brand new tab, when they switch between tabs and bring a tab back into focus, when they close a tab, which automatically brings one of the background tabs into focus, or if Safari has been completely closed and reopened, that essentially acts like almost a new tab, and the timestamp gets updated at that point.
Can you explain how an earlier timestamp could be associated from, say, tab is open?
Well, Melanie, if you made this comment during Trooper Paul, you're in luck, because, yeah, Ian Whiffen is much better.
Something is done.
As you'll find out by the time you get here. In which case, hello and welcome to Real Time, which will be the past one. Fuck, this is all timey-wimey.
Tab is closed, tab is reopened, something else is done. How that earlier timestamp could then be associated data-wise with the subsequent search?
I think
opening it.
I think I followed that. Okay, so if, for example, at 12 p.m., I create a new tab, I can do a search for whatever I want. And at that point, if I close the tab, then the record that gets created will show that I opened a tab at 12 p.m. and I did a search. Excuse me. However, if I open the same tab at 12 p.m., do a search, close it, like completely close down Safari and reopen Safari, that would also update the same timestamp to show that I'd opened it up again. What I meant to say at that point is that if I create a 12 o'clock tab, minimize Safari. I can leave it for several hours, for several days, for several weeks. The time difference is not really important. When I come back to it and open up Safari again from a background state, the timestamp is not updated. So it will still show 12 p.m. today, and it will show whatever my most recent navigational event is. So I can search for something in 3 weeks' time using the same tab I opened today, and the timestamp will show today's time.
All right. I think
so. It also occurs to me, if Melanie's behind, when I mentioned it's just his British accent that is making you say he needs to slow down, I'm realizing, no, that was the previous witness she's probably talking about. So, yeah, he absolutely needed to. Ian Whiffen's been good. And that last explanation, no, if you don't close it, no matter when you pull it back up, it basically shows the timestamp from when you opened it, not when you pull it back up. So, yeah.
I think this is a good place to take our break.
Yes.
Mr. Whiffen, we're going to, of course, ask you to stay with us, okay? As the jurors file up, you can file up behind us.
Thank you. Board, all rise for the jury.
And could I see counsel regarding timing, please?
Yes.
Yeah, worst witness so far for the prosecution. Worse than Trooper Proctor. Not quite as cringy as Trooper Proctor, but just because Trooper Proctor, there was not much of evidentiary value. With this guy, there should have been, but he was just a bad witness. Like, literally, they need to send him for remedial training, I think. He unless they think he can improve, he's not cut out for testifying. And that's a big part of the job. If he can't testify, like, if his testimony sinks cases, he needs to be transferred or, like, find a different career. I realize that sounds harsh, but if the prosecution can't count on you, what good are you? As harsh as that sounds. And yeah, I think Whiffen can eat spaghetti Yanetti for lunch. I definitely agree that. Yeah. But Vince, with you, I'm not sure that that's punishment you're suggesting. Not that I'm kink shaming, but with you, I don't know that that's a punishment you're suggesting. And let's try to outrun the Jesse Weber jump scare and go right to there.
Thank you. Maybe see the quote back.
I mean, I don't actually know because I haven't read the evidentiary rulings, and I'm sure there was a motion in limine that the judge ruled on, and it presumably it's not offered for the truth of the matter asserted, but every time Jackson tried to ask, well, what does your friend mean here? Sounds to me like it's the truth of the matter asserted, but from a non-witness. And it's just, to me, it shouldn't have been allowed in because it's not probative in the slightest. It's only prejudicial. There's no evidentiary value whatsoever. I went on this rant at the beginning of the live stream, Alpha. But basically, if it's good for the goose, it's good for the gander. I want to see Karen Reed's text with Turtle Boy in evidence. See if she uses naughty words. See if she has bad things to say about Lolly or Trooper Proctor or whoever about John. And see if she uses the C word or the R word or, any naughty words that shock the conscience. Even doing the exact same analysis, the judge would not let those in, even though she let Trooper Proctor's in. But I think if it's good for the goose, it's good for the gander, and we should see all of Karen Reed's naughty texts. So.
Okay, whenever you're ready, Mr. Lally.
Your Honor, Mayor.
Yes.
And the thing is, with the other parties' texts, like with Trooper Proctor's friends, it's that they can't offer theirs, only Trooper Proctor's for the truth of the matter asserted. But even then, I don't think it's truth of the matter asserted. Like literally, it's hearsay. It's an out of court statement. It's of no relevance. But if they let Trooper Proctor's in, they've got to let the whole conversation in somehow. Is I'm thinking how the analysis went, so that you have the conversation, the complete conversation. But and that's the same thing with Johnny Depp. But it just, none of it should have come in. None of it should have come in. And the thing is, though, the rules of evidence are the same in criminal and civil. And they may be numbered differently, but they're pretty standard from state to state, and federal versus state. So yeah.
Start showing you another document.
Thank you.
That.
I do, yes.
And what do you recognize that?
This is the entire Google URL that was found on the browser state record. So broken down into each of its important sections.
May I approach again, Your Honor?
Yes.
I'm going to take this through to the next exhibit.
Okay.
Same objection as before.
Okay, there are a couple of different objections. I need to see your type. I don't know what you're talking about.
Well, we started off strong for the afternoon session. Immediate sidebar. At least it appears to be a short one, and I wasn't paying enough attention to, well, even if I were paying attention, I wouldn't know what the objection is, just because I haven't seen what they're objecting to. It's an exhibit that hasn't gone up yet, so presumably it's hearsay, but I don't know how, because I didn't see it. So
You are unmuted. That will be the next exhibit.
Exhibit 618.
Thank you.
well, looks like Lolly won.
Yes.
Yes.
Now, Mr. Whitman, what's up on the screen now? Is that what you have before you have 618?
Yes, yes.
And if you could again, using the laser pointer, direct the jury's attention.
Shocking, Naven. I assume you were asking why he wasn't wearing it in court, because I know why.
So, what are we looking at in this case?
Okay, so the left side of.
But if you're asking why he's not wearing it on his stream just now, presumably it's because it was blown completely out of the water by Mr. Whiffen.
The table is the entire URL that was recovered from the browser state record. What I've done is broken it down into each of its individual components and explained what each of those components means. So the very first row is google.com/search. That just tells the browser that we're going to the Google website and that we want to run a search. The second part, the Q equals, is telling the browser what the query term is. So the query term here is hot long to dying cold. The little plus symbols in between is in place of a space because spaces can't be part of a URL. Next, we have the input encoding and the output encoding. Just explains what kind of characters to use and what language to use when you're accepting the search query and giving it back to the user. And finally, the important part is the and client equals Safari. This is something that just tells Google that this query is being done using the Safari client. Again, if I was to use Safari and just visit the Google webpage and type that in, or type a search in, that part of the string wouldn't be there. That's only there because I used the Safari search bar as part of the Safari application to do that search.
Thanks. So, Ms. Gilman, you can take that one. Now, sir, with reference to that, what, if any, relationship does that have to the information you were discussing just prior to it?
Again, that confirms that this search was conducted via the Safari search bar feature that's part of the Safari browser application, the same one that caused the records to be recorded in the plist.
Your Honor, may I approach the witness again?
Yes.
Give another document. Do you recognize that, sir?
I do, yes.
And when you recognize that?
This is the live records from the browser state.db database.
Mayor Pro Tem,
Yes.
I'm also seeking to introduce the witness. Okay.
Right, thank you. Was it 6 months?
Now return to the witness. Name published after the jury call, Your Honor.
Ian Whiffen, the witness on the stand right now, Vince. And calling him a query string is rude.
And Mr. Whitman, do you recognize what's up on the screen now is what you have before you as Exhibit 619?
I do, yes.
Now, turning back to the browser DB database for this particular device, with regard to the timestamp and the last view time, what, if anything, do you observe in reference to that depicted in this, and could you direct the jury's attention to it?
Yeah, so this timestamp is the last view time according to the database itself. It's already been offset so that it's in local time. This particular table, we can see there are records missing. Between records 4025 and 4031, we have, 4025 and 4031, we have 4026, 27, 28, 29, and 30 missing. And typically the timestamps that we do have here, some of them are separated by as little as a second or two.
Now, with reference to the house long to die call, that was record 4028, is that correct?
That's correct.
And so based on records missing
Thanks for joining us today, Frank. Sweet dreams.
from this portion of the phone as far as that database, what, if anything, did you endeavor to do with respect to ascertaining what?
So first of all, the task was to try to recover the deleted messages. The deleted history records from browser state. So first of all, was reading the deleted pages, essentially, to find the records that have been deleted from this current version of the page.
Madam Pro Tem.
Yes.
Sorry, Joe, that document, I'll ask you to do that.
Yes.
And do you recognize that document, sir?
I do, yes.
So what do you recognize that to be?
This is the same data source, so it's still browser state.db, but now looking at it with the unique recovered record.
And what is that last term that you use? What does that mean? I'm sorry.
So typically there can be lots of different versions of a page within a WAL file. So you may have several page ones, several page twos, and so on. What I looked at is doing is recovering the data where the records that I recover are different from each other. So if I recover the same record multiple times, I can ignore it. But if I recover the same record with a slight change, then I would show it in this view.
Mayor Pro Tem.
Yes.
And I'll seek to introduce the minutes. Okay.
Okay.
Court Commission may publish after the jury.
Yes.
Mr. Whitman, if you could, move away from order to find it helpful to direct the jury's attention to what are we looking at here, and what, if anything, did you uncover during this portion of your analysis?
Yes. So again, the very first column on the left is the unique identifying number. You'll notice that there are some numbers here which are repeated. This is, as I say, because the records are recovered from multiple versions of the same page. There was actually 16 versions of this record across 23 different versions of this particular page. These three had some difference. Primarily, it was what's called the tab order field, but that's the only difference that showed up across these three host long to die in the cold records. All the rest show the same URL, the same ID number at the beginning, or tab ID number, and the same timestamp. Worth noting, there is no title shown.
The thing is, though, Alpha, if the feds paid him for his analysis, there's no sunk cost really for the defense in not calling him. But, you know, even if he's an inferior witness to Ian Whiffen, it's still, you know, if you can create confusion, might be worth calling him. Of course, if you piss off the jury by calling a moron trying to refute an excellent expert witness, that's a risk.
In this particular record, again, that speaks to the fact that this page didn't successfully complete loading. Otherwise, there would be a title or Google search costs long to die in the cold, as you saw on some of the other examples earlier.
Now, sir, with respect to the table up here, is there any indication in regard to private browsing that you were talking about before?
No, in iOS 15, as I mentioned, if you are using private browsing mode, there is no records recorded in this database.
It entirely depends on their agreement. But you know, the Fed's paid for his analysis, is my understanding, and they're just trying to piggyback. Presumably, there's still the trial appearance fee, because usually you're going to pay the expert witness for their analysis, for their research, and then you're going to pay them a certain fee for however many number of days they testify. And if so, basically the risk is you pay the expert for their report, for their analysis, and then at trial you say, I really don't know if I want to call this expert. I don't know if they're going to help. Well, part of you is going to say, well, I've got that sunk cost because I paid for the report, so it's just a little more to pay him to testify, so I might as well. Whereas if you didn't pay for the analysis, there's no sunk cost. So it's just a matter of, do I pay him to testify, or do I say, no, you're not needed? And there's no sunk cost, pressuring you to have them testify. In fact, it saves you money not to. But I don't know what his testimony would be. I don't know how good he would be. I haven't seen his report, so I really can't say.
Based at all.
So the fact that that's not listed in this table, what, if anything, does that tell you?
Everything that was recorded in this database was conducted not in private browsing mode.
Now, with respect to your work within your field, are you familiar with the term called a session?
Yes.
And can you explain to the jury what you want to say?
At this point, Naven, that was 8 weeks ago. You count on the jury forgetting what he promised them in the opening. Just make the argument and close. That expert was a moron. He didn't know what he was talking about. He doesn't even have a degree. He got a certificate in the UK. Was it written in Quill? So you just don't even mention it in the closing and hope that the jury forgot the promises. Now that's risky, because something they tell you in law school, don't promise something in the opening if you can't deliver. But in a long enough trial, the jury's going to forget, so who cares? So no, because the reality is often there's gamesmanship in experts, and let's say there's 2 experts in a field and one side has deep pockets, the other doesn't. You go out and you hire both of those experts, and hey, they work for you. And then you just don't call one of them. That way the opposition doesn't have an expert, or they have to get a lesser expert. And since you're the one paying them, the other side can't force you. Yeah, they're an expert. They peer reviewed the opinion of the expert that we are having testify. So can't make the other side's experts testify for you. So
I understand that term to mean and how it applies to this specific instance.
Essentially the life of the particular tab. So when I start a tab and I start to use navigation, I go to different websites. All of my navigation events would be considered part of the same browsing session, essentially.
Now, sir, if I could turn your attention to the knowledge C database for a moment. And again, if you could maybe I'm repeating this, as far as, can you explain to the jury what you understand that term to mean as far as what is the knowledge C database in respect to the other databases we talked about?
Yeah, so far, the bulk of what we've discussed, the history.db, the browser state DB, and mobile Safari.plist are all particular to the Safari application on iOS. Knowledge C is much more global. It's much more ingrained within iOS. Everything is essentially recorded in there on iOS 15. So again, backlight activity, unlock activity, application state activity, and web usage activity is all recorded as part of Knowledge C.
May I approach that, Your Honor?
Yes.
I haven't. I mean, how that would be appropriate from an expert witness is beyond me. That's just complete speculation based on nothing. So yeah, I wouldn't let that in because it you know, experts are given latitude in speculation, but just saying throwing out wild accusations, there's no way the judge should let that in. But
We'll do another document, we can just do that.
yeah, I haven't seen it. See, I'm just glad to know that Dr. Hare is
Yes. And do you recognize that document, sir?
I do, yeah.
Local here, downtown Salt Lake City. Can't remember his name. And I feel really bad calling him Dr. Hare, but I just can't remember his name. He was a really nice guy. Like, I only spoke to him for a minute, but really nice guy. Really nice.
What do you recognize as?
This is a document I created based on the Knowledge C web usage records.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce and no objection.
Thank you. Thank you.
Thank you. Your Honor, with the court's permission, may we publish that to the jury?
Yes.
Sir, again, what's up on the screen, do you recognize that as what's before you as the next exhibit?
I do, yes.
And if you could, again, Mr. Gilman, if I could ask you to scroll down to the green tabs. Okay. Now, if you could, sir, again, using that laser pointer, if you could direct the jury's, well, first.
And looking up Dr. Hare, Gwyneth Paltrow does not pull his name up. Apparently, I'm the only one calling him Dr. Hare. But shock horror, I just deleted that search from my search history. Not to hide it, just because it clutters things up.
Can I ask you, what is it that we're looking at in this exhibit?
Okay, this is a particular what's called a stream within Knowledge C. A stream is basically all like information being grouped together. So in this particular case, the stream is related to Safari, and it's
the counter to Dr. Spiegel was Dr. Doofenshmirtz. So the one with the crazy hair at the Johnny Depp trial was Dr. Doofenshmirtz. Dr. Hare is the psychologist from the Gwyneth Paltrow trial. So hence why I spoke to him, because I was there the day he testified.
What web page was visible on screen, what time it started and what time it finished.
Now, with respect to this particular tab, there are portions that are highlighted in green and portions that are highlighted in blue. Is that correct?
Correct.
You explain to the jury what the portions highlighted in green represent.
I highlighted the sections in green due to their timestamp. So typically these items last between 2:27:37 a.m. and 2:27:53 a.m. So around the time of the Google search, if you were to believe the browser state.
And with respect to the items highlighted in blue, what are those?
The ones in blue are the actual Knowledge C records that show when the How Long to Die in the Cold and the How Long to Die in the Kikti web pages were actually visible on screen.
And so from this, what if anything were you able to ascertain?
So what I'm seeing here, for those of you who can't see, this is absolutely devastating to the defense. Like, it completely blows out of the water the 227 search. Because this wide column here appears to be basically what's on the screen, what the search has been, what's brought up. And then we have the time over here. So 2:27 and 53 seconds, we have Hockomock Sports, girls hockey. 2:27:58, Hockomock Sports schedules girls hockey. Franklin, 21:22. 2:28 and 0 seconds, hockomocksports.com/schedules/girls hockey/Franklin, 2021-22. And then at 6:23 and 37 seconds, it is still on hockomocksports.com/schedules/girls hockey/Franklin /2021-2022. And then at 6:23 and 56 seconds, it goes to How Long to Die in Cold. So it was still on, the tab was still open to Hockomock Sports at 6:23. It had been open for nearly 4 hours on Hockomock Sports, and then changed at 6:23 from Hockomock Sports to How Long to Die in Cold. So to me, that blows it out of the water. That, Hosslong to blow up a conspiracy theory right there.
As to the searches or the time associated with the searches from your analysis?
At 2:27:40, the only websites that were visible on screen were related to Ozone Basketball and Hockomock Sports, and that the How Long to Die in Kickd first appeared on screen at 6:23:56, and Hosslong to Die in Cold first appeared on the screen at 10:33 a.m.
So those two searches from your review of this traction in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
And Hockomock Sports was still on the screen at 6:23. It is, but that table, if the jury could see it, which they will because it's going to go into the jury room with them for deliberations, but that table made it extremely clear, easy to see, easy to understand, and just that table was a great representation of it. Like, hearing the testimony is one thing, seeing that table just made it crystal clear. And happy Tuesday, Lisa. Good to have you here.
Now, from all this, sir, what, if anything, were you able to conclude with regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobile Safari.plist record searches that show 6:23 and 6:24, and we show the same searches with very similar timestamps. Hosslong to Die in Cold first appeared on the screen at 10:33 a.m.
I was getting ready to shout at you,
Those two
Vince.
searches from your review of this traction in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
Now, from all this, sir, what, if anything, were you able to conclude with regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobile Safari.plist record searches that show 623 and 624, and we show the same searches with very similar timestamps within half a second as showing up on screen in Knowledge C for the how long to die in the Kikdi, and the how long to die in the cold was actually several hours later, which took a little bit more explaining, looking at Knowledge C and when the applications were opened up.
Now, with respect to your view of the extraction of the device around these times, were you able to ascertain as to what time this particular device connected to a Wi-Fi sometime after 2 a.m.?
I actually didn't look at any Wi-Fi connection information.
Wait, what? You only did what you were asked to do? Nothing more? Conspiracy.
And with respect to 2:27 in the morning to 2:27 a.m., what were the websites that the device had visible, and what were the websites the device was connected to at that?
So according to the Knowledge C records, which were mostly also reflected within the history DB as well, it was the Hockamock Sports, YouTube, Ozone Basketball, and that's it for the main domains.
Now, with regard to the Wi-Fi connection, is your memory exhausted as it pertains to that?
Yeah, I don't remember looking at Wi-Fi history.
Yes.
Maybe he did.
I'm showing you a copy of your report.
Thank you.
If you got no cover.
Okay.
And sir, I'm sorry, in the interest of time, if I could ask you just to look at the next page as well, just briefly. Yes.
Okay.
Do you remember refresh, sir?
I do, yes.
May I approach to retrieve?
Yes.
So, Mr. Whitman, from your review.
We don't kink shame Vince, and it's perfectly understandable, you know, if that is your kink. I mean,
Of the extraction report in regard to this device of Mr. McCabe's, about what time was the connected to a Wi-Fi network called McCabe?
I believe it was 0207. I didn't actually remember the timestamp just then.
And with respect to the disconnection from that, you know when that was?
I can't recall.
Your Honor, if I may approach? Yes. I think there's the time, Your Honor, may the witness.
Yes.
Thank you.
Sir, if you can, from looking at your report, if you can just indicate to the jury as far as the Wi-Fi connections with.
The Wi-Fi was connected at 0212 and disconnected at 0539. There was no further Wi-Fi activity until 11 a.m.
Thank you, sir. May I approach this to retrieve, Your Honor?
Yes.
so Wi-Fi connected at 212. Presumably, that's when they got home, the McCabe's, because, you know, leaving between 1:30, 1:45, dropping the girls off at their houses, and then going home. So 212. Disconnected at 5:45, 5:47, whatever. That's about the time roughly that Karen showed up at her house. Roughly. She left. No more Wi-Fi. Using 5G after that, which is part of the conspiracy, of course.
Now, sir, are you familiar with something called a write-ahead log or a wall file?
I am, yes.
And if you could explain to the jury what your understanding of that term is and how it applies in this specific case.
Yes. So a write-ahead log is essentially a temporary store for database pages. When I'm talking about database pages, it's not something that the user ever sees. It's part of the structure of SQLite databases. Just as chapters in a book can span multiple pages, data in a database can span multiple pages also, and it's not necessarily in the expected order. It's up to the database application to find those pages and order them correctly in order to display the data to the user. The WAL file, on the other hand, it still contains pages, but they're organized in frames, essentially. And a frame is the same as a page, but with additional information at the top that identifies what page it is. So I mentioned earlier that it's possible to have multiple versions of the same page within the WAL file. That's because every time I write a record to the database, a new frame is created and the page is updated. So for example, if I was to have a new database, create a record, a new frame is created with page 1, and it adds my record. As soon as I add a second record to that database, a new frame is created again. So I now have frame 1 and frame 2. Both of those frames would contain a version of page 1. The first frame would contain only record 1. The second frame would contain records 1 and 2, and so on. Forensically, where it gets interesting is on the edit or deletion of a record, because the same process is applied. So now a new frame is created. The page number is the same as previously, so we still have a page 1. But now only the records that I don't want to delete are copied across. So I could end up in a situation where I have 4 versions of page 1. One has record 1, one has records 1 and 2, one has records 1, 2, and 3. But the most recent version of the page only has record 1 and 3, for example. Now, a normal piece of database software will only look for the most recent version of the page, so you would only see records 1 and 3. The forensic software can look at all previous versions of the page as well, and that's how we're able to recover record 2 in that instance. And that's essentially how we were able to recover the browser state record from WAL.
Now, so turning to that issue as far as deletion, what, if anything, well, let me ask you this first, just before we leave the WAL file. So with regard to the WAL file, what, if any, relevance is there that certain data only exists within the WAL file?
So again, if I create a record that's in the WAL and delete it before it gets committed, which means when it gets merged into the main database, then it exists only in the WAL. It could be that it's a brand new record that just hasn't been written yet, or it could be one which was deleted from the database prior to the commit occurring.
When you say commit, what exactly what does that mean?
Commit's a process where essentially the database looks at all of the most recent versions of each page in the WAL file, copies them out from WAL and puts it into the main database, and then deletes the WAL file altogether. So at that point, we lose the ability to recover data from WAL because the WAL doesn't exist, but we have all the most recent versions of the page.
Now, so turning to the concept of the topic of deletion of data, what, if anything, did you find with regard to deletion of data with respect to this search as applied to the P list that you discussed before?
Recovering data that's been deleted from the P list is not really possible. So all we can say is if this record exists within the P list, it hasn't been deleted.
Now, same question with regard to issues of deleted data with regard to the history DB.
There was no records of any, so there's no evidence of any records being deleted from history.db since early January. I think it was like the 3rd of January up to February 2nd.
And how were you able to tell that with regard to the history DB?
Again, every record is given a unique number, and there'd be a gap in that numbering system if a file or if a record had been deleted. The fact that there was no gaps indicates that nothing had been deleted.
And with regard to deletion, what, if anything, were you able to ascertain with regard to deletion versus web usage in the Knowledge C database?
Knowledge C contains such a large amount of different type of data that's always being added and deleted for various reasons, none at the discretion of the user. It's a completely system-driven event to delete information from Knowledge C. So we can't say what was deleted from Knowledge C, but we can see that during the times of Safari usage, records exist within Knowledge C that indicate, or certainly appear to indicate, that nothing was deleted.
What, if anything, were you able to find with regard to deletion in respect to the browser state DB data?
Browser state did have numerous records that had been deleted. Some we were able to recover. 3 records from browser state all had a timestamp very similar to 22740. These were 3 records that had been deleted at some point.
What are some of the options for deleting data from that particular, from browser state?
So the first most prominent option is to delete absolutely everything from the device. or delete all history from the device, which, as I mentioned earlier, we know that didn't happen because we still have other records. So the only other real option is to delete selectively. That could mean delete one at a time, and it could mean delete either the full day, the last 2 days, or last hour. But in all of those cases, the record must exist in history.db in order to be deleted from browser state. The fact that this record, the hoslong and the how long to download don't exist within the history database would mean that the user would never have the option to selectively delete that record.
Oh.
Yes.
So those searches not showing up anywhere means she couldn't have deleted them herself, is what I just got from that. Wow. Wow. So where has the defense got all this then? And yeah, he's definitely an expert. At least he looks like an expert to me. Of course. You know, you could fool me pretty easily with technical jargon.
Thank you.
That means Vince is impressed too.
Yes.
Do you recognize that, sir?
I do, yes.
What do you recognize that?
So this is a list of the browser state DB records showing a red line where a record or more have been deleted.
And again, the term deleted, as far as it applies to this particular area of the database, what exactly does that mean again?
It means the record has been marked as deleted. If you were to read this database in a regular database application, you would not see it, but it doesn't necessarily mean that we can't recover it.
Pro Chandra?
Yes.
I want to seek to introduce them as an exhibit.
The exhibit?
I have no objection to the exhibit.
That is the question.
We're good. Your Honor, the Court Commission may republish Exhibit 622 to the
Yes.
And Vince, that's exactly what I was about to say. You can't just submit an affidavit for the trial. You can't cross-examine the affidavit. It's, you know, as far as voir dire, he might have submitted an affidavit for today's purposes. This is what I expect to testify about at trial. These are my qualifications, yada, yada, yada. And then the defense does the dirty word and proffers it to the court in the voir dire. But we know from the Free Karen Reed crowd, giving a proffer means you've committed a crime, because that's what the Free Karen Reed crowd tells me every time they come in here screaming, but proffer, but to get it in front of the jury, it has to be subject to cross-examination. Now, if the expert has testified in some subsequent or some prior proceeding and was subject to cross-examination, and for some reason is unavailable during this trial, they could, in theory, play that. So, looking back at the Gwyneth Paltrow trial, you'll recall there were a number of witnesses that they played the deposition, because depositions have cross-examination. So it's subject to cross-examination. But you'll also remember there was a lot of discussion of what had to be deleted from those videos of the deposition and what could come in, because in a deposition, normally, if the question is objectionable, you object, And then the opposition's lawyer says, all right, now answer the damn question because we'll let the judge decide later. And yeah, and that's it. The defense can call their expert witness to testify. So just the affidavit isn't enough. They can't just say, here's my affidavit, give it to the jury. They'd have to testify or have testified in a deposition that, you know, and then they're sick, they're dead, they're whatever, conflicting trial, something that keeps them from being able to attend, or just from the prosecution. Yeah, that was a terrible deposition for him. Go ahead and play it, you know. Or, you know, if they were subject to cross-examination in the grand jury, or if there was a civil trial that went first, you could, you know, that's prior testimony subject to cross-examination. You can play that.
Again, sir, what's up on the screen? Is that what you have before you as Exhibit 622?
It says yes.
And if you could, please, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed.
I hope there isn't any, Vince, but...
So again, we can use the number down the left side, which will identify the unique identifier given to each of these records. And we can see that the red line between the first two records indicates that records between 39...
Hell yeah, Paw Patrol rock! Ah!
986 and 3993 have been deleted. We can see that record 4001 is deleted. Records between 4004 and 4019 have been deleted. Record 4020 was deleted. And then finally, records between 4025 and 4031 have been deleted also.
As a good juror, Jennifer Ray, I avoided the voir dire today, so...
Now, sir, as far as records 4024 and 4025, what, if anything, were you able to ascertain as far as the dates and times associated with those?
Yeah, so these particular records show up at 227.
That's part of the conspiracy, Vince. Supermom has a mom's Google search history. That's part of the conspiracy.
731 and 227.33 respectively. And this matched records within Knowledge C that showed that at this particular time when the tab took focus, that particular website was also shown visible to the user in Safari.
Now, as far as the date and time for 4024 and 4025, what, if anything, did you observe with respect to the date and time for 4026?
I think I have some young family members that would agree, some that would disagree. Grey Duck.
And what can you tell about that?
So 4026 was approximately a second or two after the record here, 227.33. I believe it was at 227.35. And then again, there was another record, 4027, which again was another 2 or 3 seconds after that time. So within a 9-second period between 227.31 and 227.40, there were 5 records within browser state DB that had a timestamp within that 9 seconds, all with completely different types of website, ranging from PayPal, banking, YouTube, and the Hoslong Steiner code.
Now, sir, with respect to, are you familiar with the term called spontaneous deletion?
I believe so.
And can you explain to the jury what that is?
It's not a term I would use, but essentially a cleanup operation would occur on the device where it would look for orphaned records, records that are old enough to not be required anymore, and they would just be deleted by the system without any direction from the user.
Now, during the testing that occurred, your testing, which occurred with respect to this device, what, if anything, did you observe with regard to spontaneous deletion?
I wasn't able to replicate the spontaneous deletion. I was able to replicate completely orphaned records. So a record that existed in browser state without a corresponding record in history.db. And it meant that there was no way for me to delete that record manually without deleting everything from the device regarding history.
May I approach on?
Yes.
Ah,
Maybe your first, please.
Okay, could you turn the lights on, please, Tony? Thank you.
he heard you, Edwin. He heard you yesterday. It's all that timey-wimey, wibbly-wobbly stuff. And in the interest of not going until 10 o'clock my time, I am going up to 1 1/3. Just because it's gonna, yeah. Of course, got started. Even though I started on time, it was a little later than I would have preferred to start. I just had to do stuff before starting.
You are unmuted. All right, so you're introducing
And
that.
Yep. It's approaching 8 o'clock for me right now. And with 2 hours left, factor in me chasing squirrels, I want to be done before 10 o'clock.
Those 4 pages or whatever it is, Mr. Lally?
Yes, sir.
As one exhibit?
As the next 4 exhibits.
Okay. All right, so that will be, those will be admitted. Right. Were you going to publish those? Because you can go ahead and publish them while this is.
I don't think that's.
Or Edwin, were you saying your question he answered, or no, your question was the auto delete question, so no. Never mind.
Sure.
No, you may not have.
Your Honor, if I can't take them just one by one, I think that might be.
Okay.
I'm showing the document. Do you recognize that?
I do, yes.
What do you recognize that to be?
This is a report from my Artex tool showing the history database at 21:39:34 on the 27th of January and 22:55:09 on the 27th of January.
Can I go to General?
Yes.
I'm off to introduce the next exhibit.
All right, so all 4 in. Okay, so you don't need to, you already marked them?
They have nothing marked.
Okay. 623.
I have one moment, John. Your Honor, the court's permission if we could publish that to adjourn.
Yes.
Now, sir, with regard to this, we're looking at record number 4026, is that correct?
Yes, I believe we are.
And again, if you could direct the jury's attention to what exactly are we looking at in this exhibit with regard to record 4026?
Yeah, so in the right column, we see the source of the information. So history.db is the database, history_visits would be the table, and then the unique identifying number of 31407 and 31408. We see that the start time, or the time that particular website was navigated to, according to history.db, was, as I say, both on the 27th.
So, as I mentioned him several weeks ago in this trial, for those of you who have been with me from the start, you may remember me talking about Herman Franks, who was a baseball manager, and my dad went to high school with his son and went and would go to their house and wait, Willie Mays is here. I see Willie Mays died today. So since I've mentioned him in the trial, I think it's only fair to acknowledge his death today. So it's been quite a week for sports legends between Jerry West and Willie Mays. But yeah.
7th of January, one at 21:39 and 34 seconds local time, and one at 22:55:09 local time. And both of these websites are related to Hockenmock Sports. We have the URL at the top, followed by the title of the page, followed by a visit count that tells us how many times that page has been visited before.
Sorry, one moment, John.
Yes.
That next document, do you recognize that, sir?
I do, yes.
What do you recognize that to be?
This is the same kind of report.
And I know we mentioned that she had a bad day earlier, but dear God, Vince.
This is related to the YouTube record that was part of the browser state database, related to It's Raining Men on YouTube.
Is that the record number 4027, is that correct?
It is, yes.
No, may I approach again?
Yes. Okay.
And Laura Owen knows a thing or two about
No, very briefly.
nutbags
Yes.
too. You're trying to break me again, Vince. Like you did with the
And so what's up on the
shitter.
screen now, is that what you have before you as the next exhibit?
It is, yes.
And again, if you could, using the laser pointer, just direct the jury's attention to what if anything, of significance you observe in this record of 4027.
Yeah, so again, we have 5 records related to the YouTube video, It's Raining Men, starting at record 31398, 31399, 31400, 31401, and 31402. These were all accessed on the afternoon of the 27th of January 2022.
May I approach again, Your Honor? Yes. Another document, you recognize that?
I mean, if something leads me to that, Gray Duck, we know we're having a good time. Just, you know we're having a good time if that happens.
I do.
What do you recognize that to be?
This is the same again, related to record 4029. Shows that a website was visited on the 28th of January 2021.
You want to ask that this be marked?
Okay.
Excuse me, as the next exhibit. And Your Honor, with the court's permission, may I publish that?
Yes.
As well?
And Vince, usually if I'm in someone else's comment section, I will absolutely jump on it if someone gives me an opening. So, you know, I appreciate having people in my comment section that will do the same.
What's up on the screen, is that what you have before you as the next exhibit in regards to record 4029?
It is, yes.
And again, if you could explain to the jury what we're looking at.
Yeah, so this URL, cantonma.org, relates to the URL that was provided in record 4029 of the browser state database. It shows that this web page was accessed at 1 p.m. And 17 minutes and 0 seconds, and 1 p.m. 17 minutes and 8 seconds on the 28th of January 2022.
May I approach again, Your Honor?
Yes.
No documents, sir, you recognize that?
I do.
What do you recognize that?
Again, the same kind of report. Again, this type of record 4030 from browser state, and it shows access to Ozone Basketball.
And with regard to that report, as far as the same kind of report, that's from your tool, the ArtX tool, is that correct?
Correct.
And that ArtX tool, is that a widely available tool used within the field of
It's his
forensic
tool.
investigators?
Yeah, it's something that I say I've worked on for around 5 years. I've given it away free to the digital forensics community for 5 years. There's approximately 600 users globally, and it's taught as part of the SANS digital forensics training courses.
Vince, you hear that? He's shared his tool for free with digital investigators. And, well, he's an expensive tool. But, yeah.
May I approach again, just
Yes. Yes.
She looks like she's, like, last witness, she looked like she was having a good time. She no longer looks like she's having a good time. At all. And little Alan Jackson, are those veins on his forehead, or is the hair dye streaking down his forehead a la Rudy Giuliani?
Maybe publish that for the
Yes.
Your Honor. Regard to this exhibit up on the screen, record 4030, and if you could just draw the jury's attention, direct the jury's attention to what if anything is significant to observe in this exhibit.
Yeah, so again, we have records from the history.
Sinclair, I haven't watched it, but you'll remember last week or the week before, I said it. I said, just because Lolly is methodical and even, on direct, he could get feisty on cross, and I've heard that's what it was today. And so, yeah.
History database related to Ozone basketball, and it shows that this website was accessed at 11 a.m. and 26 minutes on the 25th of January 2022.
Mayor Pro Tem?
Yes.
It's going to be. Now, with respect to sort of the totality of your analysis, Mr. Whitman, what, if any, conclusions did you come to as to the timing of the two searches in question with relation to what you observed in your analysis and testing of this device?
Yes. So, in conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted.
That's a very unfortunate camera angle for Paul O'Keefe.
Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoslong to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the Hoslong to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record.
It was less unfortunate for him, though, once he put his hand down. That's the first I'd noticed it like that.
Where Hoslong to Die in the Cold was shown on screen, even though the page never successfully loaded.
And with respect to your analysis and your testing here, what, if any, opinion you have as to whether or not any of the data marked as deleted was actually user deleted, or a user actually actively went through the process of deleting it?
Yeah. So again, we know that we know that nobody deleted the entire history. So that leaves the only option to be selectively deleting records. The fact that there are no missing records in HistoryDB shows that it's impossible that that record could have been deleted by the user. It would have just been orphaned in the database, and I believe would have deleted itself at some stage whenever a particular cleanup function ran. Although, as I said earlier, I haven't been able to replicate that. I was able to continue to read the various versions of the page that contained Hoslong to Die in the Cold browser state record, and found that it existed at the same time as another record that was created at least 2 days later. Therefore, I can determine that that particular record was not deleted until at the earliest 10 p.m. on the 31st of January. And it's not possible that the user could have created or caused that deletion to occur.
Now,
So it's no evidence tampering. She didn't try to delete it herself because it's not possible she deleted herself. It was one of those auto deletes. Technology working properly, the way technology works, is not evidence tampering. Continuing to use your phone normally after your friend murders her boyfriend is not evidence tampering.
Analysis and testing a review of the extraction in this case. Did you have occasion to review an affidavit of a Mr. Richard Green?
I did, yes.
And what, if any, opinions or conclusions do you have as to that affidavit?
I had issues with several of the statements being made as part of the affidavit.
And what issues were those?
Namely, it specified that Cellbrite report identified that the search was conducted at 227.40. And as I've explained, I believe the tab took focus at 227.40, not when the search occurred. The report mentioned that Cellbrite report identified it was deleted by the user. We don't do that. We'll tell you that a record is deleted, but we don't specify how the record was deleted. That's something for the examiner to determine. I forget. Oh, and then there was a mention of the purpose of the browser state database. The explanation given was correct for iOS 14 and below, but not for 15 and above, which is relevant in this case.
Now, you mentioned this issue as far as coming up, obviously, in this case and some other instances, phone calls or inquiries that you received from Austria and other places. What, if anything, have you or your company, Cellbrite, done with regard to rectifying this issue?
Well, I'll allow it.
Okay. We recognize that this timestamp could be misleading. Regardless of how we label that timestamp, the very fact that a timestamp is there we feel would be or potentially misrepresented. So the decision was taken to remove the timestamp altogether from that information. So now we show the web page was visited, but we don't attribute a time to that purely because it could be wildly inaccurate.
Your Honor, this may be the appropriate time for the instruction.
Okay. All right, so jurors, we're about to see a demonstration by Mr. Whitman. It's simply a demonstration to help you to understand the evidence that you've heard. It's not evidence from this case, but it helps you understand the evidence in this case. You must decide this case based solely on a fair consideration of the evidence and nothing but the evidence. But this is a demonstration to help you understand that evidence. Yes.
All right. So, like I said, he's got the laptop in front of him for a reason, so he can demonstrate how he came to the conclusion. But that's not evidence, because only the evidence is evidence. This is merely a demonstrative. This is showing how he analyzed the evidence. So, still very valuable.
And so to that point, Mr. Whitman, were you able to prepare a demonstration in regard to what you've been discussing through the course of your testimony?
I was, yes.
And that demonstration doesn't specifically reflect on searches or the extraction report that you looked at in this case, correct?
Correct.
But as far as the overall issues that you've been discussing in your testimony, correct?
That's correct.
And with court's permission, may the witness now illustrate that.
Yes.
Okay. So first of all, on the left there, you can see a screen of an iPhone, and that is a phone that I have in front of me live. It's just demonstrating what I can see on the phone. This is my
Ottawa.
tool. And the feature which I continuously use this tool for, which is not available really in any other vendor tools, is the ability to create a live connection between my computer and the phone. The live connection is what I've just started here, and what's going to happen is all of the files and folders that exist on the phone will be mapped to my computer so that I can navigate it. I can look around and I can take a look at near enough live records on the device. Prior to the availability of this tool, I would have to test a theory on a phone, do an extraction, and then pass the extraction, which could take anywhere between 20 minutes and several hours. The reason that I'm using this tool today is because I can do those same tests within 10 or 20 seconds, typically. So I just need to wait for this section to do. So it's already mapped out all the files and folders. It's now asking for a few important pieces of information, which it will then populate on the screen. So information such as the device, serial number, etc. What we're interested in, though, is the browser state record. So I can go to the browser state database and take a look at that and open that up. And you can see that at this moment in time, I have no records in the database at all. If I go back into the live view of the phone, you can see I have Safari open from last night. So it's been sat in the background overnight and not doing anything. But at 10 past 8 last night, I performed this search in a brand new window. So started Safari, opened up a new tab, immediately searched for new tab at 2010 on the 16th of June. If I now search...
That's the convention my brother goes to, working data security.
For the time right now, 1442. What I can do is go back to my RTX tool and press this reload button. That's going to delete the database from my computer only and copy the most recent copy of the database and WAL file from my phone back to my computer, where it shows me I still have no records. That's expected behavior because at the moment I've not closed the tab. So if this again was iOS 14, there would be a record there to say what tab I had open, but iOS 15 doesn't work that way. If I now go back to my tabs and actually just close this window, I can go back into RTX.
Well, I think more importantly, he'll ask, did you find any nudes?
And hit reload again. And we now see we have some records. I can look at this particular record and you'll see the title is 1442 Google search. You'll see the Google search record here. So I just need to change the time zone as well to Eastern time. So you see it's the most recent search which I conducted, the 1442 search. The last viewed time, though, still shows as 8:10 p.m. last night, because that's the time that the tab was focused, not the time that the search was conducted.
Thanks. Want to have a moment, John?
Yes.
Thank you, sir. I have no further questions.
Okay, Ms. Tinetti?
Thank you, Ron.
The thing is, Anne, she didn't delete them. From his testimony, they were auto-deleted. She couldn't have physically deleted them. is my takeaway from the testimony. So, yeah. So when exactly did she delete the files? Never.
Good afternoon, Mr. Wilson.
Good afternoon.
Sir, you had spoken a little bit about what was your assignment here in terms of the data that was sent to you. And I believe that you testified regarding that 2:27 a.m. or 2:27 and 42nd a.m. timestamp that it didn't make sense to the investigators, correct?
Correct.
Were you told that one of the investigators was Trooper Michael Proctor?
I don't recall any names being mentioned. The ticket came to me, or the request came to me via another Cellbrite employee who'd been asked about this case and asked whether we could offer any help.
Okay, thank you. You would agree with me that when you're making or doing a simulation, you want it to be as close to an apples-to-apples comparison as you can get?
As best possible, yes.
And to get truly accurate research results, you want to eliminate as many variables as you can, correct?
Correct.
You wouldn't, for instance, want to use an Android operating system to try to replicate the activity from Jennifer McCabe's Apple iPhone, correct?
Correct.
What version of iOS did you use for your testing of Jennifer McCabe's data?
So this test has been undertaken on various different versions of iOS, from iOS 12, 13, 14, 15, 16, 17, and most recently on the beta version of 18 last week. This particular demonstration was on 15.8.2.
Okay. And you're aware that we said 15.8.2.
Correct. I've also tested on 15.7.
Oh, fair enough. You're aware, however, that Ms. McCabe was using iOS version 15.2.1, correct?
Correct.
And you would agree that the way that an artifact is stored would depend on the iOS version that you use, correct?
Correct.
And your simulation did not use the iOS version that Ms. McCabe was running on her iPhone, correct?
Correct. I used the closest version I could find.
So I'd like to ask you some questions about the characteristics of browserstate.db-wall in record number 4028.
Okay.
That record number, we testified, was found to be deleted, correct?
Correct.
But you were able to recover the date and time associated with it, correct?
The date and time of the last viewed?
Of that record number.
Yes.
And what was that date and time?
2:27 and 40 seconds a.m.
You were also able to recover the content of that particular Google search itself?
I was able to recover the URL for it, yes.
Okay, and what was that Google search?
Hot long to die in the cold.
And it's true, however, that the session history could not be recovered, correct?
That's correct.
Now, given those characteristics that you've just discussed, did your testing result in a WAL file record, a WAL file record, that matched the characteristics of 4028? In other words, deleted with session history not recoverable?
The issue with the session history, I was able to recover only the first page of session history. What happens is when there's a large amount of data that's split over multiple pages, if it's a live record, all those pages point to each other so that you can chain it together and get one large amount of information. Once they've been deleted, some of those pages can be overwritten, and therefore the point.
And that's what I was thinking, Vince, when he brought that up. Oh, you used 15.21 instead of 15.22? How dare you? And it's like, so they probably fixed a bit of code. Like, how big a difference would there be? I didn't say anything because what I wanted to say was big fucking deal, but yeah.
Pointers don't make sense anymore. So the amount of information in this session was way larger than one page, and I wasn't able to recover anything further.
Okay, and you'd agree that the simulation was done using a different operating system, correct?
Correct.
Were you able to recreate the other deletions that appeared before and after that record 4028?
Which deletion, sorry?
Well, you would have testified, I believe there was an exhibit that was introduced that showed that there were multiple deletions both before and after, correct?
Correct.
Were you able to recreate those deletions?
When I manually deleted records from the history, then the records also were deleted from the browser state.
Now, I believe that you testified, and if you didn't, I believe it's in your report, that there are essentially 5 mechanisms for record deletions in the browser state database, correct?
Correct.
You ruled out 4 of them pretty quickly, correct?
Correct.
And I believe you testified to that today, correct?
Correct.
The only remaining option was selective deletion by a user, or there's some internal mechanism for record deletion that is not fully understood, correct?
Correct.
All right. And you know of, as you testified today, you know of no internal mechanism for record deletion that's not fully understood, correct?
I've not been able to replicate that function, no.
All right. If there is no unknown internal mechanism for record deletion that's not fully understood, that would leave selective deletion by a user, correct?
Not in this case, no.
All right. Well, selective deletion, you would agree, means that a user selects what to delete, correct?
Correct.
And regarding the user, the term user, what is that? Who is that?
Whoever's using the phone at the time.
Okay, so it's actually somebody who is using the actual iPhone itself, correct?
Correct.
Not necessarily a computer expert, correct?
Correct.
Would you agree with me that somebody who had access to the data before it was extracted and sent to you could have made selective deletions of the data?
Objection.
Oh,
no, I don't.
Are you aware of an app called MySQL?
Yes.
What is MySQL?
MySQL is just a method for viewing SQLite databases.
All right. If someone had access,
the mastermind Jen McCabe. Yeah, this is nonsense.
To the raw data, before it was sent to you, and use that app, they could make selective deletions of the data, couldn't they?
I assume you're talking about opening up the extraction, taking out the particular file and editing it?
I'm sorry, I interrupted you. You're right, I apologize. And I apologize to you. If you could restate your answer.
Oh, fuck off. You intended to interrupt him. You didn't want the jury to hear his smart answer.
Give me your full answer.
Okay, so it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would, it essentially hashes the original data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Would you agree with me that someone with access to that data in an appropriate application or program could also delete and renumber history.db and knowledge.cso so that it would appear as though there was no break in the numbering, so that it would also appear that nothing was deleted?
Yeah. They come up with the brilliant cover-up for Huslong to die in cold, but dump the body on the front lawn. Brilliant conspiracy there. Brilliant.
It's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected.
Thank you very much, sir.
Mr. Lally?
Any discrepancy between the iOS version and Ms. McCabe's phone and the iOS version in the demonstration that you did, what, if any, impact does that have on what you showed this jury?
So in this particular case, every iOS version that I tested, as I mentioned, from 12, 13, 14, 15, 16, 17, 18, the timestamp is always referring to the time that the tab took focus. So even though there are some differences with when the record's created.
So basically, within the minor update, Yannetti indicates there'd just be a huge difference using 15.21 versus 15.22. But he says, well, I tested 12, 13, 14, 15, 16, 17, and the beta for 18, and they all worked the same for me. But that one little incremental update, that's what killed it.
The meaning behind that timestamp has been consistent.
And what you were asking about what you were asking about in regard to selective deletion, you indicated that there's no evidence of that in this case. Is that correct?
Correct. Selective deletion would require that the record existed in the history database in order to be selected to be deleted. The fact that there's no missing records indicates it was never written into that database and therefore could not have been selectively deleted.
Now, the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things. Did you see any evidence of that in review of the extraction of Ms. McCabe's phone?
I didn't have access to the hash information to see whether any changes had been made. That's something that the original examiner would have had access to. From my point of view, there was nothing in there that would indicate that tampering had occurred. The timestamps all made sense for the files. The historical pages all made sense. So it's probably possible, but it would take a large amount of skill to do.
Now, with regard to your analysis and your testing in this case, again, what is your opinion or conclusion as to when these two Google searches were conducted?
I'm of no doubt that the only time those two searches were conducted was at 6:23 and 6:24 on the morning of the 29th.
And once again, none of this would be an issue if Jen McCabe took my advice, that admittedly came in the future from when she did this, but don't hand over your phone. Fuck you, get a warrant. Say it with me now. Fuck you, get a warrant. You cannot have my phone.
Further on. Prior to today, have you ever heard of spontaneous deletion?
It's not a term I'm familiar with.
Thank you.
All right, sir, you are all set. Thank you very
Thank you.
much. Do you need a couple minutes to take yourself
Is that like spontaneous combustion? What's she smiling about? Did she think that went well for her? Did she think that went well for her? Why is she smiling? And the jury's still
All right,
in.
Mr. Lally, next witness, please.
Yes, Your Honor, call Trooper Nicholas Carino to the stand.
Like she's not even trying to hide it. The jury is still in, and she's smiling as if that went well for her. She's delusional. She's delusional. Wow.
I should give the court during the case out here. The truth, the whole truth, and nothing but the truth. So help you God. Yes, sir. Thank you.
Yes, ma'am.
Okay. See you now. Good afternoon.
Good afternoon, sir.
Good afternoon, sir.
He looks like one of my undergrad finance professors. CJ5, good morning over there in the Upside Down. I hope Wednesday is a good day.
Could you please state your name and spell your last name for the jury?
Yep, Nicholas Guarino, Guarino.
And how are you employed, sir?
I work for the Massachusetts State Police.
And how long have you been a member of the Massachusetts State Police?
This is my 9th year now.
Now, prior to working with the state police, what, if any, prior experience did you have in the field of law enforcement?
I was a local police officer in Norwood for almost 11 years.
Now, with respect to your role within the state police, where is it that you work now?
I currently work at the Norfolk District Attorney's Office.
And within the detective unit, is that correct?
Yes, that's correct.
And with respect to that, what, if any, specialized role you have within the detective unit attached to the Norfolk DA's office?
I conduct cell phone forensics, computer forensics, and I also do sexual assault investigations.
Of course, like as a 20-year law enforcement officer, I have a feeling most of the shaved head brigade, it was a matter of pride. Why would you shave that head of hair in your 40s or even 50s? You wouldn't.
Now, with regard to the electronic forensics, what, if any, specialized training have you received in that particular area?
I have about 300 or so hours at Cellbrite, CCO, CCPA, cell phone repair forensics, Berlin motor vehicle forensics, Axiom magnet cell phone and computer forensics, X-Ways. These are all different programs used for cell phone and computer forensics.
Now, sir, at some point, did you become involved in the investigation involving the defendant Karen?
Yes.
And with respect to that, let me just ask, at some point, did you become aware of an affidavit from a defense expert named Richard Green?
Yes, I have.
And sometime following that, did you have occasion to reach out to Cellbrite with regard to what had been a part
Okay. Now I'm understanding where Edwin got the affidavit. So the defense expert Green would have to testify, but this is kind of what I've termed the pre-buttal witness, where the prosecution gets the affidavit, they get the summary from defense expert witness Green, and have their own witness review that and say, yeah, so he's going to testify later on about this. Here's why it's wrong. So that's where the affidavit comes up. So when you mentioned affidavits, I thought you meant like in lieu of his own testimony in the future. That wouldn't be allowed. Here, testifying about why his future testimony is wrong based on an affidavit, fine.
Stated by Mr. Green in regard to two Google searches contained within Jennifer McCabe's phone.
Yes, I did.
And eventually, at some point, did you have occasion to speak with the gentleman who came in here right before you, Mr. Dean Whiffen?
Yes, I did.
So that wasn't Trooper Proctor that had reached out to Mr. Whiffen or had any communication that you're aware of with Mr. Whiffen, correct?
No, I reached out after the defense experts' findings were released, and I read his report.
And did you also have occasion to review a report from Ms. Jessica Hyde?
Yes, I did.
And with respect to those two reports, what, if any, conclusions or opinions did you come to independently in relation to those opinions of Ms. Hyde? Objection.
Sustained.
Now, Trooper Garino, you had mentioned that you've had specialized training in regard to something called BURLA, correct?
Yes.
Could you please explain to the jury what BURLA is and how is it used in criminal investigations in your life?
So BURLA is a specialized hardware and software used to download the infotainment and telematics modules in a vehicle. So telematics module is basically like the SIM card for the car. And the infotainment system is your radio head unit that enables you to have Apple Play, CarPlay, or Android or Google Play for the vehicle.
And at some point, you made aware of a search warrant that was authored in regard to seizing the infotainment system from Ms. Reed's vehicle.
Yes, sir.
And just so the record is clear, can you describe Ms. Reed's vehicle as far as what type of vehicle we're talking about?
Yes, it's a Lexus LX 570 SUV.
And specifically on February 2nd, 2022, did you have occasion to remove that infotainment system from the vehicle pursuant to that search?
Yes, I did.
And once that item was removed from the defendant's vehicle, what, if anything, did you do?
After we removed it from the vehicle, it was brought back to Norfolk DA's office for data extraction or attempt to.
And that data extraction, if you know, based on your training experience, sort of how is that conducted, or what is the process of extracting data using BURLA?
So depending on the system, it's dismantled. They have the specialized hardware that actually goes on to the motherboards of these systems.
So this is testimony I've been looking forward to. Hopefully, it's better than Trooper Paul's was, because that was a disaster.
And we're able to pull the data. Or the other option, if that's not viable, is to do a chip off where we have to basically destroy the motherboard and take the memory chips off the devices to try to get the data that way.
Now, with reference to this specific device, what, if any, efforts did you undergo in order to extract the information without using the chip off?
So at the time that we pulled the system, it was not supported. I emailed BURLA and called them, see if they had a timeline of when this might be supported so we could get the data. We deemed chip off last support, as a last resort, because it is a destructive process. So once those memory chips are taken off, the likelihood of trying to reattach them and get it to work again is very slim.
Let me stop you there for a second. When you talk about an item being supported, what does that mean?
Whether or not BURLA has the ability to pull the data from that vehicle.
Well, not just texts. Did she have GPS synced? Like, are we going to get some GPS data? Could be interesting.
And how is that sort of determined, or how are you able to ascertain whether or not a particular vehicle, make, model, manufacturer is supported by the BURLA device?
They have an app, and they also have the tech support. But if you put in the VIN of the vehicle, or if you don't have the VIN, you have the make, model, and trim level, like limited or XLE or whatever, you would be able to go in and look it up and basically say, BURLA will tell you, yes, it's supported for GPS points, or it's supported for diagnostic data, or whatever that they're able to get out of the vehicle. And they work with the automakers to get these get this data. So,
and approximately how many different types of if we're looking at sort of the entirety of different makes and models of manufacturers, if you know sort of what percentage of those types of vehicles are actually supported and BURLA can actually extract information?
I don't know as of right now. It's a lot, and they're constantly updating it, so they are able to do more vehicles as time goes on.
Now, at this particular time, as you sit here today, June 17, 2024, the vehicle the defendant was operating on January 29, 2022. Is that vehicle available or supported by BURLA at this time?
The trim level that the defendant had is not still supported. There is Toyota and Lexus support now, but it's not, unfortunately, for per model.
Now, you mentioned that you had reached out to the Burla company for updates as far as the availability or when the defendant's vehicle might be supported. Is that correct?
That's correct.
And about how many times and over what time period are we talking about that you reached out to ascertain?
Immediately when I did the extraction, I should say extraction, but when I took the system out of the vehicle, I had to reach out to Burla because where it wasn't supported, they actually had to send me tech diagrams so I could go in and, again, not destroy the whole vehicle as I just took those components out. Over the next, almost 2 years, year and a half of going back and forth with them with their support and their sales team.
And when you say going back and forth, how often, out to them, or how often were you getting a response in regards to the Burla?
Usually every few months, I want to say every 3 months, give or take. I forget the exact number, but phone calls or an email to them asking.
Now, beyond that, are you familiar with a national cybercrime?
I mean, absolutely, they're federally mandated. A 2021 Lexus, it would be illegal for it to be sold without a backup camera. Now, whether that saves any of that as a recording, I doubt, but it has to have a backup camera.
Conference?
Yes.
And do you attend that on an annual basis at least?
Yes, I do.
And with respect to that, what, if any, time at those conferences did you spend dedicated to ascertaining the availability or the supportability of this vehicle with reference to Burla?
So Burla has a booth at the National Cybercrime Conference. I spoke with their sales team there. Their response was to keep calling Burla, keep pestering them, and they might actually get the support sooner than later.
And again, were you ever able to ascertain or get the support to download the information from?
No, unfortunately.
Now, at some point, were you able to download any information from that particular infotainment system from the defendant's vehicle?
Not from the infotainment system, but Burla released a new item similar to a mechanic scan tool. It plugs into the OBD2 port, which is underneath the dash. So basically, if a mechanic went in there with a scan tool to tell you why you have a check engine light, this does something similar. So you plug it in, and then it pulls the car diagnostic data from that.
And as far as the data that you receive from that, what, if anything, did you observe?
Again, I got a series of 14s was the numbers. There was no readable data. I reached out to Burla and asked them, I said, is there a reason why it pulled this data, but when I put it into the software, it's not telling me anything. It's not giving me any readable data. And they said they know it is diagnostic data, but they haven't got anything from Lexus to say these 14s, these codes mean this. Oh, they only know it as emissions.
So was Burla itself able to read that information and transform that?
And that's good memory, Jennifer. Trooper Paul did demonstrate that the backup camera was working when he did his tests. That was on Friday in his direct. The question, of course, is, was it blocked by snow? Does it record? Last 5 backups or whatever, last 5 times in reverse. I doubt it, but sure would be nice.
Binary code into any sort of readable data for you.
Other than the number 14, no.
Now, from there, what, if anything, did you do with regard to the Burla defendant's vehicle?
It was placed back into our digital evidence lab, and then we did eventually do a chip off to the device.
Now, with respect, to the chip off, that was done sometime in December of 2023. Is that correct?
Yes, that's correct.
And again, if you could expound upon a little as far as, can you describe for the jury sort of the chip off process, why you were reluctant to do it, and what's entailed in it?
As I said before, it is a destructive process. As soon as we do it, we take those memory chips off. It's applying extreme amounts of heat to the motherboards to take the memory off. That'll heat it. You lose a lot of the soldering and capacitors, anything that's on that motherboard. So, like I said, once the memory chips are taken off, it's going to destroy the board.
And as far as that chip-off process, who, if anyone, was present with you, or who, if anyone, assisted you in removing that or conducting that chip-off process with regard to the motherboard from the entertainment system from the defense vehicle?
For those of you interested, my dad worked for Fairchild, well, National and then Fairchild Semiconductor for 25 years making computer chips.
I'm sorry, at the time that we actually did the chip off? Yeah. It was myself, AG Speak, and Maggie Gaffney.
And who is AG Speak?
AG Speak has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
And who is Ms. Gaffney?
She was a defense's expert She's the one who actually did the chip off, applying the heat and taking the chips off.
Did Karen respond, "Ooh, I'm an expert at that"? Oh, shit. Shouldn't have said that.
In our presence. And she, I believe, works for, I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no data that was recovered off the infotainment system or the
Fairchild flavor. Mostly 8-inch wafers, I think.
telematics module from the chip off.
And as far as Ms. Gaffney, did you have any conversation with her as far as the information that she was able to glean or read or decipher?
No, once she did the chip off,
yes.
I've not spoken with her since.
Have a moment, John.
Yes.
That's a good call, Edwin. I said he looked like one of my undergrad finance professors. Scratch that. He's a young Dick Van Dyke.
In late January, early February 2020.
I bet he can sing better than Dick Van Dyke. Better English accent, too. Better Cockney accent.
Were you provided with some a laptop and or desktop computers from the home of Mr. O'Keefe?
Yes, I was.
And what, if anything, did you do with those?
One was a Dell laptop. The other was a HP all-in-one desktop. I removed the hard drives from both systems and used...
Objection may be seen, Your
Okay.
Trying to see if any of the wafers are in here. I don't see any. Well, what my dad would do is, you know, they'd regularly scrap batches of wafers that just for some reason didn't pass quality control, or, you know, they'd made an error. And each lot that they discarded was potentially tens or even hundreds of thousands of dollars, because you're looking at thousands of chips per wafer. And my dad was always like, fuck it, these things are neat. I'm not throwing it in the trash. I'm taking it home. It's garbage anyway. And over his career, he took home hundreds of wafers. He took a few like chips that were cut and put in the little centipede housing, but he'd take them home over the years, and so he's got, I think, everything from 4-inch up to 12-inch wafers, and that they come in all different patterns, and some are really neat, and they're mostly silicon, but they do, like, some of them are etched in gold on the back, and like they're like literally the designs are really neat. And my dad has been looking into selling these because he looked on eBay, and some of them sell for quite a bit of money. And you may remember me, that miscellaneous piece of plastic in the evidence that I said, well, that looks kind of like a clamshell CD case. The reason that came to mind is because I ordered my dad 100 clamshell CD cases as potential, you know, shipping protectors to send those out. And yeah, and I hear 4 inches is an awful lot. At least.
You are unmuted. All right, Mr. Lally, you can continue.
So, Trooper Guarino, there was a Dell laptop and an HP Pavilion all-in-one desktop, correct?
Yes.
These were taken from Mr. O'Keefe's home, is that correct?
Yes, they were.
What, if anything, did you do with respect to those?
As I said, I took the hard drives out of both machines. They were imaged, and the images were loaded into Axiom to view the data that was on them.
Now, when you say something was imaged, can you explain to the jury what you mean by that?
It's a bit-for-bit copy of the hard drive. Instead of us turning it on and going through it, which would change data, by taking the hard drives out and imaging them, it creates a one-for-one copy, so that way we can view it without changing anything in the system.
And you mentioned a tool called Axiom, is that correct?
Yes.
And can you explain to the jury sort of what is that Axiom tool and how does it work?
Yeah, it's another forensic tool that we use. Can do cell phones, computers. You'll use it to load the images so we can view the data.
And with respect to the imaging that was done with regard to the Dell laptop and the desktop, what, if anything, was it that you were looking for specifically on those devices?
We were looking for a Ring video to see if either computer was used by Officer O'Keefe as a login machine to handle the account.
And from your review of what was extracted or imaged from each of those respective computers, what, if any, information were you able to glean in reference to Ring.com or anything else?
Neither computer was used. One appeared to be used mostly by the kids, and the other, I believe, was the laptop, was used mostly by O'Keefe, but there were no Ring logins.
Okay.
As far as the Ring connection, what, if any, devices were you throughout the course of the investigation?
So we still don't know how Ring videos supposedly disappeared.
Were you able to ascertain were actually connected to the Ring cameras at Mr. O'Keefe's house?
Officer O'Keefe's cell phone.
Now, if there were any other devices, whether they were Mr. O'Keefe's or someone else, ascertained from either.
You'll notice the trooper, Officer O'Keefe, not Mr. O'Keefe, not the victim, Officer O'Keefe. That's a conscious choice he's making.
The Ring footage or the information provided by Ring, whether or not there were any other devices beyond Mr. O'Keefe's cell phone that were linked to that account?
Not that I know of.
And I'm sorry, just not that there weren't any devices or not that you could tell?
Not that I could tell or that I ever heard of.
Now, Trooper Green, let me ask you some questions in general about a cell phone extraction. Are you familiar with that term?
Yes.
And can you explain to the jury sort of what is involved in that and how cell phone extraction is performed as far as your experience with regard to investigations that you've been involved in?
Yeah. So most investigations, we get the cell phones from the scene, from a suspect, from a victim. They're put into airplane mode to preserve the data. So that way remote wipe can't be sent to the phone from iTunes. If we can't put it into airplane mode, we'll put it into a Faraday bag, which blocks the cell phone signal. And then it's brought back to the lab and put into a Faraday box, which has electrical outlets inside of it. So that way we can keep the phone charged.
And with regard to this investigation, involved in
That's interesting. I never thought of a Faraday box with electrodes, plugins inside. Keep it charged, but keep, delete laws from trying to tamper with it when it's in evidence in Ironton, Ohio, for example. Of course, then I worry, hey, is that plugin, is there any connection, or is it just electricity? Because kind of defeats the purpose of the Faraday if it's a standard USB. So hopefully whoever designed the Faraday box thought of that.
The extraction of data or the examination of extracted data from a particular phone?
Yes, I did John O'Keefe's phone, Karen Reed's phone, and we had two witnesses' phones, but I don't remember doing the extractions themselves.
But as far as the data from those phones, have you had a look at that data specifically? I'm asking about both Jennifer McCabe's phone and Miss Carrie Robertson.
Yes, I have.
Now, we also at some point provided.
Fuck you, get a warrant.
From Brian Higgins' phone?
Yes, I saw screenshots of text messages.
And from the material that you were provided with reference to Mr. Higgins' phone, were you then able to cross-reference that eventually at some point with respect to the information in both Ms. Reed's phone and Mr. O'Keefe's phone?
Yes, I was.
From what you reviewed, was the information contained within the material provided by Mr. Higgins, was that consistent with what you observed in Ms. Reed's phone as well as Mr.
Yes, I didn't see any differences in those messages.
Now, with respect to starting with Ms. Reed's phone, that was received by you on January 29, 2022. Is that correct?
That's correct.
And do you recall about what time it was and where you were when you received that phone?
I want to say 6 or 7 o'clock at night at the Norfolk DA's office.
And who did you receive that phone from?
Trooper Proctor.
And with reference to that phone, what condition was it in at the time as far as you referenced the airplane?
Yep, we mentioned that, Sinclair, before you got here today. It was mentioned DUI guy is splitting his time between this DUI and the Timberlake DUI because, you know, lots of DUI news to cover today.
Airplane mode, Faraday back, things of that nature. How was it sort of when you received it?
I believe it was in airplane mode. The phone was in good working order. And it was placed downstairs in our lab, plugged in to keep the phone battery charged.
Now, the same with respect to Mr. O'Keefe's phone. When and from whom did you receive that, and what kind of condition was that in when you received it?
I also got that from Trooper Proctor at the same time as Miss Reed's phone. Same condition.
Now, with respect to the defendant's phone, the time that you received it, did you have any passcode or any way to get into the phone?
I'm sorry, who's...
And I mentioned being curious about the dash cam footage, if it's been released. But TMZ has security camera footage of Timberlake's BMW driving down Sag Harbor Drive before his DUI arrest. So fun stuff, fun stuff. And yeah, if you drink, don't drive. It's a scumbag move. Uber can be a ripoff, but it's convenient and easy. Do that instead. Like, even at surge pricing, Uber is cheaper than I am. You know, here in Salt Lake, if you come to me with your first DUI, you're paying me several $1,000s. You're paying several $1,000s in fines. You are paying several $1,000s in ignition interlock charges over the time period you're ordered to have that. You are paying several $1,000s in what was the last thing? So several thousand to me, fines, insurance. Your insurance is going up by several $1,000s, and ignition interlock. You know, even at surge pricing, if you pay $100 for a Uber at surge pricing, that's still cheaper than $10,000 for a DUI. You know, I'll happily take $3,000 or $4,000 from you and call you a scumbag, but use Uber instead.
Phone.
It's Reed's phone.
No, the software we use to try to bypass passwords to be able to extract the evidence, or I should say the extraction of the data to look for evidence, her phone at that time was not supported.
Now, what, if anything, did you do with her phone in regard to that?
Again, made sure it was in airplane mode and just kept it plugged in until such time as the phone was supported, and then we could download it.
Familiar with the device called a Gray Key?
Yes.
And can you explain to the jury what that is, and what, if anything, you did with regard to the defendant's phone and the Gray Key phone?
So Gray Key is, again, specialized hardware and software used to plug in the phones, can do Apple or Android phones to bypass passwords.
And how does that sort of function, how does that work as far as when you hook something, a cell phone or a cellular device, up to a Gray Key tool? What is it doing, and how does it work?
If I knew that, I'd be a millionaire. But it basically installs software onto it, and instead of when you put in 10 passcodes to an iPhone, on the 10th one, if it's wrong, it kills the phone forever. This has some secret software that's able to bypass that and basically keep hitting the phone with passcodes until it finds the right one.
So you may remember me explaining, I think it was during this trial, it might have been on a previous thing, but when I was in law school, so this was spring 2016, in my international business transactions class, we had the general counsel for one of the big tech companies, not Apple, not Samsung, but it was, I think, Intel. And he was a graduate of my law school. And so he came and spoke to my class. And at this time, Apple, within the last couple months, maybe a year, had just released a new iPhone, whatever was released prior to spring 2016. And the FBI was really trying to get Apple to give them a backdoor to the iPhone. because they were struggling to get in. And I can't remember, it was a big high profile case that the FBI was trying to crack that iPhone for. Now, we'll say Intel, might have been Hewlett Packard, whatever. The general counsel told us basically that Apple really would be happy to give the FBI the back door to the iPhone. They don't actually care if the FBI has it, so long as, they can't just use it willy-nilly. They have to get a warrant. They'd be happy to jailbreak a iPhone for them. The reason they wouldn't, though, is because Apple wanted to continue doing business in China. It's kind of a big market for them. And so it was a signal to the Chinese government, hey, look, all these iPhones that we're selling in China, we're not giving the US government a backdoor to jailbreak all these millions of Chinese iPhones that we're selling. But it was also a signal, we're not going to let China have a backdoor either. And so that was the actual big non-public reason that Apple had for refusing. And he said that it had never been said publicly, it wasn't in the media or anything, just that the FBI wanted them to break it. But he's like, Silicon Valley, as big as it is, there's only a handful of massive companies in Silicon Valley. And so there's only a handful of general counsel for massive Silicon Valley companies. And we talk. We go to lunch. We shoot the shit. We know why they're doing what they're doing. And so I thought that was real interesting, and just him talking about the jailbreak software that they use that spends a long time going through all the code combinations to try and jailbreak the iPhone. That's why. But I better hit play before, people come in and yell at me for chasing squirrels, even if it's, relevant.
So it essentially runs a bunch of different combinations of passcodes into the phone until it comes up with one that actually opens.
Yes, that's correct.
And at some point, did the Great Key device actually break into the defense phone?
Yes, it did.
Do you know about when that was in relation to when you received it?
Yeah, so we got the phone in January. It took, I believe support came out in, I want to say May or June, I don't remember the exact month, but we didn't actually get the passcode until August 16th of 2022.
And once that passcode was actually broken into by the Great Key device.
And I was right. It was Intel. The general counsel's name, Steve Rogers, not Captain America. Completely different build from that Steve Rogers.
Then you're able to look into the phone, is that correct?
Yes. Once the passcode's obtained, we download the data, and then we're able to take that extraction data and then open it up in Cellbrite or Axiom or whatever tool we're going to use to view it.
And the tools, as far as you're referring to,
I
Cellbrite and Axiom,
agree.
are you familiar with those tools through your
I
course
agree.
of your investigator with regard to electronic devices?
Yes.
And if you could explain to the jury sort of when you say Cellbrite and Axiom, as far as then tools are concerned, how do they work and sort of what is it that you do with the device with reference to Cellbrite?
So what do we do with the extractions once we go to open them?
Well, how is the information extracted, first of all, and then what, if anything, do you do with that?
So Great Key will pull the extraction. Well, it just, once the code's received, it again uses its software, pulls the data out, puts it into an encrypted, it's MD5 or SHA. It's an encryption key that has, it's a unique key that, so if you change anything inside that zip file, it would change the encryption number to show that something was tampered with. We take that encrypted zip file and we open it up in the software, and that's able to say, the call logs, the chats, the photos, the whole timeline of the phone.
Now, in addition to yourself, is there anyone else that works in this sort of capacity within your unit at the district attorney's office?
Yes, 2 other people.
And who are those 2 others?
The director of our lab, Samantha Vogt, and Trooper Connor Keefe.
Now, beyond yourself, Trooper Keefe and Ms. Vogt, anybody else from the detective unit, as far as troopers, would they have access to these devices, being defendants, Mr. O'Keefe's, Ms. McCabe's, or Ms. Roberts?
If they're in the digital evidence lab, no. Once the data is extracted from them, normally we give them back to the investigator or return to family. So that would be the only time that they would have access to the devices, or unless we kept them in the lab for, just for, I don't want to say safekeeping, but just for storage reasons.
Now, with reference to your review of any of the extractions related to any of those 4 devices, at any point in time, did you observe anything?
I assume, CJ5, that's a Captain America reference. Other than the name Steve Rogers, I really don't know anything about it. I'm not into superhero movies. Like, the last Marvel movie I actually sat down to watch was, like, willingly, was X-Men 2.
Reference to any information being taken off or deleted from any of those devices at any point in time?
No, sir.
Now, with respect to Ms. Reed's device, the defendant's device, it was sometime in August of 2022 that the great key was able to break into the passcode and get into the device, correct?
That's correct.
And so then once an extraction is done, that's then subsequently reviewed by someone within your unit, is that correct?
Yeah, so again, normally the investigators for the homicides know far more information about the crime and what occurred. So if need be, I'll load the phone up for them. They can go through it because they know what they're looking for. If they ask me, I'm happy to go through. If they can say, I'm looking for calls between this time period or, GPS locations, things like that.
Now, with reference to the defendant's phone, at some point were you made aware that there was some privileged information contained within her phone?
Yes, I was.
So as a result of that, what, if anything, happened with the phone from there?
We notified our supervisors,
Never heard of it.
and we did not look at her extraction until the privileged communications could be removed, and then we could, again, go back and re-inspect the data.
Now, as far as that whole process that was undertaken in regard to that, how long a time period, or when was it that you were able to have the privileged information extracted and then actually get to look at the defense phone?
It took months. I don't think we got it back from the AG's office until later, I don't know, springtime of 2023-ish.
Now, with respect to the extraction from each of these 4 respective devices, that being the defendant, Mr. O'Keefe, Mr. Caves, and Ms. Roberts, what kind of tools were used to conduct those extractions?
Gray Key, Windows 10, and then Cellware Physical Analyzer and Axiom, their program, Magnets program.
And so as far as, I guess my question is, as far as the different devices that are used, why are there different devices, and what is it that, say, one does versus the other?
So they both do great work with, decoding the data. I've noticed that Axiom does a better job at pulling GPS spots because it gives a speed and a estimated range of how strong the GPS signals are, as opposed to Cellbrite, they give native locations, but they don't have that extra data with it. So I like to look at both tools and make sure that I'm seeing everything that I need to.
Now, with respect to the defendant's phone, you at some points reviewed the extraction from the defendant's phone, correct?
Yes, I did.
And with respect to that phone, what, if anything, did you observe with regard to GPS locations associated with that device?
I didn't see that many, maybe a handful, showing different spots in Canton, but nothing that stood out to me.
Now, with respect to your review of the phone, what, if anything, were you able to ascertain as to whether or not those GPS locations were allowed or permitted or turned off or on by you?
I can't say. I didn't see anything, like I said, that stuck out to me. Normally, if the GPS points aren't there, then location services are probably turned off.
But what I'm asking, though, is the device itself capable of retaining that data as far as GPS locations, correct?
Yes, if it's turned on.
And there were no real GPS locations to speak of that you observed in your review of the extraction of the defendant, correct?
Yes, that's correct.
Now, with regard to Mr. O'Keefe's phone, what, if anything, were you able to ascertain from that as far as GPS locations were concerned?
There's quite a bit, especially on January 29th.
Now, sir, before we get into that, if I could ask you some questions in regards to Mr. Cave's phone extraction. You had occasion to review that, is that correct?
Yes, sir.
And so In regard to that, also, you had mentioned that you had reviewed an affidavit from a defense expert or defense witness named Mr. Richard Green, correct?
That's correct.
And based on your review of that, what, if anything, based on your review of what Mr. Green said or did, what, if anything, did you then do with regard to Mr. Cave's phone?
So I basically went point by point through his report to confirm or deny if what he was placing in there was true.
And what, if anything?
Everything he just said in that report is bullshit, is what he did.
What, if anything, were you able to ascertain or learn from going through Mr. Cave's phone with reference to what Mr. Green said? Objection.
I'll allow that.
It was mostly incorrect.
Hey!
And when you say mostly incorrect,
everything was bullshit.
So he states that there's a Google search that's done at 2:27 in the morning that immediately stuck out to me because when I went back and looked, that file that was parsed was not from the database that should have showed searches. This came from the session state tabs for Safari, which is a big red flag. It also came from a wall file, which is a dropping ground for where data is put before it's actually put into the main database itself. And then once it reaches a certain point, that data is automatically deleted by the device, not by a user, which Mr. Green had stated that a search was done and that was purposely deleted. There was also items regarding phone calls being deleted. Again, they came from a wall file. Looking at it, again, it's stored in the knowledge seed, the main database. It's also stored in the biome, showing in the extraction, which is another storage area that Apple is using. Again, nothing, most of the stuff that I was reading in his report was either incorrectly, I don't know, written down or he's interpreted it incorrectly.
Now,
this guy's a moron.
With regard to the phone calls or the contacts that Mr. Green indicated were user deleted.
By this guy's a moron, I mean Green, not Trooper Greeno.
Deleted by the user. What, if any, information did you look in regard to that? What did you ascertain it from?
Yeah, so he stated that Mr. McCabe had deleted 18 phone calls from the morning after John O'Keefe's body was found. Looking at the data from her call log, those calls, while they do show marked as deleted, again, they come from the wall file and they're also located in two other parts of the database. Again, as a user of an iPhone, you can't go in and just delete these files. They're handled by the operating system. It's impossible.
So as far as what, if any, opinion do you, well, let me ask you this. As far as a wall or a log file, can you explain that, what you understand that term to mean to the jury as it pertains to these particular items?
Yeah. I will only see the dog bite expert if she testifies in the actual trial, because I'm not going to watch the voir dire.
So as I said, these files are dropping ground. So when you're using your apps, using the phone, takes that data, puts it into this wall file until you either close the app or you shut down the phone, or it reaches a certain number of data in the phone. That wall file will automatically delete from the phone. So this can be on a first in, first out basis. Again, like I said, it could be when data reaches a certain level, but those calls that are being marked as deleted, Cellbrite seeing, it doesn't mean the user deleted them. It just means they're being removed from the wall file.
You indicated that from your review of the phone extraction, there were other areas or other databases, bases, excuse me, within the phone that contain that same information.
Yes. So the main database of the iPhones is the Knowledge Seed database. They're also using Biome, and then if you're using the newer software now, it's another area I won't bore you with, but depending on the iOS you're using for the phone, it's going to depend on where that data is being stored.
Now, specifically with respect to Ms. McCabe's phone, one of the contentions Mr. Green had was in regard to a contact for Brian Albert. Is that correct?
Yes, that was another one.
With respect to that, what, if anything, were you able to find within Ms. McCabe's phone in regard to contact information for Brian Albert?
Yeah, so Mr. Green's report said that he located a deleted screenshot of Brian Albert's contact. That was in her phone. The contact for Brian Albert was still in her phone, not deleted. So I don't know, maybe she just deleted the screenshot.
Now, with respect to Ms. McCabe's phone, what, if anything, did you do with regard to the call log history in Ms. McCabe's phone?
I exported it all out to a PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back to October of 2020, I want to say. And phone calls, FaceTime, they're all, the calls are there, all the records, and they're all stored in different areas of the phone. The only ones that show the wall file deleted were the ones from the 29th going up to the end, towards the end of the day on the 29th.
And now with respect to the call history, where or how is that typically stored within an iOS device?
I believe that's stored in the call stored.
If there's that much laughter, it sounds like maybe she shouldn't have been certified as an expert.
SQLite database.
And with reference to what, if any, difference storage-wise is that SQLite database versus the wall?
So again, yeah, that database where the call logs are sent, it's going to have a corresponding wall file where the data is going to be put temporarily. And then, as I said, it gets automatically deleted by the iOS, by the operating software. It's not user enabled.
And so from your review of those 1,104 phone call history records containing this traction of Mr. K's phone, what, if any, opinion do you have in regard to whether or not those items were deleted by any user?
I don't believe they were. And I will say one of the phone calls was from the actual main call stored database. That could have been user deleted but again, it's in 2 other spots in the operating system. So I don't know how or why the iOS stores it the way it does. And then marks what.
Now, sir, from your review of the 4 phone interactions that you reviewed in this case, were you able to export or print certain chat reports from specific people's phones or from specific people's
chat
phones
reports
with other individuals?
Yes, I was able to.
This should be fun.
Your Honor, may I approach?
Yes.
The witness might not agree, but this should be fun. Almost as fun as Trooper Proctor's texts.
Yes.
I want to see the real embarrassing text. Because she deserves that.
Sir, I'm showing you what's been marked as Exhibit 48.
Oh! Did you see the size of that binder for Exhibit 48? Yikes.
You recognize? Do you recognize that, sir?
Yes.
And what do you recognize that?
The first page is Facebook Messenger chats between Karen Reed and John O'Keefe.
Uh-oh.
And what's contained in there, is that a fair and accurate portrayal of what you observed from the extraction from Mr. O'Keefe's phone?
Yes, it is.
And specifically with reference to those chats between Mr. O'Keefe and the defendant, you also reviewed that material from the defendant's phone as well?
Yes, I did.
Material that you reviewed from the defendant's phone, is that consistent with what you observed from Mr. O'Keefe's?
Yes, it is.
Oh, so she didn't delete anything on hers, but not his?
Your Honor, with the court's permission, if I could request certain portions of what's been marked as Exhibit 48 being published to the jury as we go through them.
Okay.
Sir, if I could just start you out on page 1.
Okay.
Just comment if I could have that up on the screen. Now, with respect to what's up on the screen, the portion that you can see, do you recognize it, sir?
Yes, I do.
I will grab it for you as Exhibit 48.
Yes.
Now, within this particular, from the perspective of this is from Mr. O'Keefe's phone, is that correct?
Yes, it is.
So there will be blue bubbles and green bubbles, is that correct as well?
Yes.
And so who, as far as the blue bubbles are concerned, who's speaking in that?
The blue bubbles will be from Ms. Reed, and the green bubbles are from Officer O'Keefe.
Ms. Gilman, if you could please scroll down.
Still with the Officer O'Keefe.
Now, with respect to what's contained on this page 1 at the bottom, if you could read the date and the time and indicate who is speaking and what is said there.
Yeah, so the blue bubbles is Karen Reed and 1/28/2022 at 3:30 p.m. Hello. John says hi at 3:35 p.m.
Sorry,
yes.
He's definitely going to have fun reading all of this.
Those are the Facebook ones.
God, I hope Karen testifies.
What's contained in Exhibit 48 is the entirety of the chat report from Mr. O'Keefe's phone, correct?
Yes, I believe so.
Okay.
And
may I approach, Your Honor?
Yes.
I didn't comment on it, but I was looking at the times, the dates, you know, January 28th, 3 o'clock, 3:30. That's you know, nine hours to go. So
My apologies. Showing you another document. Recognize that.
Yes.
What do you recognize that to be, sir?
These are the native chats, native messages from John O'Keefe and Karen Reed.
So these are just specifically broken down as far as the chats between Mr. O'Keefe's phone and Ms. Reed's phone, correct?
Correct.
And as far as your review of both of the extractions from both of those phones, the material contained within Mr. O'Keefe's phone is consistent with the material contained in the defendant's phone, correct?
Yes, that's correct.
You want to approach?
Yes.
I will proceed to introduce the witness necessary. Okay.
So native files, are those the texts as opposed to Facebook Messenger? We saw
Yes.
Facebook
And that can be returned to
Messenger.
the witness, Your Honor, if we could, with court's permission, if we could publish that.
Yes.
Are we going to be going back and forth to create a timeline? Bouncing between text and Messenger?
Now, Trooper Carino, do you recognize what's up on screen as the next witness, sir? Let's go on, I'm sorry, if you could scroll down just a little bit.
Yes.
And again, from this first page,
Oh.
yes, from Ms. Reed, is that correct?
Yes, that's correct.
Oh. They're all lovey-dovey at the waterfall. 9:49 a.m. on the 28th. Karen says, "You have really hurt me this time." Oh.
Yes.
And if you could, again, read from this first page as far as date, time, who was speaking, and what it said.
At 9:49 a.m., Karen says, "You've really hurt me this time." 10:02 a.m., "I'm sorry. This is, sorry, it's kind of hard to read. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy."
Oh. I assume that's about the kids. I'm tired of everyone else spoiling the kids and that making me the bad guy. Presumably that's about the donut breakfast.
At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time I try to do what is healthy/smart for them. More pointedly, I try to support you in what you need. You just lashed out at me and said terrible things. I don't know how you've gone to this point with me, but I'm just trying to try my hardest. You made the point, I made your point, and continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help."
If I can stop you there, sir. If I can direct your attention to
Sir.
my apologies. Sir, if I can direct you to page 5.
Okay.
I'm sorry, bottom of page 4.
All right.
And starting with the blue bubble on the bottom of page 4, again, if you can indicate as to who's speaking, what is said, and the date and time.
He's going timey-wimey
Karen
now.
says to John at 1:21 p.m. on the 28th, "Maybe you can call someone."
I've appreciated Lolly's very linear nature before, but he seems to be going timey-wimey now, back and forth, and it's going to make me mad.
If you could continue on through page 5, sir.
On the 28th at 1:46 p.m., John says, "Like who?" On 1:47 p.m., "What time are you coming here?" And then there is, at 2:05, there's a message, but no content.
And the next message at 2:06, sir.
Yes, 2:06 from Karen. "I don't know what time, feel kind of out of it, just trying to clear my head." 2:06 p.m., John writes back, "Okay." 2:06 p.m. again, Karen says, "Text me later when you guys settle in later." Sorry, "Text me when you guys settle in later." John says, "Sure," at 2:06 p.m. again. Karen says at 2:16, "I feel pretty shitty about this. Feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said."
If I could ask you to continue on to page 7, sir.
Okay. At 2:17 p.m., John says, "Not sure what else you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it." Karen replies back at 2:17, "Things in my own life have been difficult too, you know." John writes back at 2:17, "I know." At 2:25 p.m., "Tell me if you're interested in someone else. Can't think of any other reason you've been like this." From Karen.
I mean, tell me if you're interested in someone else. Can't think of any other reason you've been like this. As she's been texting with Brian Higgins for the last 3 weeks. Hypocrite much? And tell me if you're interested in someone else, like that bitch that you gave a brotherly hug to in Aruba. Oh.
Good. Continue on to page 8, sir.
At 225, John responds back, nope. Things haven't been great between us for a while. Ever consider that? That was at 226. 229, he writes, kids are here, not in the mood to talk.
And how does the defendant respond to that on the bottom of page 8?
So you're not into it anymore. That's fine, but I don't want to keep trying, and you keep treating me like this. At 2:29 p.m.
If I could direct you to the next page 9.
Ms. Reed says, and you whack me in the face with a pillow at 2:29. At 2:30, she says, last night you're basically like, yeah, what about when we talk about the future? So why don't you just admit you're not into it so much anymore? At 2:30, oh, sorry.
Go ahead.
I was at 2:30, John says, not how it went down, but okay.
Now does Ms. Reed respond to that?
Can you please admit your head is out of the game with us?
Yeah.
Yes, sir. Please continue on to the top of page 10.
That's
at 2:32 p.m. Sick of always arguing, fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. From John.
Yeah. This looks like she's hot and cold and gaslighty and clingy. OMG, stop calling from John. Yeah, this is building up into a motive, possibly.
And then John again at 2:32. Oh my God, stop calling.
Okay, stop you there for just a moment, sir. With regard to January 28th, you were also able to extract a report specifically in regard to calls received by Mr. O'Keefe on that date.
Yes, I was.
I mean, on that date into the next date of January 29th.
Yes.
I approach Ron.
Yes.
Now we get to see how many consecutive calls she was trying to make in that time when he says, OMG, stop calling. And technically speaking, you know, the dream team should have objected, like, you know, when they wouldn't let Trooper Proctor spell out the C word because they wanted the full shock and outrage from the jury. When he said, oh my God, instead of OMG, they should have objected. But yeah, because the text actually said OMG, but the trooper read out, oh my God. And yeah, I'm guessing it's slightly more than 2 calls. But I don't know because this is my first time seeing it. So, but I think Naven does have a point.
We're now showing the document.
I also have a feeling that when this is all said and done, Karen's going to have another one of her deranged smiles as if this went well for her because she's delusional. Exactly.
You recognize that, sir?
Yes, it's John O'Keefe's call log.
Because John
and
was in on the
call log from
conspiracy.
January 28th into 29th. Is that correct?
Yes, from 28th at 9:19 a.m. to the 29th at 6:03 a.m.
May I approach, John?
Yes.
I'm also seeking to introduce the defense next. No objection.
Okay.
What's the issue? Oh, it's just Yanetti's blind.
Can I show you another document? Session review that. Look up when we finish. Do you recognize that, sir?
Yes, this is Karen Reed's call log from January 29th at 12:33 a.m. to January 29th at 6:03 a.m. And those are specifically calls between the defendant and Mr. O'Keefe, correct?
Yes, that is correct.
May I approach again, Your Honor?
Yes.
I'm off the seat. Next exhibit. No objection.
And how many times did she call around 2:30 p.m. the 28th?
Now, Trooper Guarino, from the text messages that you were just testifying from, Mr. O'Keefe indicates OMG stopped calling at 2:32 p.m. Is that correct?
Yes, that is correct.
Now, from your review of those call logs, how many times did the defendant call Mr. O'Keefe on January 28th from approximately 9:19 a.m. to about 2:58 p.m.?
There's 18 calls from 9:19 to about 2:59 p.m.
Those calls are listed
Slightly
within those
more than
records as
2
various
calls.
as far as rejected, or missed, or answered, or things of that nature. Is that correct?
Yes, that is correct.
How many of them are rejected?
11.
Oh,
4.
And how many are answered?
3.
oh.
Now, following that text message at 2:32 p.m.,
You may as well call John O'Keefe Bill Russell, because that's a lot of rejections.
from Mr. O'Keefe, the defendant asking her to stop calling him. Does the defendant keep calling?
Yes, she does.
And at some point, does Mr. O'Keefe call Ms. Reed back?
Yes, at about 3 p.m. on the 28th. Double check.
Thanks.
But Jennifer, she's in control.
Guarino, I can take each of the call logs.
How dare he not answer? She's in control.
Now, so if I can turn your attention back to page 10 on the text message with respect.
Okay, so Mr. Lally, when you put your head down and when you walk away, we can't hear you. And so there won't be a record of this. So you have to keep your voice up. Well, you just said you just put your head down and your voice went down. So keep your voice up. It's really important you do so.
Trooper Guarino, turning your attention back to page 10 of these text messages, which read from Ms. Reed's response to Mr. O'Keefe at 2:32.
And it's because she was a babysitter with benefits. So, yeah.
Yes, so 2:32 p.m. She says, "Why would you start with me this morning?" And then followed up by 2:33, "You're setting me up to fail."
If I could turn your attention to page 11 and ask you to continue from there.
Ms. Reed says, you started a number of fights from your end. John, and that's at 2:33. At 2:33, John writes back, "I've explained it a few times already, not doing it again."
As a defendant respond to that.
So you're not into this anymore. And then John says, "Not into fighting all the time, correct." That's at 2:34 p.m.
If I could turn your attention to the top.
But fighting all the time is what I bring to the table. If you don't appreciate fighting all the time, you don't appreciate me.
Yes, 2:34, Ms. Reed says, "If you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world." John writes back that there's no content at 2:34. And at 2:34, she says, "Then stop starting with me."
How does Mr. O'Keefe respond to that?
At 2:34, he writes back, "I'm not answering, stop calling."
And if you could, if I could turn your attention to the top of page 13.
Ms. Reed says, "Can you please answer after how you treated me earlier?" John responds back at 2:35, "Kaylee is right here." Ms. Reed says, "You're starting a rage with me out of nowhere, and then you tell me you're sick of fighting with me." At 2:35. She writes at 2:38, "I'm going to grab a drink in a bit."
Oh, whoa. Whoa. I'm going to grab a drink in a bit at 2:38 p.m. So, like, we've counted the number of drinks she had at McCarthy's and the Waterfall. Did she do some pre-gaming before? Did she pre-game before McCarthy's? I bet Esty knows the answer. Because, hello. But that's what it looks like to me. And, yeah, wow.
Sir.
She says, "Can you answer, please?" At 2:38. He writes back at 2:39, "No, Karen, not sure why you need to announce that you're going drinking. Have fun." Karen writes back at 2:40, "Seeing if you want to meet me later. Can you please call me?" Right after that.
And again, if I could direct you to the top of page 15.
John writes back at 2:40, "Have to take him to the doctor. He has practice." Ms. Reed writes back, "Yeah, 5 minutes." John writes back at 2:43, "My father just walked in."
Karen writes back, okay, can you please call me for 2 minutes? At 2:44.
The top of page 16, sir.
2:44, John writes back, not right now. Karen writes back, I'm there when anyone else needs me at 2:44. At 2:46, yes, John, you gave me utter grief this morning. I'd like you to call me for a minutes.
And the last one from that page, sir.
Yeah, at 2:47, I've been trying to get over the hump with is arguing, and now you tell me you're not into things. And if you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail.
Sir, if I could draw your attention
Absolutely.
to page 42.
Absolutely.
And sir, if I could ask you to start reading from the top of page 42.
Yep. At 7:41 p.m., Karen writes, okay, let me know if you end up leaving. John writes back at 7:42, why? Now you're not coming? Karen writes back, I'm waiting for the plumber. Actually think he's in the driveway. 7:42. John says 7:43, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. Karen writes back at 7:43, he's not going home after. John writes back at 7:43, 8 on a Friday. He may have to get Michael. And you have a plumber coming over at 8, knowing me and Papa could have handled it. Good luck. And that was at 7:44.
Oh, so he's basically saying, wait, so 8 p.m. on a Saturday, you called a plumber instead of relying on us? Is that passive? That good luck looks more like a fuck you.
If I could direct your attention to page 49.
Okay.
If I could ask you to start from page 49, sir.
8:29 p.m. Yeah, but he lives right down the road. John writes back at 8:30. Karen, this storm is going to be intense. Can't drive. 8:30. She writes back, okay, well, if he can't, he can't. John writes back, I'll do it Monday. Karen responds at 8:31. Ha, I better not still have this problem on Monday. John writes back, plan on being there. Karen writes back at 8:32. I'd like to know, I can take a hot shower here if I need to. John writes back, figured you'd be in Canton until Monday.
If I could direct you to the top of next page, 51.
John, I'm getting off my phone. Let me know what you're doing. Karen writes back at 8:33. I think the four of us together is toxic to this relationship. Would like to limit it. And says, you've said so yourself for probably a year now. And John writes back at 8:30.
The four of us together, is that John, Karen, and the kids? John, Karen, and the two friends that were at McCarthy's? Who's the four of us? Who's the four of us? And that, like, this explains Karen showing up to the guys' night out. It's, please, I need a ride. You promised.
33. Blizzard tomorrow. Nobody is going anywhere.
Sir, if I could direct you to the top of page 52.
Okay. Karen says, maybe I'll come back late tonight. Bad snow is in the early a.m. That's at 8:35. And again, 8:35. I'll head up there in a few minutes. Let me know if you leave. John replies back, sure. And then the next one's not until 12:55 a.m. on the 29th. I'm going home.
And the I'm going home is from the defendant, 12:55 a.m. Is that correct?
Yes, that is correct.
I'm going home, of course, to me, to my taste, is the best performance at Woodstock by the band 10 years after. It just absolutely amazing performance. You know, it's on YouTube. Look it up. Just so good. Alvin Lee, so good on guitar. Just ridiculous. But yeah, so 8:35 ish, heading to the meet him. 12:55 she texts him, I'm going home. Why is she texting him that she's going home? Like, well, yeah. Like, in the conspiracy theory, what sense does it make? Because if she dropped him off, why would she need to text him to say she's going home if she dropped him off and he would have waved as she drove off. If she left at 12:45, presumably she's already back at One Meadows. So is she texting to say, I'm going home, as in I'm going back to my house? Like I'm leaving One Meadows now and going to my house? Because this is 10 minutes after she left 34 Fairview at the very least. Texting, I'm going home. But then she spends the night at John's on the couch, worried sick. It doesn't make any sense. It's just setting up an alibi, frankly. To me, you're absolutely right, Jennifer. The only reason this is sent 10 minutes, at least 10 minutes after she left 34 Fairview and doesn't leave One Meadows to go to her house, it's setting up an alibi. She knows at 12:55 when this was sent that she needed an alibi. That's the only reason she sends this. It doesn't make any sense whatsoever. Like, if, let's say, John walks in the house at 34 Fairview, hypothetically, we know he didn't, but let's say he walks in the house, is she going to wait outside for 10 minutes and then text him and say, I'm going home? No, she was gone by then. This is setting up an alibi. Yeah. She waited until she stopped driving in the snow. It took her roughly 10 minutes to drive to One Meadows. This goes to murder. This goes to murder. And yeah, this is not good. This is very not good. Has she texted her dad around this point? Has she called her dad around this point, I wonder, having not watched ahead? Because I haven't. This is bad. No, but it goes to murder over manslaughter. It goes to, she knew she hit him and failed to render aid. And this is bad. This is very, very, very bad for her.
And if I could direct your attention to the top of page 53.
Yes, 12:55 again. See you later.
If only.
At 1:02, your kids are cucking alone. 1:29, 1:04 a.m. I'm back in Mansfield. The kids are home alone.
Whoa. I'm back in Mansfield. The kids are home alone? No. She never drove to Mansfield. This is complete bullshit. Literally the testimony is she spent the night at One Meadows. She never went to Mansfield. Besides which, how long does it take to drive to Mansfield in a blizzard? More than 10 minutes? Isn't it like a 30-minute drive? It's like it's more than a 9-minute drive. She's setting up a drunken alibi.
May I approach number 3?
Yes. Can I see counsel at sidebar about scheduling?
You are
21 minutes in a blizzard. Canton to Mansfield is a 21-minute drive, and she did it in 9 minutes in a blizzard. Mansfield is where Karen's house was. Her parents' house is in Dighton. So she made a 21-minute drive in 9 minutes during a blizzard. That's complete, absolute bullshit. Absolute
Can you go
bullshit.
until 4:15? I know it's been a long day, but does that work for you all? All right, thank you very much. So why don't we do that, and then I'll talk to the scheduling after.
You are unmuted.
Yeah.
I may have one more.
This has been devastating. Like,
yes.
This to me, this shows knowledge that she hit him at the time.
Trooper Garino, you were also able to get some chats as well as some phone calls between the defendant and certain individuals. Is that correct?
Yes. Oh, Daddy's
And,
phone.
yeah, Pro Tron.
Yes.
I hope this is Daddy's phone. I mean, why didn't she take the 16-month plea deal? Wow. I hope this is Daddy's phone.
I'm showing you the documents a second. Do those.
Okay.
And do you recognize those, sir?
Yes, I do.
And what do you recognize those?
The single page is Karen Reed to Laura Sullivan phone calls, or I should say, yep, calls from Laura Sullivan to Karen Reed. And the other one is Karen Reed and Laura Sullivan's chat messages.
What's contained in those documents? Is that a fair and accurate portrayal of what you were able to extract from the defendant's phone?
Yes, sir.
Approach Andrew.
Yes.
I want to introduce the next. Okay.
I mean, if I knew I didn't do it, I wouldn't take the 16-month plea deal. But it's looking like that might have been a good, call for her to take that plea deal, because those texts were damning.
No.
And don't forget, in a snowstorm, it's the same physics that apply for Allie McCabe driving 340 miles an hour back and forth in a snowstorm. It's the laws of physics don't apply in Canton, except for Trooper Paul in, not being able to use them properly because it wasn't a head-on collision.
Thank you.
May I approach her?
Yes.
From your documents, sir. Recognize that?
Yes, these are Karen Reed and Aaron O'Keefe phone call.
And what is contained in that is that fair and accurate portrayal of what you observed conducting the extraction of the defendant's phone with regard to the communications with Aaron O'Keefe?
Yes.
May I approach again, Your Honor?
Yes.
So Karen and Aaron.
Okay. There's no objection, Mr. Yannetti, right?
She's like, get the fuck on with it, Yannetti.
No objection. I'm very sorry, Madam Clerk. Your Honor, may I approach the witness?
Yes.
I'm showing you what's previously been marked as Exhibits 51 and 52. I think you recognize those.
Yes, these are phone calls between Karen Reed and Katie Camerano. And 52 is chats between Karen Reed and Katie Camerano.
Approach this to retrieve, Your Honor.
Yes.
Katie Camerano is the mother of the friend, and her husband was at CF McCarthy's with John, the one that gave John a ride, right?
What's contained in those exhibits 51 and 52, is that a fair and accurate portrayal of what you observed during the extraction of the material from the defendant's phone? Yes.
Jeez. Here I thought trying to drive to Park City in the snowstorm to watch Gwyneth Paltrow testify was, you know, extreme. Of course, driving through Parley's Canyon in a snowstorm is extreme, but yeah. Except, was she a killer or just attempted?
May I approach again, Your Honor?
Yes.
So showing you what's marked as exhibits 94 and then 95.
Yes. I'm sorry. They are chats between Karen Reed and Jen McCabe, text messages, and 95 is Karen Reed and Jen McCabe phone calls. And again, what's contained in those records before you, is that a fair and accurate portrayal of what you observed in the defendant's phone during the course of your extraction of materials from her phone? Yes.
Yes. So these are already in evidence, Mr. Lally, so that you don't need the fair and accurate depiction.
And clearly Karen was blameless. You know, John was mean. He deserved what he got, according to the crazies.
May I approach again, Your Honor?
Yes.
I mean, as I've said, this should have been like a 5 or 6 day trial. But that's not Lolly's fault. Oh, that's gross. That's gross. Ew. Ew. Exactly. Exactly. He deserved what Karen did to him. Not that Karen did it, but he totally deserved it because he was mean to her.
Juris, you know what? I'm going to send you home. Okay? So I need to see counsel at sidebar for just a minute to figure out the next few games. You are muted.
Well, I mean, that's what it should have been. Of course, you spend 2 years concocting a conspiracy theory, and, you know, the prosecution's going to look into things too, and those texts, you know, there could be enough for second-degree murder. I'm not saying the jury will find it. I'm not saying the jury will convict. But there could be enough. So, yeah. And that's it, Naven. That's what we have been preaching here since day one. You're innocent until you're proven guilty. But that only applies to Karen Reed, apparently, because, you know, Jen McCabe and Chloe the dog and Brian Higgins and Colin Albert, they're all murderers, you know, walking free, no trial needed, because, you know, our Lord and Savior Turtle Boy has told us so. Karen, innocent until proven guilty, and there's nothing that can be said that will convince me otherwise, is what Free Karen Reed has basically said.
You are unmuted. But you won't be. All right. So it's very important that you don't watch TV or listen to anything, or read about anything. So we will be here tomorrow. Wednesday is the federal holiday, so we're not in session. I know there's supposed to be some big heat wave this week. I really appreciate that everybody dresses respectfully for court. I suggest you come in comfortably. It's an old building. The air conditioners were great today. I don't know that that will hold up when really pushed.
She's saying, come in shorts. We won't turn you away.
So feel free to dress comfortably. We'll plan on seeing you on Thursday. If that changes, the court officers have your contact information. But we're planning on seeing you on Thursday. All right, so please, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read
And
anything about this case,
that's a
please
given,
disregard it.
Greta.
Let us know. See you Thursday.
That's a given.
All right,
No
so
way the judge overturns a guilty verdict if it comes.
All right, and Trooper, you can just follow up behind him, okay? Thank you.
No smile this time, apparently. Maybe it sunk into her that, like, as bad as Trooper Paul was, this was not a good day for her. Because even completely ignoring Trooper Paul's testimony, I'd still say there could be enough to convict. Because there's a lot of really good evidence that she did it. A lot of really good evidence. Trooper Paul sucked, but Ian Whiffen, great witness. This trooper has been a great witness. It's yeah. He's just, they've done a really good job, and I keep waiting for the hot mic moment. I'm assuming, well, the trooper followed the jury out, so I didn't even catch the hot mic moment. When did he?
See you tomorrow.
When did the trooper supposedly say, "Kill me"? Like, seriously, when? Ah, it's on court TV. Okay. Is it as he's walking out? But yeah. And it's funny, CJ5, you know, in my family, my sister looks identical to my dad's sister. Like, my cousins went to the same high school as us. One of them in the same year as my sister, one in the same year as me. And people would see my sister and do a double take and, do you know your aunt? Yeah, she's my aunt. But what's funny, it doesn't get commented as much. My mom's brother's daughter looks just like young pictures of my mom. My dad has a twin brother, and his son looks just like my dad. And you'll say, but Joe, they're twins. And the thing is, the chin shape is ever so slightly different. And I think he looks more like my dad than his. But I look around and I'm like, but who do I look like? And my Oma insists I look like her brother who died in the war. And yeah. So tomorrow is a holiday, not just in Massachusetts. It is a federal holiday, Juneteenth, celebrating when the last slaves finally found out that they were free following the Civil War. So yeah, tomorrow is a federal holiday, so no court, and there's a very small chance that I try to get caught up on something else, but that's a very small chance. So chances are I will see you all on Thursday, and then Friday. So, well, did they celebrate Juneteenth on Monday, or was it like Mother's Day hangover? I don't actually know. Even though I am in Utah, we do things weird. If Halloween is on a Sunday, they trick or treat on Saturday because, you know, can't do it on a Sunday. Of course, the smart kids go both days. So yeah, either way, I'm going to run and find some food because it's 10 o'clock here. So thanks for joining me. Do all the YouTubey stuff, like, share, subscribe, and I will see you on Thursday at the very least for the continued intrigue of Trooper Guarino's testimony. So have fun, be safe, have a good Juneteenth tomorrow. Bye-bye.